Everybody here? Everybody on? Good morning.
Good morning, Mr. Chairman.
Everyone is here. We'll begin. We're now on the record in case number 2020-00349, electronic application of Kentucky Utilities Company for an adjustment of its electric rates, a certificate of public convenience and necessity to deploy advanced metering infrastructure, approval of certain regulatory and accounting treatments, and establishment of a one-year surcredit. And case number 2020-00350, electric application of Louisville Gas and Electric Company for an adjustment of its electric and gas rates, a certificate of public convenience and necessity to deploy advanced metering infrastructure, approval of certain regulatory and accounting treatments, and establishment of a one-year surcredit. My name is Michael Schmidt. I'm chairman of the Public Service Commission, and I will be presiding today. Joining me via video conferencing is Vice Chairman Kent Chandler and Commissioner Dr. Talina Matthews. At this time, I would normally caution attendees to please set your cellular phones to silent mode or turn them off. Due to the current state of emergency in Kentucky, the Commission is hosting this hearing via video conferencing. Since this continues to be a learning experience for everyone, and there are a few suggestions I would offer. In addition to the normal courtesies regarding cell phones, these tips may help with clarity and avoid feedback issues for the video conference hearing. Mute your microphones and your video if you are not speaking. Attorneys, when interjecting, please state your name so the video record is clear. If you use a phone for the audio and a computer for the video, turn off the computer audio, otherwise there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer, otherwise there will be feedback. If another participant is in a nearby office, close the doors between the offices. Sound carries further than one thinks, which can cause feedback. Once in the GoToMeeting software platform, go to your settings. The icon looks like a gear to ensure the microphone setting is on the microphone you are using. There's a pull-down menu feature in GoToMeeting settings that will list the available microphones. Use wired headphones or wired earbuds for better sound quality. Wired is preferred because wireless devices may lose power depending upon the length of the hearing. Keep a charger nearby in case your battery runs low, and please alert the Commission if you're experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided cell phone number. The hearing today is for the purpose of taking evidence on Kentucky Utilities and Louisville Gas and Electric's request for general rate adjustments, a certificate of public convenience and necessity, and deployment of an AMI project, establishing regulatory assets and liabilities, and establishing a one-year surcredit. At this time, I would ask counsel for the respective parties to please identify themselves, the name of their client, co-counsel who may be with them, and witnesses who are expected to testify today. Before let's go ahead and do that first, and then we have a couple of other housekeeping matters to take care of. But for Louisville Gas and Electric and Kentucky Utilities, would counsel please identify himself or herself?
Yes, good morning, Your Honor. My name is Kendrick Riggs. I'm with the law firm of Stahl, Keenan, Ogden. Our offices are in Louisville and Lexington, Kentucky. I and my colleagues from the firm are appearing today on behalf of Louisville Gas, Electric, and Kentucky Utilities. Also appearing on behalf of the two applicants are Ms. Allison K. Sturgeon, Managing Senior Counsel, Regulatory and Transactions, and Sarah V. Judd, Senior Corporate Counsel, both with LG&E KU Services Company.
Thank you. And for the Attorney General?
This is Mike West, appearing for the Attorney General as well. John Horn is on here, and we expect Larry Cook to join us later. Lane Collin and Steve Barron are available to testify in this hearing when necessary.
For Department of Defense and all other federal executive agencies.
Good morning, Your Honor. Emily Medlin on behalf of the United States Department of Defense and all their federal executive agencies. I also had Houston Parrish, who is my local counsel, joining by phone.
For KIUC.
Morning, Mr. Chairman. Mike Kurtz, Kurt Bain, Jody Kyler Cohn for KIUC, 36 East 7th Street, Cincinnati, Ohio.
For Kroger.
Good morning, Your Honor. Robert Moore with Stites and Harbison and Katie Donnelly with Stites and Harbison for the Kroger Company, and our expert Justin Bieber is available when needed.
For Walmart.
Good morning, Your Honor. Carrie Grunman with the law firm of Spillman, Thomas, and Battle, here on behalf of Walmart, Inc. Walmart's witnesses, Lisa Perry and Andrew Teague, would be available, but I believe they've been excused. Thank you, Your Honor.
Thank you. Kentucky Solar Industries Association.
Good morning, Mr. Chairman. David Spinard, Randy Strobo, Strobo Barkley PLLC, 239 South 5th Street, Suite 917, Louisville, Kentucky 40202, on behalf of Kentucky Solar Industries Association, Inc. Our witnesses, Justin Barnes and Benjamin Inskeep, have presented testimony and will be available when the commission needs them. Thank you.
Thank you. Mountain Association, Metropolitan Housing Coalition, Kentuckians for the Commonwealth, and Kentucky Solar Energy Society, collectively joint intervenors.
Morning, Mr. Chairman. Commissioners, Tom Fitzgerald, Kentucky Youth Council, representing the joint intervenors. We had 3 witnesses, 2 have been excused. Carl Robigo will be available as needed to answer questions. Thank you.
Sierra Club.
Good morning, Your Honor. On behalf of Sierra Club, Matthew Miller and my co-counsel, Joe Childers, my address is 2528 California Street, Denver, Colorado, 80205. And Mr. Childers' address is Childers and Baxter, PLLC, 300 Lexington Building, 201 West Short Street, Lexington, Kentucky, 40507.
Thank you. Lexington Fayette Urban County Government.
Good morning, Mr. Chairman, Commissioners. Todd Osterloh and Jim Gardner, the law firm of Sturgill, Turner, Barker, and Maloney, appearing for both. In addition, counsel of record for Lexington Fayette Urban County Government is Susan Spickard and David Barbary, as well for Louisville Jefferson County Metro Government, Jeff Derwin and Lauren Given. Our witness, Richard Bunch, has been excused from the hearing.
Thank you. And for commission staff.
Good morning, Your Honor. For commission staff, Quan Nguyen, Tina Frederick, Tamara Reed McIntosh, and Cornelius Mance.
Okay, as I understand it, the parties have agreed to a settlement, at least in part, and signed a stipulation and recommendation to the commission, which has been filed into evidence. And that proposed settlement agreement, which must be confirmed by the commission, addresses essentially all of the issues except the net metering and cogeneration tariff issues. Is that correct, essentially?
Yes, Your Honor.
Okay.
The motion for leave to file the stipulation testimony and the stipulation, which is attached as an exhibit, was filed with the commission last Monday. Okay. And I would request the commission grant the motion for and to accept the filing.
Okay. Motion is granted. Let the testimony and the proposed stipulation and recommendation be officially filed into evidence. Now, I guess the best thing to do is to go ahead and then go through this sworn answers to questions that Mr. Raff drafted years ago in terms of settlement, since we know we have everybody here at this time, and over the course of the hearing, people may need to drop out and come back. So at this time, would the parties and their counsel please raise your right hands. Do you all solemnly swear or affirm under penalty of perjury that the answers to the following questions are true and correct to the best of your knowledge and belief?
I do.
Okay. I guess I don't know if we can unmute everybody at the same time or not, but without feedback, so I guess we'll take your word for it, given the limitations of the technology. Were you aware of, and did you have an opportunity to participate in all of the negotiations that resulted in the settlement agreement?
I did.
Okay.
Yes.
Everyone, for the record, everyone agreed that they did. Second, did you voluntarily sign the settlement agreement, and do you fully support each and every provision contained therein?
I do.
The answer that everyone gave was yes. Are there any provisions in the settlement agreement that you do not understand, object to, or take issue with?
There are none.
No.
Okay, there were none. Fourth, was any consideration of any kind offered, or were any promises made other than what is expressly set forth in the settlement agreement to induce you to negotiate and sign the settlement agreement?
No.
Collective answer was none. And finally, are you aware of any reason why the Commission should not adopt and approve the settlement agreement in its entirety?
No.
The answer was no. Now, I want to ask this question, so counsel, for any of the parties, correct me if I'm wrong, as to all of the matters that have been settled, or for which there is an agreement. As I read the agreement, all parties are advocating for the terms of the agreement. So I assume that when we start taking testimony, that there will not be cross-examination by any of the witnesses by any of the parties on issues that have been agreed to. So that if a party,
Yes,
for
Your Honor.
instance, if Mr. Riggs presents a witness and it's about the subject matter to which there's been an agreement, Mr. Nguyen will ask questions, the commissioners can ask questions, and then Mr. Riggs can follow up with a redirect if he likes, but nobody else will ask any questions or ask leading questions or questions of any type, correct?
Correct, Your Honor.
But then when we get to the net metering or cogent tariff issues, then any party, every party, I guess potentially is affected by that. So everybody will have an opportunity to cross-examine. And I'll try to go through the list. If I miss somebody or somebody's turn, don't hesitate to speak up, because sometimes I've been known to do that.
That's correct, Your Honor.
Okay. Now, I guess the other thing is, a number of the witnesses have been excused, and maybe two or three have a timing issue. Let me recite into the record the witnesses who I understand have been excused, and if I'm wrong, if I say a name in error, please let me know, or if there is someone else who's been excused or would like to be excused, let me know. For KU and LG&E, Adrian McKenzie has been excused, as I understand it. For the Attorney General and KIUC, Richard Bodino, Paul Alvarez, Glenn Watkins, and Heath Lovell. Is that correct?
That's correct.
For the Department of Defense and other all federal executive agencies, Brian Andrews, Christopher Walters, and Michael Gorman have been excused. Is that correct?
That's correct, Your Honor.
And for Walmart, Lisa Perry and Andrew Teague, correct,
Yes,
Ms.
Your Honor.
Grumman? For Lexington, Fayette, Urban County Government, and Louisville Metro, Richard Bunch has been excused.
Yes, Mr. Chairman.
For the joint intervenors, Kathy Kuhn and James Owen have been excused.
That's my
Is that
understanding.
correct? Now, I know someone, I guess counsel for Kroger, indicated Mr. Bieber would be here, but I had a note that he had been excused, but I'm not sure. Has Mr. Bieber been excused?
Yes, yeah, sure.
Mr. Bieber has been excused. I'm sure he'll be glad to hear that. So is there any other?
Thank you, Mr. Chairman.
Okay, you're welcome. Is there any other potential witness or listed witness who counsel for any of the parties believes should be excused or would like to be excused? Okay. Not hearing that there are none, there apparently are 3 witnesses who have time issues. Lane Collin and Steve Barron will not be able to testify toward the end of this week. That shouldn't be a problem because we're going to do our best to conclude this hearing at the latest sometime on Wednesday. Mr. Gregory Meeman can't testify today, but presumably will be available tomorrow or Wednesday. Right?
Yes, sir, he will.
So don't let the time go by. If it comes up that there's a problem with a witness and someone needs to break in and put on a witness out of turn, obviously we will permit that to be done. What we were thinking is that the hearing would probably go no longer than 3 days, and that we would take testimony until 5 o'clock today, and then think about by the end of the day before we recess, we'll know about and can go longer tomorrow if necessary, and Wednesday in order to finish up. But we need to be finished by sometime on Wednesday or Wednesday evening at the latest. So we'll keep that in mind moving forward. I understand. I guess there's an outstanding motion for confidentiality. Is that the only motion now that remains, or motions that remain now that we've taken care of the motion to file the stipulation testimony and the evidence in support of the settlement?
Yes, Your Honor. There are several petitions for confidential protection, and they are all unopposed.
Okay. Well,
Chairman,
I know as you know from your many years of experience, we have a problem with being current on confidentiality motions. So if we get close to getting into a matter that you consider within the ambit of a confidentiality motion, please let us know, and we'll go into confidential session so as to protect your position.
Mr. Chairman.
Thank you, Your Honor.
Now-
Chairman, this Tom Fitzgerald for the joint interveners. I believe we have a motion still pending to revise Mr. Robigo's testimony, his pre-trial testimony. It's unopposed, but I think it's still pending.
Okay, is that correct, Mr.
Mr.
Warren?
Fitzgerald's
Is
correct.
there any objection?
No.
Okay, that motion will be sustained, and we'll take care of that by subsequent order, Mr. Fitzgerald.
Thank you, Mr. Chairman.
Okay, thank you. Okay, I understand that the public notice has been given and filed into the record. Does everyone agree that that's correct?
Yes, Your Honor, and it was published without issue.
All right, we have our public comment section, and we've gotten to the point here where we required people to sign up at least 30 minutes in advance of the hearing if they wanted to provide a public comment. We had 3 prior sessions with a fairly extensive public comment on all matters that are subject to this case, and some apparently, as far as I could tell, weren't. But in any event, Mr. Nguyen, do we have anybody on the line at this time who would like to provide a public comment?
I believe we have one person, Mr. Chairman. It's Kathy Hinko.
Okay. All right, Miss Hinkle, can you hear me?
Yes, can you hear me?
Yes. You may please state your name, address, and then you can proceed to make your statement, but please limit your statement to 5 minutes.
Thank you. I am Kathy Hinko, 1941 Payne Street, number 1, Louisville, Kentucky, 40206. I am a Louisville gas and electric consumer, and I emphasize Louisville, and I am a shareholder in PPL. I've already sent data through written comments on case 2020-00350, and today I focus on 2 issues in Louisville. Net metering charges. Well, the whole world, including Louisville elected government, encourages solar use to reduce greenhouse gases, its own use, and programs for individual solar installation. The proposed change discourages this. Homeland security and resilience militates us to encourage individual home solar energy production, and even we should encourage energy cells to save the energy rather than financially punish the patriots who bring energy redundance, which makes us safer now and is environmentally responsible. Its financial impact on low-income households is minuscule compared to what LG&E asks for. As for smart meters, that's a con job. You're asked to approve the expenditures that me and ratepayers will have to pay in the future without telling us the cost in any kind of transparent way. And then you pretend it does not affect rates as it does not affect current rates. This betrays the transparency of rate setting and will cost ratepayers hundreds of millions of dollars. The 5 lowest income zip codes in Louisville are dominantly Black and already use less electricity than the 5 highest income zip codes, which are dominantly white. Proven through homeschool instruction and quarantine, low-income neighborhoods have the least infrastructure or wealth to use or benefit from smart meters, and renters are least able to create savings. 40% of Louisville rents and 66% of Black or Latino households rent. Is the plan to gouge low-income Black neighborhoods to subsidize toys for rich white people? And let me remind you, 42% of Kentucky's Black population lives in Louisville, and race matters in Louisville. With smart meters, LG&E will know to the second what we are doing in our homes, and law enforcement will have access to this new real-time information. And that is an issue about race and civil liberties for all of us. Do not approve smart meters until cost equity, usage equity, and civil rights are guaranteed. And I just want to say, if LG&E needs new technology, how about programming that gives us data by census tracts and joining the 21st century? Thank you.
Okay. Thank you, Ms. Hinkle. Was Ms. Hinkle the only person who signed up to speak?
Yes, Your Honor.
Okay. We will now close the public comment section of the meeting. Mr. Riggs, would you like to call your first witness at this time?
Yes, please, Your Honor. I would call Mr. Kent Blake.
Okay, Mr. See, Mr. Blake, could you turn on your camera and your speaker? Okay. Mr. Blake, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Riggs, may I ask?
Thank you, Your Honor. Before I ask, Your Honor, I want to represent to the Commission that Mr. Blake and I are in the same room, a conference room at Louisville Gas and Electric Company. With us is Mr. and Mr. Lovecamp. Mr. Lovecamp is able to provide access to the record in both cases to Mr. Blake and to all of our witnesses, no different than if we were in the hearing room and seated next to the witness stand under that type of assistance. But it will only be access to the record to our witnesses as requested by the witnesses or as necessary by the examination.
Okay, thank you.
Mr. Blake, did you cause to be prepared to file with the commission direct testimony of 31 pages and 2 exhibits?
I did.
And Mr. Blake, did you also cause to be prepared and file with the commission rebuttal testimony of 30 pages and 1 exhibit?
I did.
Finally, Mr. Blake, did you cause to be prepared and file with the commission stipulation testimony consisting of 23 pages, 9 exhibits, one of which includes the stipulation and recommendation?
I did.
And Mr. Blake, did you also provide data responses in this case?
I did.
Do you adopt and affirm your written testimony and data responses this morning as your testimony?
I do.
Thank you, Your Honor. Mr. Blake is now available for any questions.
Mr. Nguyen, questions?
Yes, just a couple questions, Your Honor. Thank you. Good morning, Mr. Blake. Can you hear me okay?
I can. Good morning, Mr. Nguyen.
Okay, good. I just want to point you to the stipulation, and in regards to the 4-year stay-out provision, there's a, I guess, an exception to that 4-year stay-out provision. Is that correct?
That is correct.
Okay. And you state, and I'll quote, on page 5 of your stipulation testimony, the stay-out commitment does not preclude the companies from, 1, seeking to defer recovery of certain kinds of costs, 2, petitioning for emergency rate relief, 3, continuing to have their cost recovery surcharge mechanisms and riders operate as usual, and 4, seeking rate relief due to statutory or regulatory changes that affect the company's recovery cost. Just want to ask you a little bit more detail about the first item that you listed in that exception regarding seeking to defer recovery of certain kinds of costs. Can you provide a little bit more detail about that and, you know, the types of situation that would allow the companies to come in despite the stay-out provision that's been agreed to and put forth in the stipulation?
Sure. Just to clarify, Mr. Nguyen, if I look back at the stipulation, you're referring specifically to section 1.2A. Is that correct?
That's correct.
Okay. That language is meant to be consistent with past commission orders on the criteria used to establish regulatory assets and regulatory liabilities. So that would be, where we've used that in the past would be something, for example, like, you know, major storms outside of the normal type storm activity in the area. So it is meant to be consistent with that, meaning that the stay out would not preclude the companies from filing a request for the establishment of a regulatory asset if those criteria are met. I believe there's one slight adjustment to what has been included in commission's orders in the past. Section 3, I believe, includes the word government in addition to industry-sponsored initiatives. That was added in light of there being a change in the administration at the federal level. So not knowing what initiatives may come from the new administration, we added that for emphasis. And again, this is just for the company's right to file a request to establish a regulatory asset.
Okay. And then for the fourth one, seeking rate relief due to statutory or regulatory changes that affect the company's cost recovery. What types of situation would that encompass?
We actually called out in that provision of stipulation a specific example, which would be federal tax reform. Just as we did with the Tax Cuts and Jobs Act, where there was a separate proceeding to address the impacts on rates
of that change in tax law. I believe this would cover a additional change to federal tax reform.
Okay. And then skipping now to the provisions that relate to the retired asset recovery rider, could you just provide a general description of that particular rider that's been proposed to be included in the stipulation?
Sure. As we tried to convey in testimony and in the stipulation agreement itself, part of the agreed terms were to leave the depreciation rates for the company's Mill Creek 1, Mill Creek 2, and Brown 3 generation units unchanged from currently approved rates. There was a recognition in doing so that given the company's projected retirement dates for those units, that would leave a significant remaining net book value at the time of retirement. So the retirement rider was put in place as an alternative to updating depreciation rates. So it would be a separate mechanism that rather than recovering that investment over what is now the projected remaining life of those units, we would instead continue current recoveries. And at the time of retirement of a generation unit, we would make a filing with the commission to recover the remaining cost associated with that unit, a recovery of and return on over a 10-year period. So that would include what's left on the books, as well as incremental decommissioning costs that may be incurred after retirement.
Okay. So there is contemplation that there would be a filing with the commission prior to, I guess, the rider taking effect, or the.
Yeah. I'm sorry, I didn't mean to cut you off.
Yeah, no. Just wanted to make that confirmation. So at the time of the determination of Mill Creek 1 or Mill Creek 2 or Brown Unit 3 being retired, could you explain what events would cause that decision to be made? So for instance, will it be because of the company's decision to retire one of those power plants due to economics of having to comply with a particular environmental compliance regulation or standard?
I believe that's the reasons for our projected retirement dates now are spelled out in the record of the case. Specifically, I believe it's testimony exhibit LEV2. But you're right, it is environmental requirements with respect to Mill Creek 1 and Mill Creek 2, and it is largely economics associated with Brown Unit 3.
Okay. So I guess implicit in that is that it's the company's intent to operate those units to the extent as economically as possible.
Correct, yes. All of our decisions are no different than they've been in the past. Our decision to retire individual units are driven by the economics, by the affordability for customers and the reliability of the system.
Okay. Those are all the questions I have. Thank you, Chairman.
Vice Chairman Chandler, questions?
Yeah, thank you, Chairman. Good morning, Mr. Blake.
Good morning, Vice Chair Chandler.
Just a couple of questions. One, following up on Mr. Nguyen's questions. I don't know that it's clear to me in the stipulation, so I want to make sure that we get it in the record. The asset retirement rider that you were just discussing, is filing with the Public Service Commission an accounting filing or specifically a request to recover those assets through the retirement rider?
I believe it would be, we would provide all of the documentation to support the then costs remaining to be recovered. So it would be an approval of the amounts that would go through that rider. The Commission would have every opportunity to review those to confirm that those are the remaining book values to be recovered. So I think, does that answer your question?
Well, it does and it doesn't. I guess what I'm trying to figure out is doing the math, right, and just confirming that the math is correct on an amount, right, is sort of, to me, an accounting filing. That's not necessarily the same as an approval, right? So let's take a step back. Let's just say, without the retirement rider, the companies, well, I think we can go back to Brown maybe 1 and 2, where there was at least a small, I think a couple $1 million left of net book value remaining when the companies made the retirement decisions, correct?
Yes.
Okay. And in a rate case, the companies came to the commission and sought recovery or amortization of those remaining net book values, correct?
I'm sorry, could you repeat that question?
Yeah, and in a proceeding, the companies sought recovery of that remaining net book, correct?
I hate to interrupt, Mr. Chandler, you need to speak up. The reporter is having difficulty hearing you.
Okay. Is this better?
It's not much.
I don't know how much louder I can get.
Yeah, I don't know. I'm just taking cues from the court reporter.
You hear me okay, Chairman?
Mr. Chairman, I believe it's the phone and computer setup from the companies that is causing feedback that's making it difficult to hear anyone else when they're speaking.
We could hear okay here.
I'm sorry?
We can hear okay here.
Apparently Candace can't hear.
Oh.
So is there any way, Mr. Riggs, that you'll be able to get the microphone closer to Mr. Blake? Because I think it seems to be very sensitive to any sound.
It's going to be tough. The microphone is stationary and affixed to the table.
Okay.
Yeah, I'll mute my mic and let's see if that doesn't help. Okay. Okay, can you hear me?
I think I'm still hearing you through Mr. Riggs's microphone.
Okay, we have one dial-in. But we each have separate microphones.
Okay. Okay. So we'll just try this. I'll just ask Mr. Riggs to be very careful not to, I'll ask Mr. Riggs to hold his breath, and I'll ask short questions if I can. Let's go back to Brown for a second. There was a remaining net book value on the Brown units, I think 1 and 2, they were retired, right?
Hang on just one moment. Someone was attempting to adjust my microphone. I wanted to make sure it was on. My recollection is there was a small book value remaining on Brown 1 and 2. As we've done in the past, under composite depreciation, those remaining balances were rolled into effectively the balance of steam plant.
Okay. And did you all explicitly seek commission approval for that? Or, I mean, I guess you all implicitly sought commission approval for that because you sought to recover that through rates. Is that fair?
Correct. There was I think we typically do it through a reallocation of depreciation reserves at that point.
Okay. So let's take a step back and say that in this situation, we'll just do a hypothetical because this is what I want to understand. If you have a station that you retire prematurely, and by prematurely, I just mean you make a retirement decision with a remaining net book value, right? A positive net book value. There's an undepreciated amount of plan. And you sought regulatory accounting for that to get a regulatory asset for the remaining net book value. You all would be explicitly seeking the recognition of the amount, but you'd also be arguing and have the burden to say that it should all be it should all be deferred, and then it should all subsequently be recovered, correct?
Correct.
Okay. What I want to make sure I understand is with this retirement rider, it is by moving this stipulation item, is the commission explicitly saying to the company that you get to recover whatever the remaining net book value is, and then that subsequent filing is just an accounting filing for us to check the math?
Understood. And I think that is the agreement that is part of the stipulation, because it was the only reason for the retirement rider is the agreement not to adjust depreciation rates for Mill Creek 1, Mill Creek 2, and Brown 3, such that it would happen like previous retirements have for the company, where there is a negligible remaining book value at the time of retirement. By not updating the depreciation rates for Mill Creek 1, Mill Creek 2, and Brown 3, we would project that the remaining book value at our current expected retirement date would be north of $100 million for each of those units. So the trade-off for that is to, rather than providing recovery via an increased depreciation rate in this proceeding, all parties have agreed to provide that same recovery further into the future via the retired asset recovery rider.
So
I would say approval of the tariff and approval of the stipulation is essentially approval of that remaining book value, subject to any questions of prudency of the cost incurred.
Well, that's I'm getting to the second part, because that's what I'm trying to make sure of. So let's take a step back. If you all changed, if the commission approved your depreciation changes as proposed, right? The expected change in the retirement date for Mill Creek 2, for instance, is 2028. Hypothetically, if the commission approved that change in depreciation rates, it should have a net book value of 0 in the year 2028. All things is perfect treatment and everything works out well, correct?
Yeah, I would say near 0. And again, this is a technical point, but depreciation rates are set based on plant and service as of a point in time. In this proceeding, I believe that was June 30 of 2020. So it would be designed to recover the then plant and service over the remaining life. So to the extent you had capital additions, and let's say for Mill Creek 1, that would be over another 3.5 years. To the extent you had capital expenditures for Mill Creek 1, a year after that, say on June 30 of 2021, the depreciation rates are still designed to recover those costs over 3.5 years, but you only have 2.5 years left to recover them. So that's what typically causes some of those small remaining book values at the time of a unit's retirement.
Right, and that's all I'm trying to say is near 0, right? The expected, from what was initially proposed in that application, Mill Creek 2 would be fully depreciated or near fully depreciated in 2028, right? But under the company as filed position, if the company retired the unit in 2026, for instance, there would be a remaining net book value on that, correct?
There would be.
There would be. And the companies, insofar as they wanted to seek recovery of that remaining net book value, would have to come to the commission to do so, right?
I'm not sure about that from a legal standpoint, so I'm hesitant to answer that. Again, we've made retirements of units in the past, and as long as those are not considered extraordinary retirements and abandonment of property, we would follow the traditional accounting methodology, which is you reallocate depreciation reserves and effectively spread that cost over the balance of steam plant.
Okay. So I want to go back to your second answer here.
Okay.
You all file this retirement rider, and I'm going to use your word, prudent, that you all will still be seeking recovery of those costs of the retirement rider, subject to review by the commission of the prudency of those amounts.
I think the commission always has the opportunity to challenge the prudency of costs being recovered, yes.
Well, and that's what I want to make sure that the stipulation doesn't you know, that it doesn't envision that whatever the amounts are just are the amounts, and by agreeing to this stipulation, they're agreeing to the amounts whenever in the company's sole discretion they choose to retire those assets. I'll just say that, and I just want to make sure that's not the case.
Yeah, and I will phrase my response slightly differently to try to confirm the point. In this proceeding, no one has questioned the prudency of the investments made to date in Mill Creek 1, Mill Creek 2, Brown 3, or any generation unit for that matter. So I believe that from a prudency standpoint, that would leave, for review, would leave the period between now and the filing of a request for recovery under a retired asset rider. So, for example, if we decided to spend $100 million on Mill Creek 1 prior to the end of 2024, I'm sure the commission would, in that retired asset recovery rider filing that we make for Mill Creek 1, I'm sure the commission would have a lot of questions on why we spent $100 million with only a few years left in that plant's life.
And that is the exact point. That is the exact sort of scenario that I'm asking about. That if you all spent 100 or 200 or 300 million dollars and then 3 months later decided to retire it, it's your testimony that the purpose of the stipulation is not to impact the commission's ability to review, again, using your word, the prudency of those subsequent investments for ultimate recovery.
That is correct.
Okay. The other question I have on this item is that on page, and I'll just say the page, but we're going to use round numbers for a minute because I think you'll understand. On page 21 of your direct, you noted that the change in the depreciation rates for the coal-fired generation, 48.3 million for KU and 59.2 million revenue requirement increase for LG&E. In the stipulation, the revenue reduction for keeping the Mill Creek 1, 2, and Brown 3 rates the same reduces the revenue requirement 33 million for KU and 36.5 million for LG&E. Just the first question, the difference between those is that there were other units whose depreciation rates changed, correct? That's not addressed by the stipulation.
That is part of the answer.
Okay.
Also, and I believe this was addressed in discovery, and I can't remember which data request and which party asked the question, but that was the section of my direct testimony that addressed the drivers of this rate case.
Right.
I took a simplified approach on depreciation and just included the impact of the change on depreciation expense.
Okay, and not net salary.
There are other offsetting, right, depending on your depreciation recovery, right? It has an impact on capitalization or rate base, and it has an impact on the amortization under the ARAM method for property-related excess accumulated deferred income taxes. So those are both offsetting impacts to the depreciation expense change. The first of which, the capitalization change, in my driver's discussion within direct testimony, were included in the capitalization change. The impact of the change on excess accumulated deferred income taxes was addressed in my discussion of income tax changes.
Okay. So the second part of this, though, is that the stipulation reduced the revenue requirements for KU and LG&E for keeping the depreciation rates current for Mill Creek 1, 2, and then Brown 3. KU for $33 million, LG&E for $36.5 million, right?
Yes.
Mr. Collins' adjustments for maintaining the depreciation rates for Mill Creek 1, 2, and then Brown 3 was almost $42 million for KU and $45 million for LG&E. So rereading your rebuttal and then reading the stipulation testimony, I don't know if I just didn't see it, but could you explain what the difference between what Mr. Collins proposed for maintaining those depreciation rates and then what the stipulation provides for maintaining those depreciation rates?
Sure. And I believe the reconciliation between the two is actually provided in the rebuttal testimony of Mr. Garrett. I believe it's rebuttal exhibit CMG 7. And Mr. Collin, I'm going off memory here, address the impact on depreciation expense, address the offsetting capitalization effect. What he did not address was the impact on the amortization of excess accumulated deferred income taxes. So, and that includes the private letter ruling that was issued by the IRS late last year. So that reconciliation between the two, the figures that are used here are the figures from a rebuttal exhibit CMG 7.
Okay, so a couple questions on that then, because apparently I did gloss over this.
Dr. Matthews?
Oh, no, I'm sorry. I have additional questions. Sorry, Jerry.
I'm sorry, could you repeat that? I lost the audio a little bit there on your question.
Is the private letter ruling that you referenced specific to LG&E? Was it requested by LG&E KU?
No, it was not. It was an industry-wide issue. So we discussed that with our tax experts, our outside accountants, on how to handle that.
Okay. My last question, Mr. is the rate case stay out. Your direct testimony explicitly discussed the anticipation or preference for the companies to be able to have more time between this case and their next rate case than has been the practice over the last, decade plus, right? What with the 4-year rate case stay out stipulated to? What were you all? What were you thinking before that? I mean, were you thinking 2.5 years, 3 years, 5 years? And can you just put some color around? I understand the environmental spending of the past 10 years being a significant driver of cost recovery. I understand, even some of the gas infrastructure. But what is it over the next 4 or 5 years that leads you to believe that you have an ability to not rate increases as frequently as you have in the past?
Sure, and you're right. And going back to direct testimony, I was trying to be as open and transparent as possible. That was a goal, right? To not continue to file every 2 years. I didn't have a specific time frame in mind of how long we might be able to do that. What I tried to be, in being open about it, I also tried to disclose the challenges associated with doing that, right? You have to invest only at a level while still maintaining safe and reliable service, right? You have to only invest at a level, theoretically, that would keep capitalization/rate base flat, right? So effectively equal to depreciation. You have to offset any increases in expenses
be they inflationary or otherwise, other demands, because we are showing no load growth for the foreseeable future. You have to assume that market interest rates remain at their current levels. So there are a lot of externalities that could prevent us from being able to do that. However, we wanted to try, because if you look at our projected capital expenditures, we project investing at a level of $700 million plus between the two utilities, sort of starting in 2022, compared to $1 billion to $1.5 billion over a number of those historic years that you're referring to. So we thought if we were ever going to be able to do it, now would be a time. Didn't know if we could. In negotiating the stipulation and recommendation, parties challenged the companies to commit to that via the stay-out provision, which has very limited exceptions to it. So as part of the settlement, and to reach that settlement, we agreed to commit to that for a 4-year period.
Okay. And the chairman always says, don't trust an attorney who says last question, because I did have one that was, the annual 2023 payments coming from Big Rivers. It's your testimony that you all are proposing not account for that in rates, but instead those payments be directed towards economic development. My primary question on that is, or two questions. One is, what economic development are you talking about? And two, are you all proposing that it be incremental economic development, or to pay economic development costs that the company already incurs?
I don't know that we were that specific, because those payments have not started yet, and based on our understanding of the timing of Nucor locating to the state, we expect that they won't start until 2023. We have received the upfront payment that was part of that settlement agreement, and that is included in the economic recovery CERC credit. The annual payments, we are simply proposing that those be used for economic development. Obviously, the service territory in question was an LG&E service territory, so the investment in economic development would be within the LG&E service territory, from site readiness to any number of things that are done on the economic development front. So as we discussed I believe in discovery in the case, our proposal would be to hold on to those payments once they start, utilize those in economic development, and provide, at the request of the commission, provide a full accounting for all such payments received by LG&E and how those funds were utilized. Now, to the extent that we can't find an effective way from the customer's perspective to deploy those funds, then that can certainly be reassessed at a later date, because the other option would be to provide those as a reduction in rates going forward.
So, and I'll just express my concern is that if you already have certain economic development costs that are being recovered through rates, whether it be salaries or other programs, right? And you receive this money, technically the proposal, you all could defer costs that are already incurred and that are already recovered through rates, right? You could use this money to pay for those expenses and effectively it not be incremental or over and above what customers are already paying for, right? So I'm just curious if you all would commit to ensure that if the commission does approve this for economic development and that you all do spend it, that it's costs that are already not recovered through rates.
I believe that's fair. And I believe we would lay that out, again, with that reporting of where those funds went.
You're saying that when you report, you'll indicate the base amount that's in rates, and then the actual costs incurred, and then the amounts in and above that you all spent pursuant to this this stream of money from Big Rivers?
I think we can do that, yes.
Okay. All right. Thank you, Mr. Blake. Thank you, Chairman. That's all I have.
Dr. Matthews, questions?
I'm going to just follow up on the Vice Chairman's most recent line of questioning about the economic development. Would you also commit to a discussion in each of those reporting periods of the numbers of jobs that were created as a result of that economic development spending?
We would certainly do our best to quantify that.
And it may be created or retained. I think would probably be the best way to do the accounting.
That's fair, yes.
That's all I have, sir.
I have nothing. Mr. Riggs, any redirect?
No, Your Honor, I do not.
Okay, thank you. May this witness be excused? Is there any reason why Mr. Blake should stay?
No.
Mr. Blake, you may step down and you're excused. Thank you.
Thank you, Mr. Chairman.
Mr. Riggs, you may call your next witness.
Thank you, Your Honor. Call Mr. Paul Thompson.
Okay. Mr. Thompson, would you?
He's on his way to the witness
okay.
chair, Your Honor.
Mr. Thompson, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Riggs?
Thank you, Your Honor. Would you please state your full name
Paul William Thompson,
and your title, sir?
President and CEO, LG&E and KU Energy, LLC.
Your business address, Mr. Thompson, please.
It is 220 West Main Street, Louisville, Kentucky, 40202.
Mr. Thompson, did you cause to be prepared and filed in these cases direct testimony consisting of 23 pages and one exhibit?
I did.
In subject to the errata filed on December 9th, 2020 in the records to your testimony, if I were to ask you the questions contained in your testimony today, would your answers be the same?
They would.
Thank you. Mr. Thompson's now available for any questions, Your Honor.
Okay. Mr. Nguyen?
No questions.
Cross-examination?
No questions.
No questions? Vice Chairman Chandler, questions?
Thank you, Chairman. Good morning, Mr. Thompson.
Good morning.
If I wanted to ask questions about the company's interaction and participation in OVEC, is Mr. Beller the appropriate witness?
He is currently on the board of OVEC. I was previously, but he is currently on there. I am not.
Okay. And if I wanted to ask about the an agreement you may have heard about before, the Joint Reliability Coordination Agreement that LG&E has recently signed on to, that is currently between TVA and PJM, but is adding LG&E and KU as parties. Who would be the best witness to discuss that with?
I would suspect the best place to start is with Lonnie Beller.
Okay. I appreciate Mr. Thompson. I have no questions.
Dr. Matthews, questions?
I don't have any questions. Thank you.
Okay, thank you. Any redirect, Mr. Riggs?
No, sir. Thank you.
Okay. Is there any reason why Mr. Thompson should not be excused? All right, thank you, Mr. Thompson. You may step down and you're excused.
Thank you.
All right. Your Honor, we would next call Mr. Beller. He's on his way to the witness stand. We're going to change out counsel here just for a second. Good morning, Mr. Chairman. Lindsay Ingram, Stall Keenan Ogden. You hear me okay?
Yes, Mr. Ingram, we can. Okay, are we ready to begin?
Yes.
Mr.
Yes, Your
Miller,
Honor.
please raise your right
Yes.
hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Ingram, you may ask.
Mr. Beller, would you please state your full name for the record?
Lonnie E. Beller.
And your job title and business address, please.
I'm the Chief Operating Officer for LG&E and KU. My business address is 220 West Main, Louisville, Kentucky, 40202.
Mr. Beller, did you cause to be filed both direct and rebuttal testimony in these pending rate cases?
Yes,
And were you also the sponsor or co-sponsor on multiple data responses that have been filed in the record of these two cases?
yes,
You adopt that testimony and those data responses here today?
I do.
Mr. Beller is available for questions, Your Honor.
Thank you. Mr. Nguyen, questions?
Yes, Your Honor, thank you. Good morning, Mr. Beller. Can you hear me okay?
Yes, I can. Good morning.
Great, thanks. Let me refer you to the company's responses. Well, it will be KU response to Commission staff's second request for information. It's item 30, and it's subpart D. And then for LG&E, it's item 33, subpart D, regarding the SEAM costs.
I have it here, yes.
Okay. Can you explain whether energy costs and revenues associated with SEAM would be included in KU and LG&E's off-system sales tracker?
Just so I understand the question, you're asking if energy and what was the other item?
Energy costs and revenues.
Correct. We in the SEAM construct are proposing to treat it just like any other off-system sales transaction that we've incurred in the past. And so both the cost to satisfy that transaction and the revenue that we receive from that transaction would be included in the monthly filing of the fuel adjustment clause.
Okay. And then in the responses, I guess first for KU, the SEAM-related expenses that are included in the test year is $13,340 for KU. Is that correct?
Correct.
And then for LG&E, it's $9,660. Is that correct?
Correct.
Okay.
Correct.
Are those the only SEAM-related expenses that have been included in the test year?
Yes, they are.
Okay. And do you know which account that KU and LG&E would include those test year SEAM-related expenses?
No, I do not. I know they would not be part of the monthly fuel adjustment clause filings, but they would be in some other account. But I'm not familiar with that account where they would be booked.
Do you know which witness would be familiar with that? Or do we need to request this as a post-hearing data request?
The post-hearing data request would be fine. I suspect those expenditures are in a specific area of activity and would be included in those accounts, but I don't know that any witness would have that direct knowledge off the top of their head.
Okay, so I'll request that as a post-hearing data request then. And then can we switch now to the company's response to staff's fifth request for information, item 4?
Yes, I have that up.
Okay, and this, the question and response deals with planned capacity retirements in addition. Is that correct?
Yes.
Okay. In the response, you state that the planned retirement for the Zorn CT in 2021 was the only retirement the companies had planned at the time of the May 2020 filing. Is that correct?
Correct.
Okay. Do you mean just for the 2020 to 2022 time period, or was that the only retirement plan for the 10-year period from 2020 to 2029 at that time?
It is definitely true for the 2020 to July 2020 to June 22 time period. And also, as you may be familiar, within our long-term planning studies, we do look at different ranges of lives for our assets. That was part of our latest IRP. But as we get closer to retirements, they become part of our shorter-term plan. So at that time, in our shorter-term planning, our 5-year window, Zorn 1 was the only retirement that we had as part of our plan.
Okay. But for the long-term planning, that was included as well. Is that what you're saying?
Correct. Zorn would have been retired at that point. And as further data responses show, we completed the analysis that's included in the record LEB2 later on that year, and at that point established probable retirement dates for Mill Creek 2 and Brown 3, and then the ECR case that was also finalized later that year, I believe in September of 2020, was the effective finalization of the Mill Creek 1 retirement date.
Okay. And did the companies have any planned capacity additions for the 2020 through 2029 time period at the time of the May 2020 filing?
No, we did not. At that time, we didn't have retirements through the end of the decade that would suggest needing additional capacity.
Okay. Can you refer to the fifth company's response to the staff's fifth request for information again? And this is for both, there's two questions. The response is items 1 and 6. It's regarding the company's evaluation of the SCR and ELG compliance at Mill Creek.
Yes, I have question number 1 up.
Okay. And I can ask the question without you having to refer to these two responses, but it appears that the companies evaluated the implementation of the SCR for NOx reduction separate from or in isolation of the ELG project at Mill Creek. So my question is was there a reason why the companies didn't consider these two projects as a single combined project for Mill Creek?
So just to be clear, we're talking about Mill Creek 2 and the analysis around that particular unit?
Correct.
So with respect to Mill Creek 2, we wanted to determine if the retirement date that was in place before we did the analysis was reasonable. And so as the study outlines, we looked at the upcoming environmental requirements and determined that an SCR was most likely to be needed in that 2027 to 2029 frame. So we settled in on 2028. So we did this in a stepped way to answer your question. We determined that that unit would need the SCR, and then we evaluated the economics of adding that SCR and determined that it would not be cost justified to add the SCR. And then we took the extra step of determining within the ELG front if we could justify the incremental expenditures to cover Mill Creek 2's operation through the established new retirement date of 2028. So to answer your question specifically, we evaluated in a step way, not at the same time. It would get you to the same place, and that place would be that an SCR will be required at Mill Creek 2 in the 2028 timeframe to continue operation. And at the same time, we can justify investing incrementally in the ELG projects at Mill Creek to allow Mill Creek to operate until 2028. So you end up in the same place, and perhaps could have structured the analysis differently, but you end up in the same place.
Okay. Just to jump now to same fifth request for information, but item 12 regarding the Bullitt County Gas Pipeline Project.
Okay, I have that up.
Okay, subject to check, would you agree that the project's estimated cost at the time it was approved by the commission in 2016 was around $27.6 million?
That is correct.
Okay, and the response to this data request, the projected estimated cost is now at $74.2 million without considering contingencies. Is that correct?
The $74.2 million is correct, but if I understood your question, it does contain contingency.
Oh, it does contain. Okay, I'm sorry. I thought I read it without. So the $74.2 million is with factoring in contingencies?
Yes.
Okay. Can
Mr.
you
Nguyen, can I just ask that we bring that up, or that maybe Mr. Beller looks at that response?
Yeah, I'm sorry. Go ahead, Vice Chair.
I was just, can we make sure, because I think I saw it yesterday and it said without contingency, so I want to make sure that we're on the same page.
Okay. Hang on. Let me bring up the response. Give me 1 second. Share it real quick. Are you?
Okay. So
I'm sorry. Hang on 1 second.
So I see the one that says does contain contingency. That's my fault. I read it as does not contain contingency. I guess my question for Mr. Bellar on this is, did the $27 million contain a contingency?
Subject to check, our typical budgeting process and cost estimating process would include contingency, yes.
Okay. And I guess the only reason I asked that is, for Mr. Nguyen's questions, is it an apples to apples comparison of costs?
The $27.6 million and the $74.2 million are costs that would be required to complete the project. So in that sense, they are comparable. Obviously, different information was used to create those, but if that's your question, Vice Chair, were they to accomplish the same task, and that is construct the pipeline, that is correct.
Okay, thank you. Sorry, Mr. Nguyen.
Okay, no, that's okay. Thank you for that, Vice Chairman. So yeah, just to confirm, I guess the response to staff's fifth request, item 12. If we can scroll down just a little bit more at the end of that table, just to confirm that it does say that it is with the contingency. Okay, the project estimate does contain contingency. Guess we can take that off now, Travis. Thanks. So, Mr. Beller, just can you explain what caused the increase in the cost of the project?
Sure. So if you go back, the 27.6 million estimate was based mainly on previous projects that the company had performed to construct gas pipelines, natural gas pipelines, namely the project where we provided a gas pipeline to our Cane Run 7 combined cycle combustion turbine, which was part of previous cases. The new estimate, the 74.2 million, is predominantly based on bids, two sets of bids we received both in 2019 from the marketplace. It represents costs that multiple respondents to our RFP for construction requests provided us. That's mainly in the contract labor section of the estimate that you see here in answer to the fifth commission data response to question number 12. And so we used that information to come up with this estimate, and then we included the costs that we had incurred to date, and that's how we have arrived at the 74.2 million. I will point out that it is our plan, since those bids in 19 for which this estimate is based on are no longer valid, obviously, we would rebid the project at the time we get all the necessary right-of-ways in place to be able to construct the project. Part of the reason we want to do that is obviously the bids are out of date, but also within the bids that we received in 2019, the respondents to the RFP included significant standby costs in their bids based on the anticipation that at that time that we didn't have full approval to allow the contractor to construct the project in one sequence, and there would be days in which the contractor would have to stand down. And so we would want to be able to get a bid that did not include that contingency, or not as significant of inclusion of that contingency in the bids.
Okay. And can you provide the current status of the project? Has construction began at all on the project?
I'm sorry, could you repeat that? You broke up a bit in the question.
Sure. Could you provide the current status of the project? Has construction already begun on the project?
No, we have performed right-of-way acquisition for a majority of the properties. There are some of those properties that are subject to condemnation proceedings. We would anticipate the resolution of most of those this year in terms of an initial resolution. We would anticipate appeals that could go beyond that. So costs of obtaining the real estate and right-of-way have been incurred, materials have been purchased, but no construction has begun. We would not begin construction until we have access to all of the properties.
Okay. So is that the only thing that is causing construction not to begin, is the right-of-way acquisition? Has there been any permitting, or has all permitting been achieved?
So the right-of-way acquisition at current schedule projection would be the longest lead item, but there are permits that we would have to obtain before we could begin construction. Some of those we expect, the major aspects of permitting, we would expect to be resolved by mid-year. This year, there would be other permits that we would obtain once we select a vendor to perform the construction. Those are more directly associated with the actual physical construction. So those permits we expect to be able to obtain to not unnecessarily delay construction. But you're correct, there are other things that we would have to accomplish before we would begin.
Okay. Can I direct your attention now to LG&E's response to the AG and KIUC's data requests, second data request, item 26, and subpart H of item 26?
Yes, I have that here.
Okay. Of the 10.766 million increase to inline inspection, could you provide a breakdown of inspections performed in high consequence areas, medium consequence areas, and any other areas outside of those two?
Yes, we could provide that. I couldn't do that off the top of my head. There are various inspections included in that amount. I think they are included below. We would obviously have that information, but we'd have to go back and assess it from that perspective. But we can definitely provide those data points that roll up to that $10.8 million.
Okay, and I'll request that as a post-hearing data request then. Just want to confirm, LG&E conducts inline inspections outside of covered segments or, the high consequence areas. Is that correct?
Yes, correct. So if you have a line that has and contains high consequence areas, and to orient the commission, we have around 40 miles of high consequence areas amongst our 400 miles of gas transmission pipeline. If you have a section of line that has high consequence area in, we would typically inspect that whole line from what we would call the inline inspection launcher. The non-technical term is the pig launcher, and we would insert the inline tool, and then we would retrieve it at the end of that line. So we would capture data not only on high consequence areas, but on other pipeline segments, and which is also a great safety practice for sure, but also required in Mega Rule Part 1 to comply with the new requirements that we have there.
Okay. Those are all the questions I have, Chairman.
Before we entertain any other questions, it's now 25 to 11, so let's take a break until 15 minutes until 11 o'clock, and then we'll come back with more cross-examination of Mr. Beller. Thank you. We'll be in recess until 15 minutes until 11. Okay, we're now back on the record. Mr. Ingram, I know you've been here but out of sight, I guess, from the beginning, but there's been a lot of background noise that makes it difficult to hear and difficult for the reporter to hear. And I guess our analysis, or our IT person's analysis, is that somehow it's coming from you all, that when people move papers or something, that basically it causes a lot of static on the line. And that's all I've been asked to say is, I don't know that there's anything that can be done about it, but apparently our group has identified it as coming from your end.
Chairman, just to clarify, this is Allison Sturgeon. Just wanted to let you know we have one central audio login to the hearing, and so and it's tied to the camera that's facing counsel. So anytime the witness speaks, the video will show as if counsel is speaking, but that mic is muted. So the only microphone that is live at any time, except for when counsel is cross-examining, is the witnesses.
Okay.
And so we don't think it's coming from here. I will tell you, when we're watching, it looks like sometimes when our witness is speaking, there is sound coming from the hearing room. And so I don't know if it's somehow echoing through the commission's hearing room, but I wanted just to point that out to you. We only have one live mic.
But here's what we have tried to do, Mr. Chairman, and will continue to do and try to do even better, is to minimize any noise in the conference room that we are in when anybody is talking, except, of course, for the speaker. So we've got mics muted and papers still and mouse click stopped and doors shut. So we'll do the very best we can. We'll try to get even better as the day moves along.
Okay, all right, thank you. All right, Vice Chairman Chandler, cross-examination.
Yeah, thank you, Chairman. Good morning, Mr. Miller.
Good morning, Vice Chair.
Please pass along my apologies to Mr. Lovekamp, and that he has to spend the next, I guess, hour and a half being as still as possible while trying to do his job. So I have a few questions that are, I have one item, a couple of items that will take a while, but I have a few one-off questions, or relatively one-off questions. So we may jump around here a little bit. If you need time or you want to pull something up for your recollection, you want to look at an exhibit, just say so and slow me down and stop me. The first thing I asked Mr. Thompson about this, about LG&E and KU being added to TVA and PJM's Joint Reliability Coordination Agreement. My understanding is that those entities are updating that Joint Reliability Coordination Agreement for issues around planning, I think primarily transmission planning, and that they're also adding LG&E and KU as parties to that agreement. Do you have any knowledge of that agreement or the edits or addition of LG&E KU to it?
Yes, we have been, as you relayed in your question, working on that. One bit of information that I'm aware of that we definitely want to include in that process is, as you know and the Commission knows, there are a large number of generator interconnect requests within the LG&E and KU footprint, as many other control areas, PJM included. And so one of the main things that we're working on there that I'm aware of is to include better coordination of those interconnect requests as it relates particularly to affected systems. And what I mean by that, if there were a generator who interconnected to the LG&E and KU system, and that somehow impacted PJM, that those procedures would be better aligned as we move forward. But as you also relate in your question, there are general planning coordinations that we hope to improve and over time by entering into this agreement. But I'm not aware that we've actually executed that yet. It's still part of the process. And then the last point I would make, of course, TVA's involvement is they are our established reliability coordinator for our region. So most definitely they would be involved in that process.
Will this culminate in a company's filing the agreement under a 205 or 205 filing, or will it be a PJM filing?
I am not aware that it would require a FERC filing, but we could definitely research that and reply with post-hearing data response, whether it would require FERC filing or be included in some other update that we would provide.
Okay, and I'll ask Mr. Nguyen to go to that, because I would like to know, because PJM has been talking about this and given monthly updates on it for about 3 years now, indicating that it will be filed in the next quarter with FERC. And it's 3 years on and it's still being negotiated or edited. And there's no insight into, to the general public or even to the commission as to what changes have been made or how those implicate LG&E and KU's planning processes or EKBC, Kentucky Power's or Duke. I appreciate as much insight from the company as you all can provide. You mentioned the affected system studies and the generation interconnection queue with LG&E KU. I'd like for a minute, if I can, to walk through something. I'm going to attempt to share my screen here. Let's see how successful I am. Can you see my screen?
Yes.
And you see the PJM website?
Yes.
Great. So I'm going to go to the generation interconnection queue for PJM. And I'll go to the queue here, and I'm going to choose active requests in the generation interconnection queue in the state of Kentucky. You see that?
Yes.
Okay, and I'm just going to export that to an Excel document real quick here. All right. Let me know if you still see it. Do you see this this Excel document?
Yes.
Okay, so this is just a download of the active PJM for the state of Kentucky. Here, this column D is state, AY, provides the counties, and then provides the TO for each of these projects. Do you see that?
Yes.
Okay, so I'm just going to pick one that's representative. It stuck out to me when I looked at this last. It's because it's the biggest cell. It was the first double link cell. So I'm going to go to it, and I'm going to move over here to the system impact study for that project. Let me open that up here. And I'm going to open that system impact study online. All right. You see the document that I'm looking at, the PJM system impact study for that Q project?
Yes.
Okay. Great. So this is, do you see that at the bottom there? It's from August of 2019.
I can't see the bottom on your screen.
Hold on one second. It says Generation Interconnection Impact Study Report for Q Project AE1-247, Barron County - Summershade 161 kV, 80.7 megawatt capacity / 120 megawatt energy. See that?
Correct. That's what I can see on the screen. Yes.
Right here at the bottom, that's in August 2019.
Yeah, I now see that as you scroll down. Correct.
Okay, so I'm gonna just search for Clifty. I will zoom here before I even ask if you can see, because I guarantee. You see here, section 13 on page 12 of the system impact study discusses contribution to previously identified overloads.
I see that.
Okay. And you see that there are 3 IDs here, and they talk about bus-to-bus lines and contingency overloads, and the buses are from 7 Trimble County in the LG&E area to 06 Clifty in the OVEC area.
Yes, I see that where your cursor is, yes.
Okay, are you aware of what this transmission line is?
Yes, generally, it's an interconnection we have with OVEC from our Trimble County station.
Okay, and it notes that the previous overloads here are anywhere from previously 141.56% overload to 155.64% overload. You see that?
Yes.
Okay, and then if I go down, let me find the next reference here, go bear with me. Here we go. System reinforcements, it refers to the same line, the Trimble Clifty 345 kV. That was the line we were just talking about, correct?
Correct.
Okay, and it says in the system reinforcement section, it says upgrade description. No OVEC end upgrade required. The line is owned by LG&E. A LG&E affected system study will be required for AE1-246. The AE1-246 customer will need to sign on to an LG&E affected system study agreement. LG&E will determine if there are LG&E system impacts, including on the Trimble Clifty LG&E OVEC tie line. Final LG&E impacts and necessary LG&E system upgrades will be determined once the LG&E affected system study is complete by LG&E. See that?
Yes.
Did I read it accurately?
Yes.
Okay. So that affected system study that it references, those are the studies that we were just talking about that hopefully will be addressed with these updates to the Joint Reliability Coordination Agreement. Is that right?
Correct.
Okay. So if, and I'm asking this out of ignorance, if the this project, right? If in previous project there's 140% overload of that Trimble Clifty Creek 345 kV line, right? And I think from your testimony, someone else, you provided the 10-year, a 10-year transmission capital plans, or 5-year transmissional capital plans that didn't include anything related to this project. Is this an issue from the company's perspective as it relates to its retail customers?
So maybe I can speak to it more generally versus this particular instance. Clearly, we would perform studies to determine if PJM were to allow a particular generator to interconnect, if that would have any impact on our system. The specific example you brought up is a case in point along that lines. And so we would then determine whether or not, I think as you were alluding to, other projects that we have on the horizon would address those issues, or would they remain, and if the need to correct that issue on our system be solely driven by that generator interconnect. And from that point, we would have the option of, through a FERC filing, seeking recovery of those costs from that generator, in this case, that wants to interconnect to PJM. So it indeed could have implications on our system and implications on investments that we have to make in our transmission system if we are impacted by generators that are allowed to interconnect to other systems around us, hence the term affected systems.
So, but specific to this line, this is a big line, right? Is this your all's tie to OVEC?
Yes.
Okay, so this is your all's primary tie to OVEC, that you all pay a demand rate to continue to participate in the OVEC agreement, which we'll get to in a minute. and that you all have the ability to purchase effectively economy energy from, right?
Correct.
Okay, so what I'm trying to understand is, I think I understand, if you all put in an affected system study, let's just make up for, they all use numbers, right? So Kentucky Solar 17 shows up, and they are in the PJM queue, and PJM shows that they're going to, contribute to overloads on the Trimble Cliff line, and they require that entity, PJM requires that entity to get an affected system study from LG&E and KU, right, or LG&E. Are you all identifying that Trimble Clifty Creek as a necessary upgrade for new interconnecting generators? Are you aware of any where you identified as a necessary upgrade?
I'm not aware of all the interconnected studies that we've done of that nature. And as you would be aware, there are many studies that are done and fewer interconnections that are actually made or projects that actually make it to completion. And so maybe the best example would be if we did have a project that would go to conclusion in that case, and we were required to make an upgrade solely associated with that affected system. The way our tariffs read now, we would have to make a filing at FERC to suggest that that customer pay their share or pay for those upgrades that were solely necessary to allow them to interconnect.
Yeah, I appreciate that. And that's what I'm trying to find out. So I understand those, at least as they're referred to in RTOs and ISOs, as network upgrades. And they usually, sometimes that the interconnecting generator can just pay the upfront cost of it, right? Or, the utility or the transmission owner can build it and then charge it exclusively to that customer, right? I understand that there are different ways to do that. I'm curious about this specific line. I can appreciate that if those interconnecting generators are driving a cost, that you all have the ability to, if they choose to do so, upgrade that facility and charge those interconnecting generators, whether it's on a pro rata basis, if there's 5 of them and they all contribute, they pay a portion, or if it's just one. My question is, do you all have a concern with the ability, forget additional competitive generators, do you all have a concern that this line is still appropriate and usable and not overloaded to serve LG&E and KU's native retail needs?
No, we do not have a concern. We perform annual transmission studies, and part of those annual transmission studies are to determine if there are any projects necessary on our system to allow us to provide service to our retail customers and any other obligations that we have, as you would be aware, any other firm transmission requests that we've granted. And so if there are no projects in the current expansion plan associated with that line would have been found to be adequate as it exists today to provide service to the obligations, let's just say it that way, we have on our transmission system.
And are those like generation deliverability studies? Is that what you're specifically referring to when you talk about the studies that you contemplate and perform?
Well, generation deliverability is part of that, but it's really the broader, the industry term is load flow studies, to examine where the power is going to flow based on different time periods and different load forecasts, and then different outage patterns. We design to a single outage contingency approach, and so we look at all those types of analyses to determine the adequacy of our system, and if our system is found to be inadequate, propose projects to correct those inadequacies.
So those are things like voltage violations and thermal violations is what you're referring to?
Correct.
I'm going to ask a question, and if you'd like to go on to the confidential session, and if we can, I hope not to get details. Are you aware generally of Trimble 2's outage rate?
Yes.
Can you discuss why Trimble 2's outage rate is the amount that it is?
In broad terms, yes.
And like I said, the actual rate was provided under a petition for confidentiality. So if you feel the need to answer on a confidential session, that's fine. But if you feel like you can respond in the public session, just let us know.
Okay.
So it's up to you. Would you prefer to answer this question on the confidential or public record?
Well, if we want to try to stay in public session, you can ask your question, and then maybe we'll see where that takes us.
Yeah, my question is just why is it at the rate that it currently is?
Okay, that is your question. Okay, I understand now. So without commenting to the particular number, which I don't recall off the top of my head, Trimble 2 is our newest coal-fired unit. As with all units, we have detailed asset management plans to try to create the highest level of availability that can exist for that particular asset. Trimble 2 is a supercritical unit, a bit more complicated to operate. The metallurgy within the boiler is more sophisticated than other units that we have. We have had some tube leaks in that boiler that have had to been corrected over time. So depending on the period in which you're asking, you could have seen outage time, equivalent outage rate time associated with those forced outages when we have boiler leaks. We have entered into our first overhaul of that unit within the last 2 to 3 years. So if you're looking at an equivalent availability factor, not a forced outage rate, those availabilities could have been impacted because we have gone into that first overhaul cycle for that unit and completed that overhaul cycle. So without trying to correlate a particular data point, those are some things I would offer that would have impacted the availability in terms of equivalent availability factor and availability in terms of equivalent forced outage rate.
So, and I think it's the E4D that I specifically saw. So that's helpful. Do you have any reason to believe that the E4D, the E4 for Trimble 2 in the future will deviate significantly from the system average for steam generators, for the company generators for the forced outage rates?
You broke up a bit, but just to be clear, you were asking if we have any reason to believe that Trimble 2's equivalent forced outage rate would deviate significantly from the overall performance of the LG&E and KU generation system.
Yeah, like the system average of the E4 for the other steam generation.
So from a target perspective, we have seen very good performance on the rest of our fleet, and Trimble County included, as we included in my direct testimony. We don't have any reason to believe that Trimble 2 over time would not perform consistent with our target forced outage rates. And there will be times, though, when we have very low, as we've experienced recently, 1.5% to 2% E4 rates for the system, that Trimble 2 could be above those numbers, but we don't have any reason to believe that Trimble 2's rate would be higher than what we target for the overall system, which is around 4.5%, and what we would believe to be industry best performance for those types of units.
Okay. So I want to talk for a second about EV infrastructure. the companies are proposing, but I understand the cost is not incurred in this rate case, proposing to build 4 EV chargers, fast chargers, across its system, and 8 if they get matching dollars from a state pool from the EV mitigation fund. Is that right?
Correct.
Okay. So in addition to or complementing sort of you all effectively building and rate basing, or I don't want to upset Mr. Garrett, capitalizationing, if that's a term, rate basing EV chargers. Are you all looking at anything else in terms of EV infrastructure? And I ask it from the perspective of working with people who this is their business line to identify circuits that wouldn't require significant upgrades to accommodate EV charging, whatever it may be. Are you all doing anything else on the EV front other than building your own chargers?
We always looking for opportunities to get new load on our system. So Mr. Wolf can provide more detail, but we would work with any customer who wants to locate a charger or a for-profit charger on our system to help them determine what upgrades may or may not be needed at that particular location. And within the footprint that they're considering, provide information about what it would cost to interconnect the type of load that they're looking at on our system. We would also assist them with their rates, the rates that they'd be paying at that location, given the character of service that they're asking for. And so that's one thing that we would be willing to do, obviously very much in line with providing customer service to prospective connectors to our system. Ms. Saunders may be able to testify a bit on some of the other more direct efforts that we're taking with respect to EV infrastructure. I'm aware of an application that Louisville Metro has to expand charging, and we're participating in that application to receive some incremental funding there. So those types of activities go on, and as I said, Ms. Saunders may have more detail on specific examples for you.
Okay. And I'll just say, you all actively participate with large industrial customers, for instance, being proactive, right, in identifying, locations or areas in which may be good areas for development or additional load, and you all are proactive in those processes. So I just want to make sure, I'm going to ask if you all are being proactive, other than building your own or rate basing your own EV chargers, if you're being proactive on the EV front. Ms. Saunders is the person to speak to.
Correct.
Okay, so earlier, and I missed, and I apologize. Earlier, you were talking about the forced outage rate of steam units. Do you remember that?
Yes.
So in addition to just looking at forced outage overall, does the company, when doing system planning, look at the equivalent forced outage rate, or the probability that a forced outage will occur when the generation is demanded?
If you could repeat I didn't hear the last 2 words of that question. I'm sorry.
The equivalent forced outage rate, which is the probability of a forced outage when the generation is demanded. Does that make sense?
Okay. So to level set, if you think about the probabilistic outage of a generating unit when the company or the system requires its output. A way to think about that is there is a forced outage rate, which is the probability that that unit would be totally forced offline. The equivalent forced outage rate that we are discussing here picks up those times in addition to the times it would be forced offline is times it would be derated and unavailable to provide full capacity. So the combination of those two represents the probability of that unit being available at full load. And so we do examine that in our analysis, both from a generation planning standpoint and from a transmission standpoint. And from the transmission standpoint, it's more of a unit outage perspective that we look at. We have a base planning dispatch that we use within that transmission planning, those transmission planning studies, but we would also look at our contingency analysis would include units being offline at individual stations and how that would impact power flows on the system and ability to serve load without having thermal overloads or other equipment overloads.
Right, and that's what I want to get to is that it feels like when we talk about reserve margins, it's a bit simplistic, right? Because you can take the gross, megawatt rating, right, or the nameplate rating, and then you say, well, that's not necessarily reflective of the amount of power that's going to leave, the station, right? So then you've got to look at you've got to look at a more refined, smaller megawatt amount, and then you've got to look at the forced outage rates of generation, right? And then when you're talking about planning for the peak, then you should also discuss the probability that those forced outage rates will occur when they're demanded, right? And I guess my question is, when you all look at it from that perspective, you all determine by looking at that generation and then what you were discussing with your transmission, right? Contingencies on your transmission system. How often do you all study that? And do you all study that in a way that complements or feeds into your integrated resource planning?
The broader answer to your last question is yes. And when we evaluate reserve margin requirements, the availability of our units, the targeted availability of our units are part of that. And when I say target availability, I mean equivalent forced outage rate, both D rates, full forced outages, and maintenance outages and others all go into that calculation of reserve margin. So anytime we do a reserve margin study, which is typically coincident with the integrated resource plan filing that's done every 3 years that you're very familiar with, it can be done on other time periods if it's necessary or suggested by other changes that we would have in our system, but it's typically done during those time periods. So all that work is done at least on that integrated resource planning period. And then if there were other major changes to our system, we would look at those analyses in between those time frames. So all that is factored into our planning.
Okay. Can I ask if Mr. Lovekamp can provide you with page 40, let's call it 42 of your direct estimate?
Okay, we have it here.
Okay. Do you see I think on line 22, it starts off with LG&E has followed through?
Yes.
Okay. So I'll just read it because if you need we're talking about the same thing. So starting on line 22 on to 43. LG&E has followed through with its plans to utilize additional inline inspection tools as technology has evolved. Those tools provide a better understanding of the threats to the pipeline and its condition. The inline inspection tools that are now commonly being used by LG&E include geometry, I assume axial magnetic flux leakage, circumferential magnetic flux leakage, electromagnetic acoustic transducer, and pipe grade sensors. Leveraging a connected set of inline inspection tools enables LG to achieve a higher overall level of pipeline safety. The expanded inline inspection tools also supports compliance with the Mega Rule Part 1 relating to expanding construction documentation requirements for natural gas transmission pipelines and reconfirming MAOPs. In addition, use of an expanded set of inline inspection technologies enables LG&E to achieve a higher overall level of pipeline safety. LG&E is running inline inspections in about 85% of its dry gas transmission pipelines. You see that?
Yes.
Okay. So you used the word earlier, and I'll use it here. I just want to make sure we level set on this one. Are 85% of the company's transmission lines required to be inspected using an inline inspection tool?
So to level set again, we have requirements to inspect our pipelines, and industry norms are to use inline inspection tools to perform that inspections. And relating back to a question I answered by staff counsel, when we inspect a pipeline to comply with the previous regulations and now going forward, the regulations required by Mega Rule Part 1, we would inspect the whole of that pipeline. In the past, we were not required to have data for non-HCA areas, those high consequence areas defined by PHMSA regulation. But we felt and have felt for a long time that obtaining data on the condition of the pipeline, regardless of whether it was in an HCA, if achievable, would support the safety of our gas system. So when we have run those inline inspection tools in the past, we would capture all the data that we could on that pipeline. We were required to have it on the HCAs for assessment of pipes in those areas. So going forward, in terms of Mega Rule Part 1, we will use this expanded set of tools to inspect all of the pipeline, which is required under Mega Rule Part 1 to reconfirm the maximum allowable operating pressure of the pipelines. So I know that was a longer answer, but hopefully it was getting to the point you were asking.
Well, it's on the subject, but I don't know that I got the confirmation that I'm looking for. Not all of your pipes have to be inspected using ILI, correct?
We have to perform.
Let me withdraw that question. I feel like I'm asking it in a way. Let me ask it this way. Are there other methods that you can inspect portions of your pipes that you are currently using ILI or planning to use ILI to inspect?
There are other ways that we could inspect our pipelines, and to add some color to that, we could do what we call direct assessment, and that is we could dig up and expose the pipeline and perform either metallurgical samples or visual inspections of the pipeline. Challenges to that are obvious in terms of the number of miles of pipeline we have. We can pressure test our pipelines. We can take them out of service, fill them up with water at pressure, and test the integrity of the pipes that way. So there are other alternative ways, but we have determined, and really industry has determined, that inline inspections are in general, the most economic and most detailed way to inspect pipelines to ensure safety.
Okay, and I think you're referring to a couple of the evaluation and assessment methods mentioned in 192.937 of the federal CFRs, I think, where it's ILIs, pressure tests conducted in accordance with subpart J of that, spike hydrostatic pressure tests, evaluation and in situ direct examination by means of visual examination, guided wave ultrasonic testing, and then just direct assessments. Is that your understanding of some of the different ways to test in lieu
Correct.
of ILI? Okay.
Correct.
my next question is, I appreciate reliability and safety, right? And I guess my question is, when there are alternatives, right? How do you balance reliability and safety in terms of cost? And my question is surrounding this. The companies have made a significant or plan to make a significant number of capital investments just to be able to use the ILI tools, right? So how did the companies look specifically at the cost of complying with the legally required obligations of assessment using the various types or ways of assessment?
Okay, so maybe one example that will be helpful, when we evaluate modifications to pipelines to allow a particular tool to traverse that pipeline, and one of the things that we look at is if the impediments are, let's say, diameter. Let's say the pipeline has three diameters. Let's say it's 16-inch, 20-inch, and 24-inch. This is an actual example that we have on our system. And the tool that we have will only traverse 16 and 20-inch diameters. It won't handle the 24-inch diameter and measure properties along that line. We would evaluate, could we perform inline inspections of the sections that don't contain the 24-inch pipeline and do another assessment technique and use inline inspection for the areas in which our tool will traverse. And we look at that analysis versus the cost of modifying the pipeline, which I think was one of the parts of your question. Then we would obviously, we have requirements to repeat these inspections every 6-7 years, depending on how we schedule those reassessment intervals. And we would look at having to replicate that time over time, that breakup process that I described, where we would do multiple inspections of that pipeline. So we cast that out over time and do a revenue requirement analysis, and what gives us the lowest cost would be the technique that we would go forward with. So we clearly look at any of those expenditures as we do other expenditures. What is the least cost way to perform the required, regulatory required inspections and get reliable data? Obviously, we want the reliable data, not just the least expensive way to do it, but we look at that in any assessments that we have and how we've determined to comply with Mega Rule Point 1 and historically how we've chosen to comply with regulations in the past.
Yeah, but I think you made a clear distinction there. Are you all by default assuming that the way to comply with inspection is always ILI?
So we have, if you're speaking specifically about Mega Rule Point Part 1 as an example regulatory requirement, we have assessed that with some limited pipeline replacements that we've done, that inline inspection along with engineering critical assessment associated with that, that would be the best approach, the least cost approach to complying with the requirements of Mega Rule Point 1. So we have made that determination. We have invested in the development of a tool, or a set of tools that traverse multiple diameters that we have on our system, and that is the plan that we have going forward, is to use inline inspection as our predominant compliance method for Mega Rule Point 1.
Are you saying that you review the other processes allowed under 192-937 to comply with Mega Rule 1 in lieu of an ILI?
Yes, we looked at the expense of pressure testing and all that goes along with that. We can talk about that very complicated process to be able to perform that type of activity. We've looked at direct assessment and given the lengths of lines and the other options too that are enumerated in Mega Rule Part 1, and have determined that will be the lowest cost compliance approach to those requirements in the rule.
And so did you all conduct a formal analysis that can be provided to the commission on that?
We have an analysis. We can provide that as a response to the commission. There are several analyses over time that we can provide as a post-hearing data response if you're interested.
Okay. And so there's the Mega Rule 1, right? And then there's also the reference in your testimony to running ILIs in 85% of its dry gas transmission pipelines. And I just want to make sure I understand, ignoring Mega Rule Part 1 for a minute, right? High consequence areas have, at least in recent history, been required to be reviewed using an ILI. Is that your understanding?
You needed to perform an assessment of HCAs in the accepted industry practice. Yes, you're exactly right, is to perform inline inspections to provide that data.
So, and let's just say that you all, let's say law that you had to do high consequence areas using ILIs, even though that's not, necessarily the case. There's the other assessments, but you all chosen to do it. Well, let's just assume it was for HCAs, right? Do you all historically been using, or are costs included in the test year in this case, for non-HCA areas running ILIs?
So back to the question that was asked by counsel, and maybe a little background is helpful. So HCA, let me make up an example to help explain. If you had a 20-mile pipeline, you may have 2 miles of HCA on that 20-mile pipeline. That HCA can be 1,000 feet here, 1,000 feet there. It's not necessarily contiguous in any nature. And so the approach that we have chosen is to put, and again, I'll use the industry term, a pig launcher at the beginning of that line, at the end of that line. And we're gathering data as that tool traverses the line, propelled by natural gas flow, and where we will pick up those non-contiguous sections of HCAs that are required to be assessed. At the same time, for a very low incremental cost, we're gathering data on the non-HCA section. So that's the approach we've taken for many years, and those costs are, yes, included in the expenses the company has incurred.
Yeah, and I appreciate that there are going to be instances where you launch and recover a pig, where you're not necessarily setting the system up to where you launch at the beginning of an HCA and you recover it at the end of the HCA, that it's going to traverse incidental MCAs or inconsequential areas, right, or lower consequence areas. What I'm asking is, are you using ILIs for lines that have no HCAs?
Subject to check, we may be. I would have to provide that information as a post-hearing data response. I'm not aware of every line that we've launched a pig, and there may be other reasons why we wanted to assess that line that may or may not have HCAs on that line.
Okay. Now I'll ask Mr. Nguyen to just take note of that. We're working through them here, Mr. Miller. Is the company going to own the multi-diameter ILI?
I'm not aware, subject to check, that we would own that. We will be able to have access to it and pay for the inline inspections performed by the vendor in which we contracted, but we I don't believe are going to own the asset.
Okay. I want to ask you about the Bullitt County pipeline for a second. So when the CPCN was approved, it was, let's say, sub $30 million with your Mr. Nguyen, right?
Correct.
Okay. And now the estimate is in excess of 70 million, right?
Correct.
Okay. And so from your experience, you've done a couple of jobs in the past before your current one. You understand generally the standard for a CPCN, right?
Yes.
Okay. And so, part of the review, and I'm sort of paraphrasing here, but part of the review for the CPCN is that you've reviewed all the reasonable alternatives. It's not necessarily the least cost, but it's sort of a most reasonable cost review CPCN process.
Yes.
Okay. So you all looked at it, and it was sub $30 million, and it was to alleviate this, this sort of. You have a place in your testimony where you talk about it, but I don't have it in front of me. You talk about alleviating some of the, the pressures and some of the demand. Particularly, a number of customers have sought gas in that area, and you looked at alleviating, I think, some of the safety concerns that you said, or some of the demand with that pipeline. Do you remember that?
Yes. So the purpose of the pipeline was really twofold. One is we currently are providing service to around 10,000 customers on a radial line or a line in which gas only flows in one direction. So if the supply were cut along that line, any customers downstream, if you will, would be out of service. So that was one of the main drivers, is how we can enhance the reliability to those customers along that pipeline. Those 10,000 customers are being served today. And then the second approach, as you alluded to, was to provide incremental service to gas customers in Bullitt County. At the time we proposed the project, we were able to do that, but as of around May of 2019, we have suspended adding new customers to service in Bullitt County. So those were the two drivers of the project.
So given, with the understanding that of that 70, I think it's $75 million that you and Mr. Nguyen talked about earlier, that a significant portion of that cost is driven by just the contract labor, right, for installing it. As the company looked at, in addressing those two goals, additional or different alternatives to address those needs than initially identified?
So, before we proposed the project originally, any pressure upgrades, regulator station settings, all the things that that we should look at were looked at for that line, and we developed the project to add additional pipeline into that area. And that project, in a general sense, has been in our long-term gas planning for a number of years. So, as the costs increased, we continue to evaluate, are there other alternatives for providing both the reliability benefits and the incremental capacity to that area. And we have found none that would be able to do both of those things in a cost-effective, reliable way. And in terms of things that we've considered that weren't specifically considered in the original CPCN, I would add to having liquefied natural gas injected into that system. So we've evaluated, just to give you some color, those types of things, but we still believe, based on the information we had, and of course, back to my prior testimony today, we will rebid that project again. The bids that we have now are no longer valid, but we continue to believe that that's the least cost alternative to providing the two attributes that we're looking for service in that area.
Okay. And have you conducted those analyses you were talking about? Are they formal, where the commission can provide copies of them to review?
Yes, we can provide what we've done on that in terms of the analysis that we've looked at.
Okay. So switch over to just quickly for SEAM expenses. In addition to, I think it's about $10,000 a company in that neighborhood in each of the two testers in this case, what are the additional expenses to participate in SEAM that the companies intend to incur that are not, variable with off-system sales?
So the SEAM group will create a platform that will facilitate the electronic bidding process, so the companies will have to pay a share of those costs. There will be ongoing costs for an auditor, for example, and there will be ongoing platform administrator cost of that nature. The companies would expect to incur as we go forward. The view and the analysis supports our view at this point is that those would be relatively small in proportion to the incremental margins, if you will, net profit that we would achieve by being able to participate in this market.
Okay. And how do you all plan to account for those costs?
So the way we have looked at it is that we would look at these as incremental transmission or incremental off-system sales revenues and off-system sales expenses that would flow through the fuel adjustment cost, and then any other expenses would just be accounted for in the normal course of business. And as we pointed out in the DRs that we reviewed, we haven't budgeted any of those at this point within the forward test year. And I know Mr. Conroy has additional responses to that to provide more color.
All right. I'll mark that one green and come back to Mr. Conroy after that. Five questions about the current meter reading contracts. Should those be asked to Ms. Saunders?
With respect to their applicability to LEB Exhibit 3, the economic justification, I would be the one to address those, but however you want to proceed with that answer.
Yeah, so let me just ask you this way. I think the contracts run for 5 years, maybe. Let's say in year 3 that that the companies no longer need the services under those contracts. Do those contracts have a fixed cost provision, or are they exclusively charged? Are the costs exclusively charged to the company on a per meter read?
There are provisions within the contract that relate to the number of reads that we are requesting from those vendors. Ms. Saunders will be able to provide you with those details. But as the number of reads go down, there are changes to the contractual relationship that we have based on how many meters we're asking them to read.
Okay, and was that accounted for in your LEB, I think 2 model that the entirety of those meter reading costs avoided are avoidable until the contracts expire?
So we can go to it if we need to, but there is a table in LEB 3 that shows the meter reading costs of the status quo and the other main scenarios we looked at. So those values would be reflective of the way our current meter reading contract in the AMI case, for example, would the cost we would incur under that contract, and likewise in the status quo contract, it would be just the contract to read all meters in our service territory under the terms of our existing contract. So if I understand your question, any contractual terms for payment would be reflected in the financial analysis that's in our existing contract, which there would be assumptions for in the status quo for sure, what subsequent contracts would cost in terms of meter reading, and that's part of our sensitivity analysis too, what those escalated costs would be.
Okay. The second question I have on your analysis is you looked at the status quo being is a 30-year analysis, right?
Correct.
It's effectively, 2 AMI. I'm sort of paraphrasing here, but 2 AMI plus AMR rollouts within that 30-year is one of the scenarios, right? The preferred scenario of the companies. Dual rollouts, 15 years apiece. Is that right?
Correct. The base analysis assumed a 15-year meter life The 30 years would capture close to 2 of those replacement cycles. And then we also looked at the end of the analysis, and the revenue requirements for all the proposals were stabilizing, if you will. And so that was one of the factors we looked at too, in addition to try to get 2 cycles of replacement in.
Right. So there's the AMI plus AMR, which is the preferred, the proposed, the AMI only, and then AMR only. Is that right?
I'm sorry, your audio broke up there and asking the question.
It's okay. I think your noise was picking up my noise. So it was AMI only, AMI plus AMR, and then AMR only. Those are the 3, change scenarios, right?
Right, and we did have the preferred one is where we would do AMR and gas only, but yeah,
Right.
it's an alteration of the AMI. Yeah.
Yeah, AMI plus AMR, right? And then they were compared to a status quo. And the status quo was, we'll just call them dumb meters for the next 30 years. Is that right?
Non-communicating meters, correct, dumb meters.
So did the company also look at, since the proposal is effectively to amortize or depreciate the current meters, right? Plus accrue weighted average cost of capital on the capital for new meters. Did the company look at, as a status quo alternative, deferring the investment until the current meters are additionally depreciated on their own?
So if I understand your question, we looked at 2 different analyses of sensitivities, and again, we can go to those, but I'll describe those. One of the sensitivities is we deferred the deployment of AMI meters, the whole process. We kept the duration and the rollout the same as we did in the AMI and the AMI plus AMR gas territory scenarios. We deferred that 2 different time periods. That analysis showed that it was favorable to deploy in the manner in which we're proposing. The second analysis we looked at replacing meters as they fail, existing meters, with AMI capable smart meters with the communication package in it, replacing those, and then implementing a AMI rollout. Those scenarios also showed that while better than the status quo, they weren't better than moving forward with AMI as we proposed in the case.
And are either of those scenarios affected by the 30-year time frame chosen for the studies? Because,
we would have maintained. Sorry, go ahead.
I was going to say, the reason I ask is because it would feel like with the status quo versus the status quo plus a deferral or plus, a later implementation, right? That you're effectively just pulling forward benefits that you're otherwise going to get.
Correct. In a sense, the advantage of our proposal is the benefits would accrue sooner. Any benefits that we've evaluated and the benefits in our proposal that we didn't put a dollar value on would be available sooner to customers. And so deferring those 2 deferral scenarios I talked about would put those benefits out into the future.
I wanted to also just be clear, when you say that the electronic meters that are currently replacing electromechanical meters, that they're functionally equivalent to an AMI or AMR meter, are they effectively just, are AMI and AMR meters just effectively an electronic meter with communicating modules added to them?
Effectively, yes. If you there's a meter cost exhibit in the analysis to add some more color to that. If I recall, an AMI communicating meter installed in a standalone fashion, not as part of a programmatic rollout, would be twice as much to install as a non-communicating electronic meter. Roughly $70-ish versus $140-ish for the meter with the communication module in it. So effectively, The electronic meters are, as you referred to earlier, they're a sense, a version of a dumb meter, but with electronic measurement capabilities, but no communication capabilities or remote switch capabilities.
Okay. The next question, if you want me to defer this to Mr. Wolf, please tell me. One of the, we'll call it purported benefits, is this conservation voltage reduction of AMI. My understanding is that requires, certain capacitor banks, voltage regulators, different control systems to be able to, to complete. Is it the company's testimony that there will be no incremental capital necessary over a status quo to implement conservation voltage reduction?
So let me answer it in a couple of parts. The first point I would make is some of those items that you mentioned already exist on our system for other reasons today. So that is, I think, an important point to make. And then within the economic analysis, in the status quo, we assume voltage control from a distribution reliability standpoint only. And so within the status quo, there are investments, we call that volt var optimization, not conservation voltage reduction, different objective functions there. So that is the way the analysis handled the root of your question, is the companies would, in a status quo standpoint, make investments in the distribution system to better control voltage on our system. But the goals of that rollout would not be to achieve the benefits that you have seen in the analysis that you relate to in the CVR proposal. So the cost of that are all embedded in the analysis within the status quo, and then of course the investments necessary to take it to a CVR implementation structure are embedded in any of the proposals where we have AMI.
And that's what I want to make sure that I understand. The analysis effectively assumed that volt var at whatever level necessary to achieve conservation voltage reduction is already going to be made in the system regardless, right?
So no, it only assumes volt var, not the first part of your question was accurate, but it does not assume CVR except in the AMI scenarios.
No, I understand. What I'm trying to ask and confirm is that for the analysis purposes, looking at quote unquote benefit of conservation voltage reduction, VVO is the front cost. You're going to spend it with or without AMI, right? At the level that you would need to implement conservation voltage reduction.
So let me say it this way, and then Mr. Wolf can fill in any of the technical details. But in the status quo case, we have indeed assumed a volt var approach to investments on our distribution system, again, to only for reliability and control purposes, not for a fuel savings purpose to control voltage. In AMI, we would make the investments that are necessary only to do CVR, and there would be investments that we wouldn't make because we're doing CVR. There would be a different set of investments. All those costs are included within the analysis.
So that's what I'll just tell you from reading the testimony and the data requests. I did not take away that there were incremental capital costs necessary to implement CVR. That the company already intended on making the VVO investments, and that the AMI just allowed them to test the voltage at the meter level so that VVO could then turn down that voltage. Is that not the understanding?
So the best way to think of it in my mind is if you were going down a status quo path, there are VVO investments that you would make that would be prudent to achieve those objectives. In AMI, we've assumed a different set of investments because we would no longer be on the VVO only path to invest in CVR. And again, Mr. Wolf can fill you in on the differences I think you're trying to get at. What would be different in terms of deployment of distribution technology if you were doing VVO only versus doing CVR? And what I'm trying to communicate is in our AMI scenarios, we assume the knowledge that we're going down a CVR path. So we wouldn't make certain investments that would only be required if you were doing VVO. Hopefully that's helpful.
I'll ask Mr. Wolf, but I just want to make sure, and if Mr. Wolf can answer, we'll ask in a posting your data request, how the company, if there are any, accounted for incremental capital, capital investments necessary to ensure, right?
Vice Chairman Chandler, this is the subject of Mr. Wolf's rebuttal testimony, and I think he can speak very specifically on the differences between Volt VAR and CVR.
I will ask Mr. Wolf. Mr. Beller, the DSM and energy efficiency programs, the cost effectiveness of those programs are based on avoided costs, or at least in part on avoided costs, right?
Correct.
Okay, and the company, when you all filed your last, we'll call it 5, 6, 7 year DSM energy efficiency plan, the companies at that point had no anticipation for additional capacity for the next 10 or 15 years. Is that fair?
Subject to check. That's my recollection. Yes.
Okay. And so, would you agree that at least on the avoided capacity front, things have changed, or the companies have a different perspective on capacity retirements and additions?
Yes. Within this decade, we now expect the retirement of Mill Creek 1, Mill Creek 2, and Brown 3. The latter two retirements, as is in the record, would create reserve margins below our targeted level and a potential need to obtain more capacity.
Okay. And so, those, I understand the DSM and energy efficiency programs, the commission approved those through 2025. Do the companies have an anticipation of updating those programs given the significant change in avoided capacity costs?
Yes, as part of our normal process, we would reevaluate those programs. Obviously, if the authority subject to check is 2025, we would refile to continue programs of the existing set that remain economic and add any programs that the evaluation that we would make would suggest are economic at this point if there are any new programs.
Okay, and if anybody on the LG&E KU team are looking at doing that or considering it or would be in charge of it, is that Mr. Conroy that can ask questions about this?
That work would actually go on as part of my area, but under Ms. Saunders.
Okay, I'll ask Ms. Saunders. I'm trying to narrow it to the single one or two remaining. Chairman, I have a couple more, one or two more questions before lunch, and then I think it would make sense to take a break and then my last set of questions, Mr. Beller. But, Mr. Beller, you all recently built a new distribution and operations center in Jefferson County. Is that correct?
We built it in Simpsonville in Shepherd, yeah.
Sorry, it's Jefferson County expanded, right? Okay, so the new distribution system is in Simpsonville. You all have an office building in KU in Lexington. That's technically KU's headquarters, correct?
Correct.
And then the headquarters in Louisville, which is technically LG&E's headquarters, correct?
Correct.
So I'm just curious, with the follow-on of COVID, that's quite a bit of office space. And I'm just curious, I know you all have done a renovation or completing a renovation in Lexington. And I don't know what your situation is in Louisville with your lease or how many floors you have or how much office space. but I'm just curious if you can give us some color as to how you all are planning your office space moving forward in light of a sort of a change in culture worldwide of working remotely in office space.
Okay, so as you state, we're in an operating mode today where we continue to follow guidance on office occupancy. We continue to follow guidance on if employees can work remotely, they should. And so we have that posture today and have been in that steady state posture for quite some time. So to answer your question, we are currently evaluating how we bring our employees back. We've communicated to our employees that we are, and we will give them a 30-day notice before we start to bring those employees that are working from home predominantly back into the office. And so our plans are, as we complete that rollout of that process, that's when we would look at where we would stabilize in the number, in terms of the number of employees in our current office footprint. We would stabilize at some point in the future. A lot of factors, as you would expect, go into that. And then we would evaluate our office space requirements in that context, and in the context of where we have employees, where we want to move employees, and future space planning. We always have a space planning process that ties in with our workforce planning process to make sure that we have adequate facilities for our employees. And so now, to the point I think you're asking about, we would factor in, for lack of a better term, our return to work strategy and stabilization of that environment into that planning process.
I've muted myself. Do you have an anticipation of when that process would occur?
We have told our employees that there are a number of factors that we continue to look at. One of the biggest of which is space limitations suggested with the Kentucky Healthy at Work program, which they still set in a limited fashion today. So that's one of the factors we're looking at. We also look at the posture within our employees and in the service territories where we have employees, or service territory we have employees, what the school situation is, whether schools are full in session. Of course, that will be relieved once we get into the summer. So those are the types of things we're looking at, and we haven't made any final decisions as of yet. When enough of those, if you will, impediments fall by the wayside, so we can begin to bring that set of employees back into our office environment. But as you would imagine, there's a large number of our employees that have continued, and by necessity, with some alterations to their work process. Obviously, we're continuing to provide service. They've had to come in to a facility to do that.
And maybe this will be a question for Mr. Mummon, but do you anticipate, from your perspective right now, that could possibly lead to savings for the companies?
We don't necessarily have a view on that at this point. We don't know where that's going to stabilize. We own most of our properties. As you may know, we lease the LG&E headquarters building. So in terms of nearer term immediate savings, it would only have to be where we have the flexibility to achieve any savings in that regard. But we'll definitely factor it into our long-term planning and try to achieve, as we always do, as I said, part of our planning process, the right facilities for the right employees that we have working for the company.
And the right cost to customers?
Yeah, correct.
Chairman, that's in terms of this line of questioning, all I had. I will have a little bit for Mr. Beller after lunch, but this may be the best.
All right, at this time, it's now 5 after 12, so let's go into lunch recess until 10 minutes after 1 o'clock. Thank you. Okay, we're now back on the record. Mr. Ingram, are you with us? Mr. Ingram? I guess we're waiting on council for Kentucky Utilities and Louisville Gas and Electric. I don't know if we have a way of reaching out to reaching out to council or not.
Mr. Chairman,
Yes.
this is Robert Moore, Counsel for Kroger. I just talked to Kendrick, and I know they're working diligently to get back connected.
Oh, okay. Well, thank you. We didn't know what the problem was, or if there was a problem.
Mr. Chairman, this is Lindsey Ingram. Can you see and hear me now?
Yes, we can.
Okay, we apologize for the delay. We're trying to do whatever we can to fix the technology issues on our side, and we think we're in an improved situation, and we'll see very soon, I suppose.
Well, out of all of the hearings we've held over the years, so we've been doing this, we have never had one go without a glitch or some kind of problem like this. So it's not a big deal. It's not to be unexpected. So if Mr. Bell is ready, I think Vice Chairman Chandler is probably ready to continue his cross-examination.
Can you hear me, Mr. Ingram?
Yes, Vice Chairman.
Perfect. Thank you. So I'll say now, good afternoon, Mr. Bell.
Good afternoon, Vice Chair.
I'd like to start this afternoon with a conversation about OVEC. You know what I mean when I say OVEC?
Yes.
Okay. And you're on the board of OVEC, is that right?
Correct.
And you represent both LG&E and KU on that board?
As a practical matter, Dan Arbaugh is on that board. Also, Mr. Arbaugh and I serve together. I'm not sure if we're assigned to a particular utility and what that would be, because, as you just stated, both are represented on that board. So I do believe we're assigned to a utility, but I couldn't tell you which one that I represent.
That's fair. Okay. So you and Mr. Arbaugh on there. I'm going to ask, and if you need me to be more detailed in what I'm trying to get to, please tell me. But, I understand from the company's previous rate cases in the IRP, companies are in the position, and if this is a mischaracterization, please correct me, but the companies sort of indicate they're in a position to where, because of their inclusion in the, I think it's an IPA, but the purchase, the agreement that the commission has approved regarding OVEC, right? Their purchases from OVEC, including energy purchases and capacity purchases, that they're effectively a taker. And whatever decisions OVEC makes, whatever investments OVEC makes, that effectively the companies are on the hook for paying that capacity charge. Is that fair?
So as you state, the companies are a counterparty to the interconnected power agreement. I think that we call it the ICPA, but let's just call it the power agreement with OVEC. And we are required to comply with the terms of those of that agreement as a counterparty to that agreement. And as you state, that agreement dictates capacity charges and then energy charges. And as you know, we dispatch those units economically in terms of what those energy charges are within our system.
Okay. So a couple of questions on that. Do you all dispatch those, or are you saying that you purchase from them when it's economic to do so?
So we would, in terms of the relationship with OVEC, we have a dispatch cost, which is the variable cost of generation. And so we would dispatch those units when it's economic to do so, along with the dispatch of the other units that we have on our system.
So, OVEC are members of PJM, right?
They are now, yes, correct.
And so are you saying that they then, self-commit, or are they economically dispatched by PJM?
It's my understanding that they sell into PJM, but I'm not sure in terms of PJM terms whether they self-commit, a term that you used, or they bid into the marketplace within PJM, which creates their obligation to dispatch. I'm not aware of their interaction. Ours is disconnected from that in a practical sense, since we're not in PJM.
Okay, and so that's why I want to make sure I understand. So when you all hit, internally, when you're looking at your available resources, your supply side resources, your demand side resources, there's effectively a dispatch stack, and at some point on that dispatch is OVEC. And once you hit the need for that, or whatever the cost of your internal generation is, then you effectively call up OVEC to purchase economy energy from them when it becomes economic to do so. Is that fair?
Right. Those units are dispatched alongside ours, and Mr. Sinclair, who's a witness, can kind of fill you in on the technical details on how we do that and how we dispatch the unit and where that unit falls in the dispatch queue, which is what you were referring to.
Okay. And I think that's as far as we need to probably get on that, to go on that sort of questioning. My question is the other interactions that you have with OVEC as a counterparty to the power agreement and as a member of the board. And if they're separate, please let me know on these questions. When it comes down to making investments or reviewing investments to determine if they're, the stay open cost or investment cost makes sense, is that a board decision or a management decision for OVEC?
So if from OVEC's perspective, again, it would be a management decision that would be under the terms of the arrangement that OVEC has submitted to the board if approvals are needed, under the bylaws, if you will, of OVEC. It would ultimately be a recommendation of management to enter into a new investment, and if that investment required approval of the board, the management of OVEC would seek that approval.
Okay. And so ELG compliance and CCR compliance, right? ELG has a compliance date. If you're going to maintain, this is a rough date, but if you're going to maintain the facility and become compliant, you have to be compliant with ELG, the new ELG rules, in something like 2024 or 2025. Is that your understanding?
Correct. In that time frame, without request for extensions, yes.
And then if you intend on not becoming compliant with ELG, then you can continue to operate out of compliance until March 31st, 2028 without an extension. Is that your understanding?
Yes.
Okay. And so for the decisions on ELG, I think you indicated in the record that your understanding is that OVEC has decided to get in compliance with the final ELG rule. Is that accurate?
Yes.
And is that a decision that was brought to the board? Is that a decision that you participated in as a board member?
Yes, the OVEC management presented to the board over time, obviously not in just one forum. Initially, it was just preliminary estimates and preliminary analysis that they had done. And then ultimately, they submitted us information on the final cost estimates and a request to approve their final decision to move forward with ELG compliance.
And so let me ask this: did you review those proposals and those plans?
Yes.
And if those were company assets and that plan had been presented to you by the people that directly report to you, would you have approved those for company assets the same as you did for OVEC assets?
Well, we would have looked at it differently because we're not looking at it from the same lens that OVEC is looking at. And so we haven't done that different analysis. OVEC did not perform the same type of analysis we would if they were KU and LG&E assets that would be used to serve load. They looked at it from their obligations under the power sales agreement. So I really can't answer that question because we haven't performed the analysis from the perspective of LG&E and native load, LG&E and KU native load service.
So well, can I ask, is there a cost of compliance that would make it, in your understanding of the agreements, that it would ever make it the situation that OVEC would choose not to become compliant and rather retire if they have those supply obligations under the power agreement?
I don't know that I could answer that question. That would be an OVEC management decision that they would have to take. Obviously, they have, as I understand it, obligations to provide energy under that power agreement. And so that's a difficult question for me to answer, not being OVEC management and knowing what that trigger cost would be.
Well, and I'll just say it's a difficult situation, I think, for me thinking about it, because you all are representing effectively the companies and the company's customers on that board. And you all are getting cost recovery for those capacity charges under that agreement, right?
Well, I would slightly kind of add some more color to your question. When we are, as board members of OVEC, we're representing OVEC. Back to when you started this line of questioning, you said separate the power agreement from the participation on the OVEC board. And this is a question that draws that distinction into play. And so as OVEC board members, we have fiduciary responsibilities to fulfill those obligations as OVEC board members, and they are different than the obligations that we have as participants in the power sales agreement as LG&E and KU.
Yeah, and that is actually the distinction that I wanted to get to, and we got there quicker than I was planning. So, how are you balancing those interests, because if hypothetically, OVEC management feels that all costs should be on the table, and that whatever costs it takes to fulfill those, obligations have to be made, while simultaneously you're the COO of the two companies that are on the hook for, a certain percentage of those costs. How are you balancing those, knowing that ultimately the costs that are passed through are going to be reflected on your customers' bills?
Okay, so first I would point out that we're minority share owners and represent, a little over 8% of the voting rights, if you will, of OVEC. So that as a baseline. And so as we're talking, those are distinct roles. And so what we attempt to do to balance that as board members is ask questions of OVEC as to the thoroughness of their evaluation and their analysis, the quality of the cost estimates, the type of things that we do internally with respect to how a project is developed, its chance of success, and so on and so forth, and will it satisfy its intended purpose. So we do all of that, and I don't have our voting record memorized, but when we get fully satisfactory answers to all those questions, and we're serving in the OVEC role, we would tend to vote for those proposals, approval of management's plans in that regard. And there have been instances where we didn't get all the information that we had requested, and then we would abstain in those cases. I can't recall, and we could obviously search our voting record over the number of years because I've only been on the board a certain amount of time. There may be other instances where we vote no on those projects, but again, being a minority owner, we would not be able to control the outcome on our vote solely.
Yeah, and that is exactly the other, sort of line that I was hoping to get to, is that, a significant, let's just say a significant number of the shareholders in OVEC are Ohio companies, right?
Correct.
And do you understand that at least a few of those Ohio companies now have an opportunity to pass through some of those OVEC costs as like a non-bypassable charge on customers' bills?
Yeah.
Okay. And that's it's been a significant item of interest in the news, right? That's the only reason I know about it. But I guess my question would be, I mean, these OVEC units are fairly old, right? And do you know when the power agreement expires?
Subject to check 2040.
Okay. And do you have any anticipation that there's any concern or acknowledgement from any of the larger shareholders in OVEC around whether or not it makes sense, dollar and cents, monetary sense, to continue to be compliant with the agreement based off the cost it could represent to customers?
So there have been questions, just like questions that we have asked about the investment in ELG, the example we've been discussing here, and then previously other investments or other expenses that the companies of OVEC, the OVEC Corporation have decided to enter into. There have been questions along those lines. I'm not aware of any conversations about definitive end-of-life concerns by other members and discussions around that. There's always been a focus on making sure those units are efficient. We have those conversations at almost every board meeting. We get reports on their availability, their heat rate, process improvements that they've gone through. So there is a recognition of cost consciousness amongst the board and a very focused recognition of cost consciousness on the part of the management of OVEC. But I'm not aware of any specific retirement dates that people have planned for and, made decisions off of and targeted.
Okay. So, speaking of retirements, I'd like to talk to you for a minute about your direct testimony exhibit, I think it's, which is the retirement update. Is that accurate or is that 3?
It's 2.
Okay. And specifically, I would first like to have, well, I can pick out the single questions so I'll get to my further line. So one of the, I didn't see this in anything that the company provided, but I did see that Mr. Collin in his direct testimony provided a sort of a before and after snapshot of what the companies were proposing with regards to depreciation for those changed units, the ones that had retirement dates that changed in your analysis, LEV2. And one of them that stuck out to me was that Brown 3 had a depreciated or a net book value of almost $750 million. Does that sound about right?
Say that last part again. The value, I didn't.
$750 million.
If we could provide that value, I'm not sure if that's the accurate value, but it's likely in that range.
Well, it was 741 is what Mr. Collins' direct testimony on page 17 had. And the proposal, as he noted, would effectively or almost double the depreciation expense for Brown 3 from a $40 million number to a $90 million number in annual depreciation expense. Does that sound accurate?
Yeah, subject to check. It would obviously increase it significantly because the prior retirement date for Brown 3 was 2035, and at the time we were asking for depreciation rates that would suggest almost full depreciation by 2028.
So looking at that remaining net book value of Brown 3, comparing it to the Mill Creek units, for instance, 1, 2, 3, and 4, it's significantly higher than the Mill Creek units. Now, I can understand, for instance, why it's higher than Mill Creek 1 and 2 in that neither one of them have SCR technology, right?
Correct.
Okay. And I also understand as a general matter, Brown 3 has a lot of environmental compliance projects done to it, right? It has scrubbers, it has all these different things, right?
Right. Brown 3 has an FGD, it has a baghouse, it has an FCR.
Is that why the net book value of Brown 3 is so high?
The other factor is it's the last remaining coal unit at the site. As you recall, there was Brown Unit 1 and 2 coal-fired units. Now, I think you're also aware there are combustion turbines on that site, but if you look at the coal investments at that site, Brown 3 is the last remaining unit. If you looked at Mill Creek 4, you looked at Gent 4, you would see a similar phenomenon. A lot of the longer-lived common plant are assigned to those last units, and so that is the other factor. The factors we discussed prior were also a component of that, but all common equipment associated with operating Brown 3, given it's the only unit there, are tied to that unit.
Okay. So I was talking to Mr. Blake earlier about the remaining net book value on Brown 1 and 2 that were recently retired. They had fairly low remaining net book values. And that's because you said the common plant it takes to run the entire Brown station is effectively allocated, and that may or may not be the right word, but they're effectively allocated to the depreciation of Brown 3. Is that a fair characterization of what you're saying?
Correct.
Okay. So, just get everything here. I'm going to apologize ahead of time to Mr. Lovecamp. We'll be jumping around quite a bit. knowledge, I believe, in your response to LG&E's response to DoD FEA 2-22, that quote, the commission does not approve retirement dates for generation facilities. Does that sound right?
Wait, now, Mr. Lefkamp.
That's okay.
What's the number again, please?
Yeah, that's fine. LG&E response to DoD FEA 2-24. Like I said, I apologized ahead of time for a reason.
Correct, yes. The answer to that response acknowledges that we don't seek approval dates from the commission when we retire units. We don't seek approval for the dates in which we retire units.
And that goes back to the conversation I was having with Mr. Blake earlier, right? Where effectively it's the companies that make the retirement decisions. It's the commission that ultimately has the rate that has the obligation and authority for what the rate making effect of those decisions might be, right?
Correct.
Okay. So on your direct testimony, and I'll wait for Mr. Lofkamp to pull that up, on page 10 of your direct testimony, please let me know.
I have it.
Okay. On line 12, you discuss, starting on line 12, page 10, you discuss the most recent ECR plan, and that LG&E evaluated the retirement of Mill Creek Unit 1 in order to determine whether an investment in ELG for all the units was justified. Do you see that?
Yes.
Okay. And then on page 11 of that same testimony, on line 9, you state, quote, the companies concluded in the ECR case that retirement of Mill Creek 1 at the end of 2024 would be least cost, and that ELG treatment capacity would not be built to accommodate all 4 Mill Creek steam generators operating simultaneously.
Correct.
Okay. And then on page 3 of LEB 2, I'll wait for you to get there.
I'm here.
As presented in LG&E's 2020 ECR plan, due to the cost of complying with ELG, MC1 will be retiring at the end of 2024.
I see that.
Okay. And then when staff asked you in the 5th round of data, item 1, to provide the date in which LG&E officially made its decision to propose as part of the instant application to shorten the remaining useful life of LG&E's coal-fired generation units for depreciation purposes. You said you conducted that between July and September of 2020, and the determinations concerning the retirement dates in the analysis were established in October of 2020 when the report was finalized and issued. And then you go on to say that Mill Creek 1's retirement date was changed from 32 to 24 as a result of the decision to install ELG for only 3 Mill Creek units. This decision was finalized in September 2020 with the issuance of the Commission's order approving LG ECR environmental compliance plan. Is that accurate?
Yes.
Okay. Did you watch the 2020-60 and 61 ECR cases, the hearing for those?
I did not watch the proceeding from beginning to end. I watched some of those, some of the proceeding, but not from beginning to end.
Okay. Do you remember my questions of Mr. Wilson and Mr. Revelet on this exact issue?
No, I do not.
Okay. So I was specifically asking the company through Mr. Wilson, and actually Mr. Ingram told me to start asking those questions of Mr. Revelet. Have the companies made a formal decision to retire any of the Mill Creek units? And Mr. Wilson told me not yet. So our order in that case went out in September. I think that hearing was in September the 10th, right? Then when asked to Mr. Revelet about the environmental compliance, I asked him a similar question, and I'm paraphrasing here, but basically he said, we will still have the flexibility to add controls for the fourth unit. And then noted me that he would be looking to see what comes out of the Air Pollution Control Board in, I think February was the month that he mentioned with regards to NOx. So if Mr. Revelet told us last fall that, A, there's no agreement with Jefferson County beyond the voluntary agreement last year, right? That likely those decisions won't be made until the February timeframe. And then he went on to say that the companies haven't even issued purchase orders yet. And I'm paraphrasing here, that we're delaying construction at Mill Creek to see the outcome of what comes from the NOx. So I'm trying to find out, because I'll just be honest with you, I asked questions for almost an hour specifically on this issue. That are you saying if the commission approves this environmental compliance plan, that is guaranteeing, or that is the death knell, or is setting in motion the retirement of Mill Creek 1? And the response that I got was no, not necessarily, we still have flexibility. But your testimony would indicate that by approving that compliance plan, the commission determined the retirement date for Mill Creek 1. Am I wrong?
I understand a bit of the question, and let me try to respond in this way. So the way we looked at it and the way we crafted this response is that through the course of the ELG ECR proceeding, we presented what we thought was the least cost compliance plan for ELG compliance. And at the end of that proceeding, we received approval for a plan that included the investment in water treatment capability that would cover the output of 3 of the 4 Mill Creek units. And so I understand exactly that aspect of your question. The commission approving that as a least cost plan was not what determined the retirement of the unit. It was that it is least cost to develop a plan for Mill Creek without capability to cover all 4 units. And those statements, to my understanding, about negotiating and having contracts signed, which of course at this point in time we had not signed contracts, were exactly true. We could move that treatment capability up and down to cover 3 or 4 units at the point in time that case was in hearing. But once this decision was made that it would be least cost to implement an ECR compliance plan for Mill Creek for ELG compliance with only 3 units being part of that approval, or part of that plan, then that's when we would effectively tie that we could and should, as part of our ELG compliance plan, retire Mill Creek 1.
Right, but in that, Mr. Revelet explicitly said that the decision would be made in the February timeframe. Yet, from your testimony, you made the decision in the exact same time frame that we were being told there was flexibility, and that our approval of the plan to only do 3 was not necessarily indicative of what the company's retirement decisions would be with Mill Creek 1.
So again, not having heard the full of Mr. Revelet's testimony, as is detailed in LEB2, which goes along with this discussion, there are concerns about NOx emissions in Jefferson County. That's what is implicit in your question. And we entered into an agreement to only operate one of the 2 units at Mill Creek during the ozone season for 2020, and we are going to enter into that same or similar agreement for 2021 and expect that for the remaining life of Mill Creek. And so that was something that we were thinking about at that time, but after all that had transpired, looking back in response to this question, we thought that the September 2020 date was the most responsive. We didn't mean that response to say that the commission somehow decided that for us. We were just trying to, in response to the data request, with advantage of history, all the history that had transpired when we had responded to this question, mark when that decision could be aligned with a point in time. We weren't trying to assign or attribute someone else's decision other than ours to making the retirement decision for Mill Creek 1.
Chairman, if you don't have a, because I feel like this line of questioning is very unfair to Mr. Pillar, I'd be happy to play him the video if that's okay with you, Mr. Chairman.
Chair. Chairman.
We'll see if this works, Mr. Miller. Do you see the video?
Oh, yes. I thought I was looking at another screen. Sorry. Yes, I do see the video.
Can you hear the audio?
I cannot.
And it's not going to work. So we'll move on. But I'll just tell you, having spent that much time asking those questions, it seemed from the answer that basically the response was that by the commission approving the ECR plan, that the commission's decision implicated the company's decision to then retire the unit. You're saying that's not necessarily the case.
That was not what we intended by that response. No, to assign the decision to require or to retire Mill Creek 1 to the commission. We were not intending to do that. We were just trying to pick a point in time in which we could make a response to the question. That was not our intent, though, to imply that the commission approved that retirement.
So on this item, are you aware of this is Mr. Revelett's testimony in that case, that ELG compliance, especially given that Mill Creek 1 has a single discharge point, that ELG compliance for Mill Creek is an all or nothing situation because there's going to be a common basin and a single discharge point. You can't run individual units in Mill Creek out of compliance with ELG. It's a station.
Correct. It's part of the KPDS permitting requirements that will kick in, that will have these additional reduction requirements associated with the ELG. And it is measured at the output of the Mill Creek station, not an individual unit.
Okay. So, trying to think of the best way to ask you this question. How about I just share LED2 as a starting point? We can be on the same page. All right. Can you see your LEV2 on the screen?
Yes.
Okay. So 1 second here. I apologize. LE2, nope, it's not that. In 4.2, no, I'm sorry, 4.3, the analysis methodology. Do you see this?
Yes.
Okay. You said here, before committing to actual retirement dates, the companies plan to evaluate the ability to replace the units as needed to continue to supply reliable, reasonable cost energy based on actual proposals from third-party suppliers and gathered via RFP and self-build alternatives. The results of this process will be filed with the Kentucky Public Service Commission and an application for a CPCN. You see that?
Yes.
Okay. And then I want to ask first about the methodology here, where you say that you looked at the present value revenue requirement for each alternative, that each alternative was computed as the present value revenue requirement of the following cost and revenue items. And one of them is the existing unit stay open cost, including ELG compliance cost and associated O&M. So my question on that is, did you assume ELG compliance costs as being a sunk cost or a stay open cost for Mill Creek 2?
So in order, based on our prior discussion, in order for Mill Creek 2 to remain open through 2028, there would be ELG compliance costs. And I think I spoke to this earlier in my testimony. What we did in the analysis is, in this instance, is we established, assuming ELG compliance costs for Mill Creek 2, we established what the most reasonable retirement date would be for Mill Creek 2 based on the need for an SCR in 2028, to put a specific date on it, and determined that that investment should not be made. And once we did that, to provide you a full answer here, we re-looked at ELG compliance costs in the context of them being, at this point in time, not a sunk cost. They would be a cost that we could avoid, and would investing in ELG support the operation of Mill Creek through 2028, and that analysis proved that it would. So the answer to your question is somewhat both. In the first analysis, we assumed that it's a stay open and it's a sunk cost, but then we went back once we determined what the more reasonable retirement date for Mill Creek 2 would be. Its previous retirement date was 2034. We determined that 2028 was a more reasonable retirement date. And then we back-checked, if you will, on ELG compliance costs, and would an investment in ELG to treat the Mill Creek 2 capacity be justified if we only operate that unit through 2028, and determined that that would be the case.
Okay, so how holistic is that review? Do you look exclusively at that point when you find out that the retirement date in 2028 is best for MC2? Did you also do the exact same thing in the first study, and then the second study, look at the change in your retirement dates for MC3 and 4?
So we did slightly alter the retirement dates of Mill Creek 3 and 4, but as the analysis LEB 2 shows, we did that more to organize in a reasonable fashion the retirement of those two units at the same time. So we didn't perform a specific retirement analysis on Mill Creek 3 and 4 as part of this exercise. There were no significant incremental environmental investments that we see on the horizon required for those two units. So we didn't perform that analysis for Mill Creek 3 and 4 here.
Except for ELG. Yeah, that's my concern. That's my concern, Mr. Beller, is in your first study, you would assume ELG as a sunk cost, right, to determine the appropriate retirement. And if you assume ELG as a sunk cost for 3 and 4 and change those retirement dates, I believe 2039, up from 2038 for Mill Creek 3 and down from 2043 for Mill Creek 4, and you treat ELG as a sunk cost, and you are now going to retire Mill Creek 2, plan to in 2028, which is just so happens to be the date in which you can run Mill Creek 2 without Mill Creek, the station, without ELG compliance. Did you rerun to see if it made sense then, if you're going to retire Mill Creek in 28 and you've reduced you reduced Mill Creek 4, whether ELG compliance continues to make sense?
So, what we did do in the ELG filing is we calculated how long the units would need to operate, and this is a generic statement, in order for that investment to be cost justified. I don't have memorized the dates in which that result came out for Mill Creek 3 and 4, but that is part of that proceeding. But you're correct, in this analysis, we didn't go back for Mill Creek 3 and 4 and look at the analysis. Again, there was no new, other than ELG, environmental compliance obligation for Mill Creek 3 and 4.
So I believe, are you talking about what I have here, which is SAW1 from the ELC? I'll zoom in for you. From the ECR cases, SAW1 redacted here, the break even between retirement and the ELG-free low cost scenario, the break even point of compliance.
I'd have to look at this table.
Here's the explanation below. In Table 24, the 2029 retirement case compares to the present value revenue requirement of ELG compliance and operations through 2028 to the present value of operating through 2028 with no ELG compliance. That I believe, so this is the break even, basically where it becomes positive, right? The year last Mill Creek unit retired in ELG compliance alternative. That's what you're talking about, right?
Again, I would have to kind of read through this analysis. I haven't reviewed it recently to understand exactly what it's showing me here.
Okay. But what you're saying is that you all already looked at that as long as the last unit, you all have already looked at as long as the last Mill Creek unit is retired by X, it makes sense to make the ELG investment. Is that what you're saying?
In a broad sense, correct. That was my understanding of the analysis we performed as part of the CPCN ECR filing.
Okay, but is that on an ELG3 basis or an ELG2 basis?
Help me with your terms, ELG3 and ELG2.
I'd be happy to. We can talk about Mr. Wilson's exhibit here for a minute.
Chandler, if I can interrupt. If I could interrupt for just a second. I'm absolutely in no way, shape, or form I'm trying to stop your question. You continue for as long as you want, as is your right. If there are specific things in the ECR case, whether it be Mr. Revlett's testimony that day at the hearing or exhibits that you feel like are inconsistent or that you would like for the companies to reconcile, we'd be happy to do that as a post-hearing data request. I certainly continue with your questioning, but Mr. Beller hasn't seen this exhibit any time recently. The same with Mr. Revlett's hearing testimony. So that might be a quicker way to the best answer we can provide you if you're interested in that.
No, I appreciate that, and I may end up following up, but here's the concern: is that it's sort of the data request that got us here, right? That they're imperfect and you're unable to follow up on them, and it's the data requests that have, I think, caused some confusion in what data drives decision making, right? And whether it's circular or one thing leads into the other. So I appreciate that. But if you look here, Mr. Beller, at Mr. Wilson's testimony of the Mill Creek alternatives, that these are the different alternatives that were modeled. ELG 4, 2032, 2034 shows that all 4 units, you see in the second column, all 4 units come in compliance. That's the ELG 4, right? And then the 2032 is the retirement of MC1, and the 2034 is the retirement of MC2. Do you see that?
Yes.
Okay, and so the same goes for those first 4. That the ELG 3 indicates how many, what the station size is built for, 4, 3, or 2 units, and then the first number indicates MC1 retirement date, and the second number indicates MC2 retirement date. Do you see that?
Yes.
Okay, and so my understanding is that this is the study that you were talking about, right? When you were saying the ELDR analysis.
Correct.
Okay. So the retirement dates for MC3 and MC4 in this chart are different than what the companies are currently expecting, right?
Correct. Again, based on LEV2, we're suggesting that organizing the retirement dates of Mill Creek 3 and 4 in 2039 versus 2038 and 2042 is a more reasonable projected retirement date. Obviously, so far into the future, there'll be subsequent analysis done before those retirements occur.
Right, and what I want to make sure of, because this goes back to my question to Mr. Blake about the retirement rider, right? And the investments that the companies make in units that they may not have anticipated retiring early, and by early I just mean before they're fully depreciated, right? Versus recovering their depreciation, their accelerate. I don't know if people take that word, but whatever it is, increase in depreciation expense in this case, right? Is that this study was done on the premise that Mill Creek 3 and Mill Creek 4 were going to be retired 2038 and 2042 respectively, right?
Correct.
And your new determination that was put out, at the same time the final order in this case came out, changed the depreciation for Mill Creek 3 and Mill Creek 4, and at least assumed those the third one, a retirement by 2024 or 2025 of Mill Creek 1 and 2028 or 2029 of Mill Creek 2, correct?
Correct. LG2, yeah.
But then in looking at ELG, even though things have changed, your assumption for doing the ELG 3 or continuing with the ELG 3 is based off the longer for Mill Creek 3 and 4. And instead of coming back and looking at it again as to whether or not it makes sense, you just assume that ELG compliance is the sunk cost for all 3 units.
Well, I went through how we processed Mill Creek 2, originally assuming it as a sunk cost and then re-verifying that it would be a prudent investment to operate that unit through 2028. With respect to Mill Creek 3 and 4, I covered that we did not redo and did not do an analysis for those units, and I explained the reason why. And so, just so I'm clear with that statement, your question, as I understand it, is did we look at a retirement date of Mill Creek 3 being 1 year later than what's represented in this table, 2039, and Mill Creek 4 being 3 years sooner, and reevaluate the ELG investment? Just to be clear, is that your question?
All of that, and I hadn't gotten there yet, but yes, and in the context of what you've learned with Louisville since the hearing last fall with the ozone.
Okay. So with respect to the specific part of that question, what we learned from Louisville and experience that transpired almost simultaneously with that September time period, and I'm talking about ozone readings in Jefferson County, we learned that Jefferson County is going to have difficulty and most likely won't be in attainment for ozone based on the running through your average. And so learning that influenced thoughts around Mill Creek 1 and 2. With respect to Mill Creek 3 and 4, those units have SCR, which is the best available control technology, or in the vernacular of the NAAQS compliance, which is the ozone season compliance we're talking about. It would be considered RAT, which, not to get into all the environmental lingo, that's reasonable available control technology. So in terms of NOx output in Jefferson County, Mill Creek 3 and 4 and their continued operation, again, since they have SCR installed, would not influence our decision at this point for Mill Creek 3 and 4.
Right, and the last caveat to that is, the assumption is that if Mill Creek 1 is retired in 2024, you all are looking at, or I just want to make sure I understand this, you all are making your decisions based off of the marginal versus moderate non-attainment, is that there's a cycle to the moderate and marginal non-attainment studies, right? That there's a certain number of years between when somebody is identified as being moderate non-attainment and when they have to attain that what you're saying is you still believe you'll be able to run Mill Creek 2 without an SCR between April and October. Is that accurate?
Correct. Based on what we see are NAAQS compliance issues. We list those in LEB Exhibit 2, in addition to future regulations, the CASPER regulations, that's the transport rule that you may be familiar with, and tightening of those regulations. So those things all go into the view on Mill Creek 2, and we think that 2028, based on what we know today, will be the most likely date in which we would have to have a control on Mill Creek 2 for NOx, and we suspect that control will be an SCR.
And if prior to that date, the companies are required to either run Mill Creek 2 seasonally, which you know that you don't run Mill Creek 2 during the ozone season, or that you have to retire Mill Creek 2 for compliance. How are you all looking at the likelihood of that in terms of doing ELG compliance for only Mill Creek 3 and 4 with 2039 retirement dates?
So our view today is that we would continue to operate Mill Creek 2 on an annual basis, and we would be able to do that through 2028. Obviously, as conditions change, and there are other environmental regulations that we're not aware of now, or environmental regulations are reinterpreted by current administration, we might have to change that and consider alternatives, as you premised in your question about seasonal operation of Mill Creek 2. But our view today and our current plans are to operate that 12 months out of the year, or make it available for operation should it be economic, for 12 months out of the year. And implicit in that, obviously, Mill Creek 3 and 4 would be available. And we are currently planning on installing water treatment capabilities to treat 3 of the 4 units at Mill Creek.
I just was curious. Feedback on that. Do you know how, for the purposes of your LEV2 calculation, that the Mill Creek 2 cooling tower was modeled or considered? Was it considered as a sunk cost?
The Mill Creek 2 cooling tower would have been be embedded in the stay open cost, the cost to operate that, and then there wouldn't be very many costs associated with dispatch there in terms of consumables, but it most definitely would be the maintenance of that, and all would be in an operation of the cooling tower would be in stay open costs.
Okay, and on that item, when you looked at LEV2 and stay open costs, you conducted this, let's say, mid-year in 2020. You start with capital stay open costs beginning January 1st, 2021.
I would have to look at LEV to see.
Yeah, I asked, it wasn't clear to me necessarily when reviewing LEV2.
Okay, let me look. I know there are tables in here.
Because I'll just say on page 10, for Unit 2, it looked as if you didn't start the stay open costs until 2026.
Right. The table 6 on page 10, and that's what I was looking for. So once we established the 2028 date, we prepared this table to illustrate the results of that analysis. But in the actual analysis, we would have had stay open costs in consideration for any retirement date, and we can provide a post-hearing data response to when those costs were locked down. I think that was really the gist of your question, is were stay open costs identified, what date at which or which plan were those stay open costs based on, and when were those costs locked down?
It was, because this seems to ignore costs in 2021 and 2025.
Well, this table is only illustrative of the results that we achieved. So this table is good for the scenario, or represents the scenario where we retire Mill Creek 2, in this case in 2028. What I was trying to communicate is we would have had other analysis that looked at different dates and stay open costs for all years in the study period beginning in 2021. This is more illustrative of the data that came from that study that would have had those different years in it. This just shows the analysis for a 2028 retirement.
Yeah, and I think that may be where I'm trying to keep from get feedback. That may be where I'm confused, because this seems to me, when you were talking about the two different studies, the first study determined the retirement date where you ignore some costs, and then the second study where you come back and you do the second part of it. This would, from your explanation, be the second study, but I don't know where you're considering the ELG compliance, because the ELG compliance will necessarily be before 2026.
Correct. So what we would have in this table, in table 6, is ELG compliance, and the cost, the variable cost, or the ongoing cost of operating the ELG would be in the stay open cost line. And those are costs that could be avoided if we retire the unit post 2028. And the second analysis that we did, if I'm understanding the root of your question, is to look at the investment costs, which wouldn't be included in this because it couldn't be avoided if we would have already made it by 2028. So we were looking at the second analysis to determine whether the incremental analysis at Mill Creek to cover ELG compliance for Mill Creek 2 would be justified if Mill Creek 2 only operated to 2028. That was the second analysis, and this was the first analysis. So as we had gone through earlier, in effect, the ELG compliance costs were a sunk cost in terms of the investment in this decision, but their operating costs were included in stay open costs. Then we went back and confirmed that it would be justified to make that investment if we can only operate Mill Creek 2 until 2028.
Okay. So I think my final question, Mr. Beller, and I'm happy to ask Mr. Sinclair since this is also, sort of hidden vision. Are the companies going to take a second look at whether compliance with EOG for the entire Mill Creek station makes sense given the change in all the depreciation or all the retirement?
We can most definitely perform that analysis. Again, it would be a matter of having Mill Creek 3, assume it operates 1 year longer, and then bringing back Mill Creek 4, which is 2 or 3 years, whatever that difference is. But we can most definitely look at that in the context of the ECR approval.
Sure. I appreciate it, Mr. Beller. Chairman, that's all I have.
Commissioner Matthews, questions? Commissioner Matthews, I guess I'm muted, right?
Chairman, you are on mute.
Well, I don't know how to unmute. I think somebody else does that. Isn't that correct?
Give me 1 second, Your Honor.
I think I'm unmuted now.
Yes, I can hear you now.
When you're up here, you have no control over your own fate. Commissioner Matthews, any questions?
I have just a few. And they're going to seem very disjointed because they refer likely to pieces of lines of questioning of the vice chairman. On EV fast chargers, did I hear you correctly when you said there would be an interconnection? They would go through the interconnection process?
What I was referring to is Vice Chair Chandler's question on what we are doing or would do if approached by a third party to install an EV charger. If I didn't intend to say that there would be a formal interconnection request, what I meant to say is we would have conversations with the customer based on the ability of a particular location, a parking lot, a warehouse, or something of that nature to serve an EV charger, and that we would be working with customers based on those requests. But to my knowledge, we don't have any type of formal process for identifying the best places to put EV chargers for third parties or anything of that nature. But I didn't intend to convey that we had some type of interconnect process that was any different than any other customer that would seek service from us.
Okay, I may have misunderstood, but I believe that I heard that and wanted to get some clarification. Thank you. You talked about the targeted level of reserves. What are those? We were talking about retirements and building new units and RFPs and so forth. What is the company, or what are the company's level of reserves that constitute this target?
So in our latest analysis of reserve margin, our range of appropriate reserves are between 17 and 25%. And I believe in LEV2, we outlined that we would fall below that level if you were to assume the retirement of Mill Creek 1, Mill Creek 2, and Brown 3. I think to get us back above that level, we'd need 278 megawatts of capacity. So those are mathematical calculations, as you know from your past. As we determine and look for alternatives to meet that capacity need, it may be economic due to a number of factors, to acquire more than that capacity to meet that need, but that sets the base need as we think about it. There will be substantially more analysis done once we identify what the least cost alternative is to meet those needs.
Let's talk for just a second about your participation in SEAM, which could at best facilitate, I'm getting some feedback, could facilitate more trading, right? You don't have to have a transmission opportunity there. You've got the 15-minute bulletin board, if you will. Does that change at all your mathematical calculations of what the target reserves are for the system?
I would say that the broader answer would be no. These are all non-firm transactions, and we wouldn't be considering any incremental capacity additions based on the ability to make non-firm transactions. So we would look at SEAM again as an extension of the current bilateral markets that we participate in. So it would not affect at all the reserves that we would consider on the system.
And that was my assumption. Okay, then just to the line of questioning about your space planning process. And the vice chairman referred to the KU headquarters in Lexington having been renovated. How many folks are located in that building? And for example, do you have an office there? Does Mr. Thompson have an office there?
So if Rick could pull up PSC 6 KU. Yes, one of the last questions. And Rick, if you could space down, I can provide Mr. Matthews her answers. I'm looking at Part B if people are following along. So in 2020, we had 208 employees assigned to the One Quality Street. And within the restacking of that building and the renovation of that building, it's my understanding we have established more generic offices. I wouldn't have an office there specifically, but there would be a place that I could work if I were at the KUGO or Mr. Thompson could work there.
Okay. Thank you. And is that, well, just quickly, is that different from pre-renovation?
There were spaces in the building pre-renovation, empty offices that any of us could drop in if we were there, if we needed to take a call or do work. So not a whole lot different than what we had before, but in a little more organized fashion since we call it restack the building, organized where all the employees were with the renovation.
I don't have any further questions.
Mr. Ingram, any redirect?
Yes, just a little bit, Your Honor. Mr. Beller, back on the question that Commissioner Matthews just asked, I may have misheard you on the office space at KU. Were you referring to PSC question 6-34 subpart B?
Correct.
Okay, I thought that's what you said, but maybe I misheard you. I want to make sure it's perfectly clear. And then if you could, Mr. Beller, Mr. Lovekamp, could you all turn to Mr. Beller's exhibit number 3 to his direct testimony, LEB 3. The cost benefit analysis. Is the audio causing trouble, Your Honor?
Could caller 10 mute their phone, please?
Okay. That seems to be better. Is it, Your Honor?
Yes, it is.
Okay. So, Mr. Beller, Exhibit LEB3 to your direct testimony. That's the AMI cost benefit analysis. Is that correct?
Yes.
Now, there is an Appendix A to that Exhibit LEB3. Mr. Lovecamp, could you show him page A14, which is Appendix
Yes, I have it here.
okay, and at the top of that page, Mr. Beller, what table number is that?
Table 20, meter reading and inspection costs.
And if you look at, does that table reflect the company's expected meter reading costs for the various meter reading scenarios studied in that analysis?
Yes.
Through the years 2030?
Correct.
And could you just explain generally what the expected cost of meter reading would be under the status quo environment?
So the status quo environment would be a continuation of the activities that we perform today, and that would be manually reading most meters that we have on the system, and those costs are projected out over time.
Okay. And then what is the recommended solution for the company's meter reading obligation?
So it would be on this table 20, row 3, AMI plus AMR gas only, and that would be our recommended approach.
And would you agree with me that there's a significant reduction in meter reading costs under that recommended solution, especially once you get to years 2024, 2025, and 2026?
Correct. As AMI meters are installed in that scenario, we have fewer meters that need to be read manually, and the corresponding lower meter reading cost is reflected in this table.
And so would that decrease in numbers also be reflective of the savings in meter reading costs that you currently have pursuant to the meter reading contracts that Vice Chairman Chandler asked you about?
Correct.
Okay. Your Vice Chairman Chandler was asking you about your office space here in Louisville in the LG&E building. Do you recall that line of questioning?
Yes.
It testified that you were that LG&E and KU are under lease for the office space at that building?
Yes.
Do you recall when that lease terminates?
The lease expires at the end of December 2025.
Over 4 years from now?
Correct.
And then finally, Mr. Beller, you received questions from Mr. Nguyen and Vice Chairman Chandler on the Bullitt County gas pipeline. Do you recall those questions?
Yes.
Do you know whether there are any construction costs for that pipeline project in the revenue requirements in these rate cases, or more specifically in the revenue requirement in the LG&E rate case?
No, we don't anticipate starting construction in the forward test year represented in the LG&E gas case.
That's all I have, Your Honor.
Thank you. Mr. Nguyen, anything?
Nothing further, Your Honor.
Commissioner, Vice Chairman Chandler, Commissioner Matthews?
I don't have anything, Chairman.
I don't know.
Thank you. Mr. Beller, unfortunately, I've been requested to ask you to kind of hang around or be available through the end of the hearing. So I don't think you have to necessarily sit in the room, but we would appreciate if you would remain available through the hearing. But at this time, you may step down. Thank you. Mr. Ingram, Mr. Riggs, you may call another witness.
Well, we need to obviously change witnesses and change counsel, Your Honor. Would it make sense to take a 5-minute break, or do you want us to go ahead and do that?
No, we could do that. Why don't we take why don't we just take a 10-minute break, and when we come back, we'll try to go to 5. How's that? Okay?
Thank you, Your Honor.
We'll be in recess until 20 minutes until 3 o'clock. Okay, I guess we're back on the record. Is KU and LG&E ready to present another witness?
Yes, good afternoon, Your Honor. My name is Matt Parsons. I'm with Delkeen and Ogden, here on behalf of KU and LG&E.
Okay, you
And I
may.
have Mr. Wolf with me.
I'm sorry, who is your next witness?
John Wolf.
And what was his name, please?
Would you please state your name again for the court reporter?
John K. Wolf.
No, the council.
Attorney, counsel.
Matt Parsons.
Person? Thank you.
Okay, Mr. Wolf, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Counsel, you may ask.
Mr. Wolf. Thank you, Your Honor. Mr. Wolf, can you please state your full name for the record?
John K. Wolf,
Who is your employer?
LG&E and KU,
What is your business address?
200 West Main Street, Louisville, Kentucky, 40202.
What is your job title with LG&E and KU?
I'm the Vice President of Electric Distribution Operations.
Mr. Wolf, did you cause to be prepared and filed in these proceedings written direct testimony and exhibits to that testimony? Did you also cause to be filed rebuttal testimony?
Yes, I did.
Do you adopt that written direct and rebuttal testimony as your own testimony here today?
Yes, I do.
The witness is available for cross-examination.
Okay. Mr. Nguyen, questions?
Yes, just a couple, Your Honor. Thank you. Good afternoon, Mr. Wolf. Can you hear me okay?
Yes, I can. Good afternoon.
Good, great. Can I ask you to refer to, and I'll just provide KU response to staff's 6 data requests, item 7.
I'm there.
Okay. I just wanted to expand on one of your responses here to make sure that I understand the company's plans for DERs on the distribution system. I'd like to begin with you providing the company's definition of a distributed energy resource. What would the company's definition of a DR be?
From our perspective, distribution energy resource would be any distributed generation, battery resource, energy efficiency measure taken behind the meter that is connected to our distribution grid.
Okay. Would that also include solar type resources as well?
Yes, renewables would be considered a
okay.
distributed generation, yes.
Okay. And then if I can jump to, in your responses to 7A through C,
yes.
Can you explain the precise data the companies plan to use and how it would be collected?
Yes. Can you go to 8? 7A. 7A, yeah, I'm sorry, I thought you said.
Yeah, I'm sorry. It's yeah, you provided certain benefits from 7A through 7C.
Yes, yes. And I'm assuming this is referring to the desire by the utilities to have better information respective to interconnected DER resources on our grid. Today, when customers interconnect to our grid, they apply to do that. And essentially, once that application is filed, after they interconnect to our system, particularly for net metering customers, we do not have the minute-by-minute activity, net metering activity behind that meter. We cannot measure that. And so what we desire to do with either through production meters or with a DERM system in the future, what we hope to do is have better information about distributed generation resources on our system. The responsibility of distribution, electric distribution, is to manage the system and ensure that we have adequate capacity for our customers and that we have good power quality for our customers within prescribed ANSI limits.
And without knowing what the generation resources are doing, what the DER resources are doing behind the meter, it really challenges the utility to be able to do those. And particularly as you look forward where you have greater proliferation of those resources on the grid.
Okay.
And so what we would use these sources for, this data, is to help manage our voltage, understand the value that these resources are providing to the grid, enable us to make better decisions, investment decisions on capacity and other factors that we have to decide upon on a daily basis.
Okay. Thank you for that. And specifically on your response to question 7A, you note that the data will allow for location analysis to better plan needed system improvements to services transformer upgrades. Do you see that?
Yes.
Okay. Could you please provide a detailed example of the data you would use, the process that would be undertaken, and the benefit that will be created through this type of project or work?
Yes, and again, I think what we proposed in our AMI case, and with later integrating AMI with our EMS, ADMS, our outage management system, is that as this data becomes available, and we would integrate that, I believe, in plan until 2024, 2025, as we get that data available, we can leverage data analytics and algorithms to help us identify equipment on the system that's either overloaded, underloaded, those types of things. And then that would initiate through a work planning system activities of our crews to go out and test that equipment and determine if, as an example, the equipment needs to be replaced due to malfunctioning, or if there's opportunity to reduce the size of that transformer, as an example, or increase the size where loading is an issue.
Okay. And then you also note that the data will allow for location analysis to better plan needed system improvements to have better visibility when optimizing volt-var optimization and conservation voltage reduction programs. Again, could you provide some additional information regarding these type of programs with respect to the data you'd use, the process that the companies would be undertaken, and any benefits that would be created through this type of project?
Yes, and I'm sorry, could you repeat that again for me?
Sure. And this is in regards to location analysis to plan better.
Okay.
To better plan needed system improvements in terms of optimizing volt-var and conservation voltage reduction programs.
Yes. Okay. Yes. Today, the data that we have available with respect to the contribution of DER resources on the grid is aggregated at our substation transformers. And again, we go to our testimony. I think it's 15. I'm sorry. That's 19. I believe it's 5-19 for LG&E. But basically, that's the 8760 report, which gives us all of the data on that substation for all connected devices, and that would be connected load and connected DER resources. Today, that is the only data that we have that allows the utility to understand what the implications of DER resources are on the grid, have on the grid in real time. Again, the only other data that we have is the original application, and so once that resource is interconnected to our grid, we only have aggregate data available. And so with better data at the meter, better voltage data at the meter, the implementation of a DERM system, all this additional data enables us to potentially monitor and control the volt-var settings, in some cases with approval, obviously, from the commission, that we can control the output of the inverters to help manage voltage and VAR on our grid.
Okay. In reference to your response to item 7B. You mentioned research the companies are engaged in with EPRI.
Yes, sir.
Do you know if that research has resulted in any written materials, memos, reports, or any other written studies that the companies have received?
That study is still ongoing. Again, I think we are one of more than 30 utility companies that are participating in the study. I think that highlights the importance of the study. And what the study is really looking at is designing a more robust modeling tool that enables utilities to model the effects of DER resources on the grid. Most of the modeling tools that are out there in the industry today were built around the bulk electric system delivering electricity from the generator to the point of consumption, one-way flow. Today, we do not have data on all the all the generation out there on the grid behind meters. And so what this modeling tool will enable us to do, what we anticipate, will be to be able to model those resources on the grid under various scenarios, under peak loading conditions, et cetera, to help us better understand what the implications of these DR resources are, both in the system planning perspective, but also when we start having additional interconnection applications come to the company, we could leverage that information of what we know already, and then automate the process by which customers apply and then are modeled on the system to expedite the interconnection process.
Okay. Do you know when that study will be? Do you know when that study will be?
My understanding is the study is wrapping up near the third or fourth quarter this year.
Okay. Can I now refer you to company's response to staff's 6 requests for information and item 12?
Yes.
Okay. The response deals with the company's evaluation and studying of the DERMS and its impact or potential impact for the companies. And you note at the end of the response, the companies were not able to conduct the search for the requested documents within the time allowed to respond to this data request. Could you provide these in a poster and data request, given that there will be additional time now to do that?
Yes, we could.
Okay.
And part of the primary issue there is the information that would be provided was provided to us by other utilities, and we wanted to get permission from them before offering that up.
Okay. Understood. And now can you go to item 22 of the 6 data requests? Are you there?
Yes, there.
Okay. I guess it's near the bottom where you state that the DERs are not yet creating problems on the KU electric system due to the relatively low amount of capacity interconnected. Is that accurate?
Yes, that's accurate.
Okay. And that you note that with additional investments, the companies will be well positioned to navigate the increased adoption of DER in the future. Can you expand on this a little for me? What types of benefits will the companies be able to derive from solar and other DERs with all of these additional investments, such as the GIS, the ADMS, and potentially any AMI?
Okay, I'll start my response with with commenting on that a lot of the investments that we've been undertaking over the last 4 years at the start of the distribution automation program, they are enabling us to enhance what we are doing in respect to managing the operations of the distribution grid. And these investments in the grid are also enabling us to then look forward into the future challenges that we anticipate with greater proliferation of DER resources and with greater adoption of electric vehicles by our customers. We realize again, because we don't have adequate data at our meters or at our customer points of delivery, that we need better data. We need to be able to leverage technologies, the convergence of technologies, to control the voltage from the point of delivery again to the point of consumption. And what we're doing with the advanced data and with data analytics, with enhanced modeling tools, with a DERM system, is being able to truly monitor what's happening at that distribution generation source, that DER resource. We're able to see the amount of energy they are pushing out on the grid. We are seeing truly what they are producing, so that if there's any load mass behind that resource, we can see that too. And I think generally what we hope to obtain with all this data is to ensure that we are operating the distribution system optimally, that we're making investment decisions that are based upon data and not based upon assumptions. And again, what we hope to do with this increased technology and data is to, as an example, avoid adding capacity on distribution lines or in substation transformers or service transformers, because we think that there's load mass there. Today, we do not have the ability to see that. And so what we are proposing and planning for in our future is to have enhanced technology, better visibility of what these resources are doing to enable us to more effectively manage the grid and manage investment decisions.
Is there a certain point in time in terms of the saturation of the DERs on the company system that would then trigger, the ultimate need or a requirement to implement a system such as the DERMS?
That's an excellent question, and I can tell you that one of the things that we've done as a utility, sometimes it's good to be the caboose, is what I tell some folks. In Kentucky, we're 48 out of 50 states in renewable adoption. And what we've talked about with other utilities, including PPL and Western Power Distribution, our sister companies under the PPL umbrella, we've talked to them, we've talked to other utilities in the industry, and collectively they all say the same thing, that once you start seeing exponential growth, it's almost too late to start making the adjustments needed on your grid to meet the demand and make sound investment decisions with respect to managing that new resource. And so what we have tried to do prudently is put in our plan, it's a 5-year plan that started largely last year, to invest in voltage management and control, voltage optimization, and to also invest in future modeling technologies, such that when this exponential growth period starts to accelerate, which we think we're already in the exponential growth period, that we will be capable of responding to customer requests to interconnect, and also be able to understand what it means to our distribution grid. The DERMS system that's proposed in plan is year 4 of our plan, and we realize that may be a floater in the plan, and we'll base that decision to move on the advancement of that technology in the industry, that it's proven technology, and then also on the penetration level of DER resources in our territories.
Okay, you mentioned that that you think that the companies are already in the exponential growth period for DERs. Is that correct?
We are starting to see exponential growth in the number of applications received.
Okay.
So we think we're at the bottom of the S.
So, what has been the increase in the number of applications from year to year?
My understanding is, and it's subject to check, but we had 300 2 years ago, then the 400s last year, and then my team shared with me last week that we're projecting 550 applications this year and potentially 5 megawatts of connected DER resources.
Is that for both KU and LG&E?
That's combined, yes, sir, combined. And we stand at roughly 12 watts today and 1,300 customers, net metering customers. Those are net metering numbers, I'm sorry.
And do you have that broken out by company, by chance?
I do, and I could provide that to you in post-hearing.
Okay.
Discovery.
Thank you, Chairman. Those are all the questions I have.
Vice Chairman Chandler, questions?
Yeah, thank you, Mr. Chairman. Good afternoon, Mr. Wolf.
Good afternoon, Vice Chairman.
Do you have, or can Mr. Lovecamp help you bring up your direct testimony? JKW, those are your initials, right? JKW.
Yes.
And then it's page 17 of that document, which is the electric operations 2021 distribution 2021 to 2025 distribution reliability and resiliency plan. Page 17 of that document.
Yes, sir.
So this is a redacted document. We're just going to talk about the public information on it. Could you walk me through, or we'll walk through, starting on page 16, these system reliability and resiliency investment programs? Those are the types of investments you were just discussing with Mr. DeWin, right?
They are a little different in that these are more oriented toward reliability of the grid, circuit hardening, whereas I think the investments we were talking about earlier would be more capacity-oriented type investments.
Okay. So we'll go through, on page 17, you put here that the 2021 business plan has, is that almost $13 million for distribution automation?
Yes, sir. That was the last year of our plan that started in 2017.
Okay, so I understood that plan to be a 7-year plan that you all got approval for in 2017. Am I wrong?
That originally was a 7-year plan. Yes.
Okay, so if you go to the previous page, it discusses it. Under section 1 there, it says the companies received a CPCN for advancing distribution automation on the electric distribution system in July of 17. You got a CPCN 17, and you plan on getting it done in the 2021 business for only 4.5 years, right?
Yes, and there are components of the project that will require additional work that are not investments. And so what we've done in the project is essentially get the software applications put in place and putting electronic reclosers out on the distribution grid. Collectively, with the appropriate communications, that allows us to eventually automate every single circuit that is connected. And so the next phase of the project will be to go through each of the circuits, and they currently are still in manual mode. The assets are in the field, but what we have to do now is go through the process of enabling the automation, and that takes engineering time to test what the devices in the field are telling us against what engineering analysis would prove out, and make sure that it all is working as it's designed. And then we would proceed through the automation of individual circuits. So the investment component of the project is over this year, but there's still work to be done to fully automate those circuits.
Was that
To-
the
to
plan?
adopt.
When the company filed for the CPCN, they got approved in the 2016 rate cases. Was the plan to have all the capital investments by the business plan in 2021?
I believe that we have compressed the capital investment largely due to the efficiencies of installing reclosers have gone better than what we projected it would take us to do. So yes.
Okay, so those investments were pulled forward. On the second item there, the capital funding for system hardening, these are what, reliability investments?
Correct.
And this, can you explain these to me? Are these things like increasing the loading on certain poles that are susceptible to breaking, or is this something more significant?
That would be looking at the poles, cross arms, conductor. We typically evaluate areas of our system that may experience more outages during storm events than others, and we would target those for improvements. And so largely that is replacing hardware, upgrading poles, upgrading the wire to make it more resilient to this type of outages caused by falling trees, et cetera.
Okay. Then the next customer is experiencing multiple interruptions. You see that?
Yes, sir.
Okay. So can you explain to me these numbers here on page 18, the CEMI 1, 2, 3, 4, and 5? Are these the number of customers? Is the 246,000 number the number of customers that were interrupted once? And then
correct.
And so you have effectively plus or minus about 4,844 customers in 2019 that experienced just shy of 5,000 customers who experienced 5+ outages.
Correct. And so this program is designed at focusing on pockets of customers who may experience high frequency of outages, and it's looking at, these are typically smaller projects in scale, what we need to do to reduce the number of outages those customers experience.
What's the length that an outage has to be to show up in this study, or does it include momentary outages?
Outages are 5 minutes or larger. What qualifies as an outage under our reliability measurement?
Is that an IEEE standard, or is that an internal measurement that sets it at 5 minutes?
My understanding is IEEE standard for 5 minutes. Yes.
And how do you all look at issues with momentary outages? How do you plan for those if you only look at ones that are the CEMIs that are in excess of 5 minutes?
We have separate reporting on momentary outages that our engineering groups, local engineering groups are monitoring. And when they see issues with momentary outages, we have a report on that, and then the local engineer would try to address what the issue is. And sometimes that's just a protection setting, being too sensitive. It may involve tree trimming that needs to be done, things of that nature.
Do you have those momentary outages aggregated in a manner like these CEMI, these 5+ minute outages?
That's difficult to know for exactly, because it relies on the availability of electronic reclosers on every circuit across LG&E and KU, and we do not have that technology deployed on every circuit. We would have that for select circuits that had the technology placed prior to the last reporting period. But we would have it on circuits where that technology is deployed. We would be able to tell them.
Is the information for 2020 available yet for either those momentary outages or for the CEMIs that are in excess of 5 minutes?
Whatever reporting that we have available, we would have the data to support what was happening on those circuits where the technology is there.
Okay. I'm asking for the CEMIs, the numbers here for 2019, it's almost May now. Do you think you all have the 2020 numbers if requested?
Oh, for the CEMI numbers, yes, we should be able to have that. For 2020, yes.
So I
want those numbers are first quartile numbers in the industry when we compare our performance against other utilities.
Okay, I wanted to go down just for a second and look at the section 7 and 8, the underground fault current indicators and the aging infrastructure replacement. So I noticed that the 2021 for the underground fault current indicators is the only year in the 5-year business plan that has any money allocated to it. The test year amounts, effectively. Is that the only year in which you all are doing this, or is that the last year in which you have a planned capital allocation?
That's the last year of a planned program that is concluding this year.
Okay, and then the next section, aging infrastructure replacement.
Yes, sir.
The first year is 29 million, and then it tapers off from there, where the second highest year is in 2023 at 16.705 million. Do you see that?
Yes.
And so is 2021 just a high year, or is it, were the years preceding 2021, in that neighborhood of $25, $30 million?
I think the main driver of the 2021 looking out of sorts with the remaining years is that we have the PILC cable replacement program in downtown Louisville, a program that started, I believe, in 2013, and that program is wrapping up in 2021.
Okay. And then if we could, the next section, the pole inspection and treatment program.
Yes.
Okay. So I wanted to ask about this. So it says before 2010, it's the third paragraph. Before 2010, those distribution poles only received an inspection every 2 years in accordance with KPSC requirements. And that you understand, or is the reference there to the regulations that require every pole to be inspected from the ground every 2 years? Is that what that reference is to?
Yes, it's a safety check, and what the cycle program is a more in-depth program that sounds the pole, digs below grade to see if there's any rot, and if necessary, does a load analysis on the pole to see if it needs to be replaced. It's a much more in-depth inspection than the PSC inspection part.
That's exactly what I wanted to ask about. So you all are still, even though you talk about and down here that you've inspected, 542,000 poles, that inspection is not necessarily an inspection to satisfy the 2-year requirements under the regulations, right?
That's correct.
Okay, and so can you just tell me what you all do different between the inspecting a pole from the ground according to, I think it's the general rules in the regulation, versus this other inspection protocol where you talk about you're looking at the ground, you're looking for rot, you're looking at loading. If you could just tell me a little bit about what the difference really is between the two.
Well, I think you really highlighted it. The PSC inspection is really a safety inspection. It's also look at the condition of the asset to make sure it's going to be able to continue in service safely between now and the next inspection cycle for the PSC. This program is much more in depth, where again we go to every single pole, we sound it, we drill into it, we treat it if we can to extend its life. We dig below grade to check for rot, and if it fails that inspection, then we schedule it either for support and or replacement based on the priority of the pole condition.
So I see that you all feedback here. Maybe if I get closer to help. Indicate there's a study that shows that that no remedial treatment requires poles to be replaced every 32.5 years, while poles who get, let's just say, greater attention can last up to 50. Is that right?
And could you provide me the source of what you're saying?
Yeah, it's the second to last paragraph there, page 21.
Okay.
The sentence starts, its very last sentence in the 4th paragraph on page 21 that starts off one industry study.
Mm-hmm.
You see that says one industry study indicates that predicted pole life with no remedial treatment is 32.5 years compared to a predicted pole life of greater than 50 for poles with remedial treatment.
Yes,
So
yes.
you all have been doing this program for 11 years. I'm just curious what evaluation you all are doing to test whether the incremental expense is resulting in longer lives for the poles.
Yes, the data analytics group is currently evaluating all poles that have been a part of the program and are using that data to determine we were supposed to wrap up, I think, the first cycle sometime next year. And at the conclusion of that period of time, we're analyzing all of that data to determine, first of all, what poles should be inspected and what priority, but also to evaluate what the benefits of the program is. What we do know is that, and I don't have the data in front of me, but we do know that the average life of the pole is meeting what this study says, and that the pole-related incidents on the pole, on individual circuits for circuits that have gone through this program, we have seen a dramatic reduction in pole-related outages on circuits that the pole inspection treatment program has been through, and that the poles have been replaced where they needed to be, or where they've been braced where they needed to be.
Are you aware of any docket in which the result of that analysis is required to be filed with the commission?
I am not.
Okay.
Personally, no.
And then I just want to make sure that I'm clear. If we go to the bottom of this JKW1, I think there's an aggregate. On page 36 and 37, if you can ask Mr. Lovecamp to.
Okay. Just about there.
You see that it provides the aggregate capital cost for the 5-year distribution management plan, or the distribution operations plan?
Yes, I did.
And so there's a $91.5 million investment intended in 2021. Effectively, at least the majority, a good portion of that would show up in the test year in this case, right?
Mm-hmm.
And then it drops off to 56, 62, 51, and $50 million in the subsequent 4 years.
Correct.
Is that sort of the distribution portion of what Mr. Blake was talking about when he discussed that the capital needs in the out years, the different sectors, and I know you're only responsible for the electric, distribution operations, but is that along the same lines that you all have an expectation that at least compared to the last, let's say 5 or 10 years, the capital needs are lower, at least in your division, over the next few years than in the past?
Yes, that's an accurate statement. And again, I think if you look at the individual projects, such as distribution automation and the PILT program, we have some programs that are nearing completion of their project life. And when those projects complete, it's more back to what I would call normal investment on the grid to maintain reliable service.
Sort of a replacement mode instead of a surge, change in operations mode.
It's more of we had the distribution automation was about adding intelligence into the distribution system. We had some issues in our downtown network with 100-year-old cable. It created some safety concerns, some operational concerns, and so that's why we ramped up our investment in the PILT program that I mentioned earlier. And so I think those two programs, and then there's a few minor programs that are wrapping up in 21 period. But I think it reflects what Mr. Blake said in his testimony.
I want to just for a second. Can you tell me in your group's actions, what do you all do? Walk me through. You're going to go out to satisfy your 2-year inspection of poles, right? Just the ordinary regulation. What does the inspector do when they get to that first pole?
So they're not only inspecting the pole, they're inspecting the entire overhead facility, all the overhead facilities. So they'll come up and look at the pole, and sometimes they're actually driving this. They may not even, in some cases, get out of the car. But the inspection involves looking at the overhead assets to make sure there's nothing that appears to be unsafe, that it appears to be in good working order. They'll sound a certain percentage of the poles on the circuit. If they find a pole, because a lot of those poles are placed around the same time period. So if they found a pole that appears to have weakness, they will then go to the adjacent poles to make sure there's not an issue with all the poles down that stretch. And then that's essentially it. And then they document any deficiencies identified. And if they identify a pole that needs to be replaced, they will put that into a backlog and is prioritized for replacement based upon the rating of the deficiency of that asset.
When you find a pole that's ready for replacement, do you all still physically tag them, or do you all use like a GIS system?
We have a work order system that essentially tags to the asset. I think in the field we actually mark some poles to indicate that this one is planned for replacement.
Okay. And are all your distribution poles GIS? You all have them in your GIS system?
Yes, sir. Okay. All facilities that our overhead lines are attached to, so that would be foreign-owned poles and company-owned poles.
Okay. You heard me ask questions. Did you hear me ask questions, Mr. Beller, earlier about the CVR and the volt bar, the VVO that the companies have installed or intend to install?
Yes, I did. I heard.
And what I want to make sure of is first, is there an incremental amount of voltage regulation or volt bar or any other hardware, we'll call it hardware, right? Capital hardware, that would be necessary to implement CVR other than AMI meters that are incremental to what a status quo would be?
No. There will not be incremental costs for CVR, and I can go back to explain the investments we talked about earlier, respective to being able to manage voltage on the distribution grid, what's called a volt bar optimization. The company's distribution had plans for implementing a VVO system and technologies on the grid to enable optimization of voltage on the grid. And that was largely driven out of the higher penetration of DER and electric vehicles that we forecast into the future. And then again, listening to our peer utilities tell us you need to start looking at it now. And so we had in plan roughly $1 million per year over the next 5-year period to deploy communications and controls technologies on existing line devices. And so I think it's important. This is very fuzzy, even within our company talking about it, because essentially the industry has been effectively trying to effectively manage voltage ever since the first generator was placed in Pearl Street, New York in 1882. They've been trying to figure out how to manage voltage. And even though the utility doesn't really get credit for voltage conservation, and I'll use an analogy. UPS doesn't deliver packages to your home in 747s. They deliver them to the regional locations, then they put them in feeders, 40-foot feeders to local distribution centers, and then they come to your home in a package car. And the electric delivery system is designed the same way. We conserve voltage in the way that we step it up to deliver it over to the load centers on transmission lines. Once we get to the load centers, we step it back down. And then when we get to the point of delivery to our customer, we step it down again. So we're constantly looking at how we can manage voltage. The difference in the VVO technology is that it enables us to operate within the mid-range. So we have to abide by or meet the ANSI requirements, plus or minus 5% of nominal voltage, which is 120 volts at a typical residential home. And when we are using just VVO, which is, again, what we are planning to invest in, it enables us with DER resources and electric vehicles on the system, it enables us to ensure that we're staying within those boundaries that have been established. What CVR is, and it's a different objective, but uses the same technologies. So the software systems that we're putting in place for VVO, the controllers and communications that we're putting on existing equipment on the grid, all of those investments are already in plan and would be done even if we were not doing CVR.
So what I want to make sure of, as a follow-on to that question, is it also fair that in addition to you saying there won't be, so VVO, no additional VVO is what you're saying. And let me ask about any other control systems or any other capacitor banks that may be necessary. You all are under the impression that there will be no incremental capital expense for implementing CVR over the status quo.
I think if you look at the CVR study, within that study, it talks about how the circuits that were selected for CVR were selected, and it was based upon the existing equipment that was on those lines. And that would entail low tap changers, capacitors, and regulators. We're not, for the 404 circuits that were selected because they already have that equipment.
Okay, so you already have the equipment. My second question is, are there costs that are incurred, or is there wear and tear that needs to be accounted for using those to reduce voltage, purposely reducing voltage, right? When you can, is there additional wear and tear where those will depreciate faster than the status quo?
The best answer I can have there, I can't tell you without knowing specifically how the system will respond to lowering that voltage. Everything we know about the way we manage the system today is based upon one-way flow and not operating within those boundaries. I speculate that any dynamic approach to voltage management will require equipment to be operated more dynamically, which means more operations. But that was a plan. Without CVR, we were planning to do that dynamic approach to compensate, again, for what we believe will be more voltage fluctuation associated with the greater penetration of DER and electric vehicles. So there is likely to be some increased operations of equipment for VVO. I cannot tell you precisely what that means as far as what increase in ratio for CVR, because essentially what we're doing is just lowering the band to tighter parameters. And it will essentially be how the distribution system itself responds to that lower voltage.
Okay.
And whether it'll operate more frequently or not.
So, I ask this half tongue in cheek. You don't expect to come in here at this point, knowing what you know, to propose additional capital improvements, the driver of which is to implement CVR.
At this point in time, the companies are deploying a VVO system, and because of that deployment and the deployment of AMI, we can now do CVR. We were going to deploy a VVO system regardless of CVR.
And you're not changing the size of the VVO system?
No, sir. No.
Okay. That's all I have, Chairman. Thank you. Thank you, Mr. Wolf.
Thank you.
Commissioner Matthews, questions?
I don't have any questions for this witness. Thank you.
Mr. Parsons, any redirect?
Mr. Chairman?
Yes.
This is Tom Fitzgerald for the joint interveners. I had just one or two questions relating to the interconnection conversation. The issues that are carved out from the settlement include net metering and then the interconnection issues associated with net metering. And I just needed clarification on one or two points, if I could.
Sure, go ahead. Ask your questions.
Thanks very much. Mr. Wolf, can you hear me okay?
Yes, I can.
Wonderful. I believe your testimony was that, and I don't want to put words in your mouth, so if I'm not getting it right, please correct me, was that there's been a significant uptick in applications for interconnection for distributed generation. Is that correct?
This year is what my team is telling me. They're seeing an uptick this year, yes.
Okay, and do you know, you had mentioned how many applications are pending for LG&E and KU at this point, roughly?
I don't have that information in front of me, but what they're projecting is 550 applications this year compared to 400 or so last year.
Okay, thanks. And do you know how many, you had mentioned a certain number of megawatts if all of these applications were approved. And what was that number?
What they're projecting for 2021 is 5 megawatts added, and I think we're sitting at 17 today.
Okay, and do you know of those applications, how many of them are for net metering as opposed to larger utility scale solar arrays?
My understanding from my team that reported this to me was that these were the net metering applications, and I could confirm that, but that was my understanding.
Okay, and just two final questions. Are you aware of any instances where either LG&E or KU has had to upgrade either their transmission or distribution infrastructure in order to accommodate net metering?
At this point in time, I'm not aware of either company doing it for a net metering customer.
Okay, and are you aware that either company has had to upgrade transformers in order to serve a net metering customer on a particular circuit?
I am not aware of that at this time.
Okay, that's all I had. Thank you so much. And Mr. Chairman, thank you very much.
Okay, thank you. Mr. Parsons, any questions?
No questions, Your Honor. Thank you.
Okay. All right, having given Mr. Fitzgerald an opportunity, does anyone else have any questions to ask Mr. Wolf related solely to interconnections? None? Well, is there any reason why Mr. Wolf cannot be excused?
No, Your Honor.
Okay. Thank you, Mr. Wolf. Appreciate your testimony. You may step down and you're excused.
Thank you.
Mr. Parsons, do you have another witness?
We do, Your Honor. Eileen Saunders.
Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Parsons, you may ask.
Good afternoon, Ms. Saunders. Would you please state your full name for the record?
Eileen L. Saunders,
Who are you employed by?
Louisville Gas and Electric and Kentucky Utilities LLC.
What is your business address?
220 West Main Street, Louisville, Kentucky, 40202.
What is your title with the company?
Vice President, Customer Services.
Ms. Saunders, did you cause to be filed in these proceedings direct testimony and exhibits?
Yes, I did.
Do you also cause to be filed rebuttal testimony and exhibits?
Yes,
Do you adopt the contents of that direct and rebuttal testimony as your direct testimony here today?
I do.
The witness is available for cross-examination.
Mr. Nguyen?
Yes, thank you, Your Honor. Good afternoon, Ms. Saunders. Can you hear me okay?
Yes, I can.
Okay, good. Could you please refer to the company's response to commission staff's 5th data request and item 8?
Yes, I see it in front of me.
Okay. Would you agree that for KU, disconnections and reconnections are split fairly evenly between contractors at 53% and employees, internal labor at 43%? I'm sorry, 47%?
Yes.
Okay.
Yes, I didn't know where you were at first, but yes, I can see that. And yes, they're split as represented by my answer to question number 8.
Yes. And then with respect for LG&E, would you agree that for LG&E, disconnections and reconnections are primarily performed by contractors at a rate about 90%?
Yes, that is correct for 2021.
Okay. Do contracts perform any other tasks other than disconnections and reconnections?
And, may I ask, are you asking for both companies?
Yes. Yes, ma'am.
There are some additional customer service related tasks, but as you can see, primarily our contract workforce here in LG&E concentrate primarily on disconnects and reconnections.
Okay. So what would those other tasks be, other than, in addition to the disconnects and reconnects?
There are additional tasks such as support of our meter asset shop from time to time. There may be move in, move out that in some areas are performed. So that I would say those are the primary type additional activities.
Okay, so just those two kind of broad categories?
I think they are the most representative.
Okay. Can you refer now to, staying with Commission staff's fifth request for information, KU's response would be item 10, and LG&E's response would be item 9.
I am looking at item 10.
Okay. You can give me 1 second.
Sure.
So do you see where you state during moratorium on disconnections, some contractors that perform disconnections perform duties within their meter reading department?
Yes, I see that.
Okay. Were any contractors let go during the moratorium?
Not at LG&E or KU's direction. And what I mean by that, I'm not certain if there were any people who were let go for other reasons as managed by their contractor, but not as directed by us as a result of the moratorium.
Okay, okay. I'm going to refer you to the company's response to the joint intervener's second request for information at item 2C.
Yes, I am. I see the question, and Mr. Lovekamp is scrolling down to the answer.
Okay.
Okay, I'm there.
Okay. And scroll all the way to the table that's on page 5 of 6. Are you there?
Yes.
Okay. This table is regarding the impact on cash working capital if customers delay making payment. Is that correct?
Yes, that's what I'm looking at. I believe, though, that was, is that correct, that was Mr. Seeley?
Oh, is this Mr. Seeley's response?
We both have our names on it.
Okay.
Rick, can you scroll to the top, please? Just let me make sure. Yes, Mr. Conroy and Mr. Seeley are both on this, and I believe that is something that Mr. Seeley can speak to more clearly than I can.
Okay. Okay. So you don't know if the amounts in this table represents a worst-case scenario or not?
I did not assist him in putting this together. My team provided some of the information, but I did not study this table
Okay.
closely.
So Mr. Seeley would be the responsible witness for this?
Yes.
Okay. I hate to switch back, but can you go back to the commission staff, KU's response to Commission staff's 5th request? Item 8 again.
Did you say, sir, item 10?
Item 8.
Item 8. Okay.
Okay. Do you see where you state that residential disconnects are still suspended as of the date of the filing of the response on April 1, 2021?
Yes.
Okay. Can you confirm that the companies have not begun residential disconnects since the moratorium on disconnects ended?
We have not begun, but we do have a plan in place to begin resuming in the June timeframe. But at the time this was filed, that is correct.
Okay. And you mentioned that the companies do have a plan to begin disconnecting residential customers in the June timeframe?
Yes.
Okay. But there isn't...
I'd like to... Sorry?
There isn't a particular time frame within the month of June that's been identified by the companies when the resumption of disconnections would begin?
We've targeted June 15th.
June 15th? Okay.
Yes.
Can you provide, and this may be as a post-hearing data request, but can you provide an estimate of the number of residential customers the companies are forecasting will be disconnected once disconnection begins?
Yes, we can provide that. I would caution, and then we will put that on there, that our customers are making payments as we speak when we provide that information. So it may vary to some degree, but
Sure.
we will provide that information.
Okay. Can you refer to either KU or LG&E's response to Commission staff's 3rd request for information, item 9, regarding disconnects and reconnects?
Yes, I see it.
Okay. You state that to determine the disconnect, reconnect charge, all costs for service orders, including overtime, are averaged to calculate the average cost per service order. Is that correct?
Show me where he's reading. Thank you. Yes, that's my understanding. Mr. Seeley can talk to you more about the calculations, but that appears to be correct to me.
Okay. So calculations would be under Mr. Seeley's realm?
Yes.
Okay. I'll just defer that to Mr. Seeley then. Those are all the questions I have, Chairman.
Vice Chairman Chandler, questions?
Yeah, thank you, Chairman. Good afternoon, Honors. How are you doing?
I'm fine, thank you.
Are you aware of the late fee provision of Tariff RS?
Yes.
Okay, so, and I'll speak generally that Tariff RS has a late fee of something like 3%, and that the tariff provides that it will be waived if there's a pledge of assistance, right? And something like it'll be waived, and then that customer won't be charged a late fee for the next 11 months, I think is one of the provisions. There's also an opportunity to waive it if that customer has not been late in the last 12 billing periods, right?
Yes.
but it's explicitly upon request. Is that right?
That's correct.
So, and I mean this genuinely, nobody looks at the tariffs as much as you or I do, right? Nobody in the general public is necessarily looking at utility tariffs. I can tell you from experience that most people think the tariffs are some sort of tax when you talk to them about utility tariffs. So has the company, or have you given consideration to striking the upon request portion of that tariff and waiving that late fee for customers who have not been late in the past 12 billing periods?
I think you're right that there are customers who don't look at the tariff and who don't know exactly what it means. So they don't call us or contact us usually asking about the tariff. What they will do, though, as a good payer, will often call in or go into their local business office and say, you know, I struggled this month or I had an issue this month. Is there anything that we can do? And that gives our team an opportunity to service them immediately based on that request. We know that our customers like choice, and for those good payers would prefer to give them the choice as to when they would like to ask for that waiver, because once they ask for that waiver, they can't ask it again. So we feel like it is an overall better customer experience, give that customer the chance to decide when to call in and ask for help, and then we can be responsive.
Is there another venue then to let customers know that they have that opportunity?
Did you say, is there another venue?
Right.
Certainly if they go onto our website and looked up waivers or looked up late payment charges, there may be information there. I would have to look at that again myself. But primarily it is basically driven on the customer asking if there's anything we could do to help them.
Do you all, if you all aren't interested necessarily or proposing to strike the upon request in the tariff, would the company have an objection to including that information on bills, either monthly or quarterly or even annually?
You know, we have not really discussed that. I would be happy to take that back and think about that, but we have not as a team discussed that, or as a company discussed that as an option. At least I have not discussed that.
Okay. So are you aware of rate OSL?
Did you say rate OSL?
Yes, ma'am.
I can't quote all the rates myself, but yes, I'm aware.
That's the sports field rate that's limited to 20 participants per utility. Is that your understanding?
Yes.
Okay. So do you know of any proactive measures that the companies have taken to inform folks of those rates, including when schools or communities are building sports fields, letting them know that if they meter them individually, that they'll have an opportunity to participate in this rate, but if they meter it with, let's say, a concession stand, that they won't necessarily?
I am not personally aware of those discussions, but it is possible that there are individuals who've had those discussions, but I'm not aware.
Okay. And I think it goes back to my question around the late fee, right? I assume that, when a school is building their new baseball field, right, or when a community is building a sports complex, they may not necessarily be looking through the utilities tariffs as to how they ought to meter their facilities before they even start taking service, right? And I just sort of ask out loud, how would they be aware of the opportunity to participate in OSL if nobody from the company has, if they've not learned about it, from somebody approaching them about it?
Well, I'd like to be clear in saying that I'm not aware, but it is quite possible that those discussions have taken place. I would like to say it is our general posture as a company, that we try to be as open with our customers as possible. We want to be as transparent with them as possible and make sure they know all of the services that we have available to them, whether it's on our website, whether it's in one-on-one conversations, whether it's in talking to them about various different programs when they contact us, or whether it's with working with low-income agencies. So our general posture
is that we definitely want to let people know what is available. I'm just saying that I'm not 100% sure sitting here today what conversations took place around that subject.
Okay. And on the same front, I was asking Mr. Beller questions about EV infrastructure and working with third-party EV charging facility owners. Charging facilities that are open to the public but are not owned by the companies. Are you aware of any sort of proactive customer service or economic development outreach that the companies have done with folks in that line of business, trying to work with them to identify places on the company's system to where EV charging would be easily facilitated?
Yes, I heard that question you asked, Mr. Beller, and I've thought about a couple of different ways to answer, so bear with me while I go through a few things. One, when we are working with our major accounts customers, for example, we work with them to try to understand what their energy needs are. If at that time they also begin to mention their interest in electric vehicles or charging stations or things like that, our team are equipped to provide them with information or to talk to them about that. We also have general information in our marketplace that can help inform individuals about our electric vehicle charging needs. And if we are working with a customer and they come to us, we do have information that we can share with them to help make that transition. But I can say that we don't have total responsibility of like each person who decides to put in an electric vehicle charging station. They may not reach out to us. So in those cases, no. But what I can say is that as we are continuing to work through programs like increasing electric vehicle charging stations, we are also looking at expanding that corridor and trying to, as part of that process, we absolutely look at infrastructure and look at placement, et cetera. So when we're doing it, yes, for ourselves, we also make those considerations. And when we're working with our customers who have expressed interest, we make sure that they are aware as well. And we try to be as transparent as possible through commercials and other media and other channels that we are placed that can be of assistance. But that program is still growing. It's still something that we are continue to develop. But as we can, we try to find different ways that we can inform customers. And we're always willing to work with any of our customers who have interest or questions in that area.
So on this front, if the companies have an intention on installing and owning their own EV chargers, right? Doesn't that effectively put them in a position to where you all are competitors with these third parties? How will you all balance that?
Well, I would say that, Mr. Beller mentioned in his testimony that we're working with Metro on an application for them to support them in getting electric charging stations. So we're, open to working with others. I can't specifically, I can't say that I think that today we're, a competitor, but it would be something we would have to consider as we're moving forward.
Okay. And then finally, I think it may have been I think you were the respondent, but in response to the staff's third request for information, number 28, there were a number of slideshows provided discussing the relationship between income and electric usage. Do you know what I'm talking about generally?
Did you say 28?
I think it was staff 3-28 in the LG&E case.
Okay. We're not seeing a stat, a 3-28, but he's looking.
Do you know what slides I'm talking about, though, that discuss that you all done internal studies on the relationship between income and usage?
No, not off the bat. We are looking, though. The question I see for 28 is related to responding witnesses Robert Conroy and David Sinclair.
Okay, all right, so so you're not the respondent, I apologize. But
That's okay.
Attached to that are two studies. The first one is called Exploratory Analysis, Income and Consumption. And if you just go to the second page of it, this talks about findings of the exploratory analysis. Do you see it? Attachment 1 to question CSC 3 dash.
Yes, I see it.
Okay. And then just the findings at the top, just talk about customer level income data gathered by surveys and merged with billing data showed consumption increases as income increases. Low income customers spend a greater proportion of household income on electricity bills than other customers. And variation in monthly bills is similar across income levels. You see those three takeaways?
I do.
So I found these studies, just frankly fascinating. I was just curious if, and now I look at my question, you weren't the respondent, I apologize. Now I look at the question, is that Mr. Sinclair has looked at sort of the, I'll say from his side of the business, is that fair way to say it? Looked at it from his side of the business, but it certainly implicates, your role as well, right? Your service side. So I was just curious if the companies, or even your perspective or from Mr. Sinclair's perspective, if the companies would commit, between now and their next rate case to continue to study this and gather more data.
Vice Chair, I truly would like to be responsive to you, but I didn't sponsor this, and I'm not as familiar with the data behind the study to be able to answer you, but I'm certain that Mr. Sinclair would be able to give you more specifics.
So I guess what I'll ask, and I don't think you're Mr. Sinclair's boss, so I'll ask it this way: are you the impression that Mr. Sinclair is in a position to commit to something like that, to looking at the customer, the correlation between customer usage and income? Is that something that necessarily falls within his job, or is that more in your wheelhouse?
I'm not sure what he would or would not be committing to. I can't say that if there was something from my standpoint that Mr. Sinclair would need in order to answer this question, he would reach out to me. But I was not engaged in this study at all.
And so, I guess my only request then is for you to go back and look at this after this, because it specifically talks about the ability and the usefulness, or gets to bill assistance, especially with customers with lower income. And it directly implicates that. So I would sort of ask that very nicely. So that's all the questions.
Yes, sir.
Dr. Matthews, questions?
I don't have any, thank you.
Okay. Mr. Parsons, any redirect?
No, Your Honor. Thank you.
Okay, thank you. May Ms. Saunders be excused?
Yes, Your Honor.
Thank you, Ms. Saunders. You may step down and you're excused.
Thank you all.
Hey, Mr. Parsons, you have another witness?
We do. Mr. Arbo is here. Do you give us just 1 minute, Your Honor?
Mr. Arbrough, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Riggs, you may ask.
Thank you, Mr. Chairman. Good afternoon, Mr. Arbo.
Good afternoon.
Mr. Arbo, did you call us to be prepared in this case? Direct testimony of 24 pages and 6 exhibits.
I did, yes.
Did you also call us to be prepared in this case of testimony of 50?
I did.
Did you also answer a number of data requests?
Yes, I did.
these questions contained in your testimonies and data responses, responses and testimony?
They would, yes.
You now confirm your testimony, the responses as your testimony today?
I do.
Thank you. Mr. Chairman, I'd like to ask Vice Chairman's examination or the issue.
Mr. Riggs, we can't hear you. We get about one word out of maybe 7 or 8. I don't know what the problem is.
I apologize, Mr. Chairman.
No,
Can you hear me now?
No apology necessary. No, I can hear you now.
Thank you, sir. So, Mr. Chairman, I'd like to ask Mr. Arbo just a couple of quick questions to clarify the issue of OVEC that the Vice Chairman asked Mr. Beller.
Certainly.
Thank you, Your Honor. Mr. Arbo, were you listening to the examination of Mr. Beller by the Vice Chairman earlier this morning concerning the issue of OVEC?
Yes, I was.
And do you have a comment on as to whether or not the company has ever voted on, as members of the Board of Directors of OVEC, on proposals recommended by the OVEC management?
Well, we vote on each of the recommendations. Is that your question, whether we
start with that? Yes, please.
Okay. Yes, we do vote on each of the recommendations.
And are there any occasions where you have not voted affirmatively in favor of management's recommendations?
Yes, there are.
And what were those two, please?
We have 2 cases where we have abstained, and this is in recent history. Again, I don't have history going back all to long periods. We abstained in the vote of OVEC joining PJM. We also abstained in the vote on the recommendation to spend the capital for the ELG and CCR expenditures.
Could you briefly state why you abstained? Why the directors representing Louisville Gas and Kentucky Utilities abstained in their votes?
And I can explain the latter one. I was not on the board at the time of the PJM vote came up. But with respect to the analysis that was provided by OVEC, I think Mr. Beller indicated that it wasn't as detailed, or wasn't the type of analysis that we would normally have expected if it was one of our assets. And really, that was the reason why we abstained. The information they provided, we felt was accurate, and it showed rationale for the expenditures, but it was not as robust and as detailed as the analysis that we would do on our own. We did request that they provide additional information, and that was not provided.
Right. Mr. Arbo, I believe the Vice Chairman asked Mr. Beller some questions about an analysis, how an analysis would be done about the closing of the OVEC plant. Do you recall those questions?
Yes.
If the OVEC plant were to be retired before the end of the date of the contract, will the owners still have to pay the debt obligations?
There would be debt obligations due. There would also be what are called make-whole payments due, and that effectively is a prepayment that would be due if the interest rates in the current environment are lower than the interest rates that were in effect at the time the bonds were put in place. There would also be costs associated with the closure of the plant. So anything required to dismantle and demolish the plant, and any kind of decommissioning, any restoration required, that would need to be paid, as well as any outstanding pension obligations that would be due to the OVEC employees.
Thank you, Mr. Arbo. Mr. Chairman, I have no further questions at this time.
Thank you. Mr. Nguyen,
Mr. Arbo is
questions?
available for any examination.
Yes, thank you, Chairman. Good afternoon, Mr. Arbo. Can you hear me okay?
Yes, I can. Good afternoon.
Just one question, and it's going to be as a post-hearing data request. Could you refer to KU and LG&E's response to Commission staff's fifth request? Item 2, and it's the attachment regarding the budgeted legal expenses.
Just taking a moment to open. Okay, I see that now.
Okay. As a poster and data request, could you provide a schedule showing the estimated costs per each item listed? So there's categories of budgeted legal fees. Do you see that? And then there's a breakout within each of those categories. So could you provide an itemized list showing the cost per those items listed within those categories?
I think there's some confidential information there, which I think we would need to be file those in a confidential way. And just so I'm clear, you want those on all the items or just particular categories?
All the items for now.
Okay.
Your Honor, we want to cooperate with the Commission fully in its examination of our application. In this case, this request may invoke privilege concerns, and I respectfully reserve the right to assert the privilege if the disclosure of this information is going to raise a waiver of the privilege. That's all I wanted to know.
Sure, you always have a right to raise privilege.
That's
I
all.
suppose if you raise,
Suggestion that I had.
okay, Mr. Riggs, if you raise privilege, I assume you'll raise that and then file something in support of it. Is that correct? Rather than just raise privilege, you'll raise privilege and cite some authority or get into some details so we'll know.
Yes, sir.
Okay,
Yes, sir. I'll provide some support, not merely the assertion of the privilege. Yes, sir.
Thank you.
That's all the question, Your Honor. Thank you.
Vice Chairman Chandler, questions?
Yeah, just a few. Good afternoon, Mr. Arbuckle.
Good afternoon.
Are you in charge of the company's filing of its annual report to the Public Service Commission, or Mr. Conroy?
I am not. I think there are many people in the organization prepare those, but I believe Mr. Conroy is in charge of filing those.
Okay, thank you. And then, okay, that's all I have. Thank you, Chairman. Thank you, Mr. Arbuckle.
Dr. Matthews, questions?
I don't have any.
Thank you. Mr. Riggs, any redirect?
No, Your Honor.
Okay. May,
No, Your Honor, I do.
Oh, I'm sorry.
Thank you.
Go ahead.
No, sir, I have no redirect. I'm muting my microphone to try to facilitate the noise issue we had earlier, but I have no redirect. Thank you, Your Honor.
Is there any reason why this witness may not be excused?
No, Your Honor.
Okay, thank you, Mr. Harborough. You may step down and you're excused.
Thank you.
Okay. You may call your next witness, Mr. Riggs.
Thank you, Mr. Chairman. We'll call Mr. Garrett.
Okay, Mr. Garrett, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Riggs?
Thank you, Your Honor. Good afternoon, Mr. Garrett.
Good afternoon.
Would you please state your full name?
Christopher M. Garrett.
Mr. Garrett, would you please state your title, your business title?
It is controller.
Mr. Garrett, would you please state your business address?
220 West Main Street, Louisville, Kentucky.
Mr. Garrett, did you cause to be prepared and filed in this case direct written testimony?
Yes, it is.
Did you also cause to be prepared and filed in these cases rebuttal testimony of 38 pages and 12 exhibits?
Yes, it is.
Did you also answer numerous data responses in this case?
Yes, I did.
Mr. Garrett, do you adopt and affirm your direct testimony, your rebuttal testimony, and your data responses as your testimony this afternoon before this commission?
I do.
Thank you, Your Honor. Mr. Garrett is now available.
Okay, Mr. Nguyen, questions?
Yes, Your Honor, just one question. Good afternoon, Mr. Garrett.
Good afternoon.
Could I ask you to refer to your rebuttal exhibit CMG 7? And also to the company's responses to Kroger's second request for information, item number 7.
Still pulling it up. I believe that's Kroger 7.
Yes.
I think that's 2-7, I think, too.
Do you see that?
Yes.
Correct.
Okay.
It's 2-7.
2-7.
Kroger 2-7.
Okay. It's possible that's Kent's.
May I ask staff counsel, is Mr. Garrett the responding witness on the Kroger
He is
2-7
not.
data response?
No, he's not. It's Mr. Blake.
Okay, thank you. That will help us locate it.
And it's the attachment. It's the attachments to those, both of those responses.
Yes, we've got the exhibit up now.
Okay.
Exhibit 7.
So for your rebuttal exhibit, CMG 7, for the KU exhibit, CMG 7, if you look on column F, line 28, it looks like it shows the total revenue requirement adjustment for the depreciation at 33.017 million. Is that correct?
That is correct.
Okay, and then for LG&E, it's located on column 7, row 29, and it shows total revenue requirement adjustment of 36.531 million, correct?
That is correct.
Okay, and those are the two figures that were used in the stipulation as well, correct?
Correct.
Okay, so if you go to for Kroger, the attachment to 2-7, it shows on the last column of this schedule, the 13-month, the total, it shows on the line that says total revenue requirement adjustment, under the total column on the far right, it shows 39.994 million for KU. Is that correct?
That is correct.
Okay. I was just wanted to ask you to reconcile these two. Why is for your rebuttal exhibit it shows 33.017 million, but for the response here, in response to Kroger's request, it shows almost $40 million. And I understand that Mr. Blake testified earlier this morning, and he said that it may have included the excess ADIT, but there may be other components that might have been included as well. So I just kind of wanted to get a little bit more information with respect to that difference.
Sure, I'll just mention a couple of things that I believe is causing the difference. Again, this is not my response, but I believe I understand the differences. And with regard to the rebuttal exhibit that I filed in testimony, my rebuttal testimony, that includes only the impact for case of KU Brown Unit 3, keeping those rates current, and then for LG&E, it only includes the impact for keeping the rates current for Mill Creek 1 and 2. There were other depreciation changes, and my understanding from this attachment is that this is all inclusive, so basically keeping rates current for everything.
Okay.
With regards to the Kroger exhibit.
Okay, so that's in addition to not only Mill Creek 1 and 2, well, for this one, for KU, for Brown 3.
For KU Brown 3 and for LG&E Mill Creek 1 and 2.
Okay. Those are all the questions I have.
And also, I would say that rebuttal exhibit CMG 7 also includes the impact of the private letter ruling. So the difference in plant as well as the difference in excess ADIT should be the differences there that cause that variance.
Okay, understood. Thank you. Those are all the questions I have, Your Honor.
You're welcome.
Vice Chairman Chandler?
Yeah, thanks, Chairman. Good evening yet now. Good afternoon, Mr. Garrett.
Good afternoon.
So I just want to make sure to follow up on Mr. Nguyen's questions there. And to follow up on Mr. Blake this morning. It's the company's testimony that the adjustment made in the stipulation is effectively to hold the current depreciation rates for Mill Creek 1, 2, and Brown 3 constant at the rate that it was before the companies filed these rate cases. Is that correct?
That is correct. Continue to use the depreciation rates in effect prior to the rate case.
Okay. So then going to, well, so then let me ask, what then is the impact of the private letter ruling if that's the case? Were you all already applying that cost of removal treatment in that manner for ADIT purposes, that plant, before the private letter ruling, or does it have no effect?
Well, let me speak to the private letter ruling, and just with regards to the timing there. We really came to know of the issue regarding the private letter ruling after the filing was made. So while the private letter ruling came out in August, we did not really start to have discussions until after the case was filed, really where we became aware of this issue. And that's when we had the conversation with our external auditor to really figure out how we should address this private letter ruling, as there was starting to be more discussion in the industry around this issue. So there is an exhibit that is filed with regards to, a data response. It's AG 2-8 that shows the impact of the cost of removal issue in the case on its own.
So I guess my question is, were you all treating the cost of removal as unprotected before the PLR, or were you already treating it as protected?
We were treating all plant-related ADIT as protected.
Is that as a result of the 2018, the settlement or the case in the 2018 Tax Cuts and Jobs Act matter?
That is correct. We agreed in that proceeding that we would continue to treat plant-related items as protected.
Okay. And so and that's not necessarily the distinction under 160. It's timing differences between book and tax depreciation in 168 that is the protected definition, right? Or that the protected designation flows from.
It really refers to, with regards to 168, accelerated depreciation only.
Okay. All right. So the whether or not it's plant related is not necessarily the determining factor. Is what the big picture takeaway from the private letter ruling is.
That is correct. It basically determined that cost of removal is not protected.
I just have a couple of questions for you. Happy to ask them in post-hearing data requests. I just want to make sure these are the kind of things that are tough to find to designate necessarily in the rate cases. So account 930 for all three of the companies, is that an account for which costs in the test year are recovered from customers or are below the line?
That is an above the line account.
Okay.
But it's recovered from customers.
How about 909?
I'm trying to remember what 909 is. That is a advertising account. Rich,
That's right.
equal filing requirement, Schedule F, Schedule, I want to say F.
Mr. Garrett, these were specific. These couple of accounts, I think, were specifically requested in the commission's initial DR as well.
I'm sorry, he's still looking up. Let me go ahead. You can control it. Yeah, okay.
I have the title of 909 being informational and instructional expenses.
That is informational and instructional advertising is included in rates. So it is above the line and included in rates.
The 930.
I was curious because 913 and 931, a portion of those advertising costs are not recoverable.
913 or 931?
913 and 930.1.
Are not recoverable.
That's right. They relate to sales and promotional advertising.
That's the general advertising expense, right? Is 930.1?
Correct.
Okay. All right. And then finally, do you know about account 426?
That is a below the line account, and that is not included in rates.
Okay, perfect. And then my last question for you, Mr. Garrett, is do you know if the company included as an offset to the revenue requirement or as a credit rebates it receives from the use of company credit cards?
Yes, I believe there was a data request on that, which we provided a response to that indicated that the level that was included in the forecasted test year with regard to rebates on credit cards.
Okay. That is a very big record. I did not find it in my first or second review. So we will look for that, and if we don't have it, we'll just request it again in a post-hearing data request.
It's an AG KIUC question. Rick, I don't know if you could do a quick search for them.
I think there were about
But if you type in rebate, it should find it. No, it's just.
I see here. It's AGK 1-32. The amount of the rebate for LG&E was $243,000, and the test period is $237,000.
Yes, I've got KU's stuff here, and it shows the amount of the rebate forecast in the base period for KU was 211, and then the test period was 193,600.
Okay, and so those were used to reduce the revenue requirement in this case as a credit to it?
That is correct.
Okay, all right, those are all the questions I have, Chairman. Thank you, Mr. Garrett.
Dr.
welcome.
Matthews,
Thank you.
questions?
I don't have any questions.
Mr. Riggs, any redirect?
No, Your Honor, I have no redirect of Mr. Garrett.
May Mr. Garrett be excused?
Yes, Your Honor.
Mr. Garrett, thank you for your testimony. You may step down and you're excused.
Thank you.
Mr. Riggs, you think we can get one more witness on here this afternoon?
Yes. Yes, sir. Mr. Spanos, John Spanos is available. He should be attending the hearing.
Okay.
Mr. Spanos, are you there?
I am. I don't seem to be able to. I'm just trying to get my camera working.
Okay.
Can you see me now?
Mr. Spanos.
Yes,
please,
Mr. Spanos.
please raise your right hand. You solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, Mr. Riggs.
Thank you. Mr. Spanos, before I begin, you have a light that is to your left. And if you could, thank you, adjust that, that would make it easier to see you. Thank you. Mr. Spanos, would you please state your full name?
John J. Spanos.
And by whom are you employed, Mr. Spanos?
I'm employed by Gannon Fleming Valuation and Rate Consultants, LLC.
What is your business address, please, Mr. Spanos?
207 Senate Avenue, Camp Hill, Pennsylvania, 17011.
Mr. Spanos, did you cause to be prepared and filed in these cases direct testimony consisting of 18 pages and 2 exhibits?
There is direct testimony for both LG&E and KU, and 2 exhibits, one for each company, yes.
Okay. And did you also prepare and file in both cases rebuttal testimony of 22 pages?
Yes, my rebuttal testimony was combined for the 2 cases.
Okay. Mr. Spanos, did you also answer numerous data requests in these cases?
Yes, I did.
Mr. Spanos, do you adopt and affirm your direct testimony, your rebuttal testimony, and the answers that you provided in response to data requests as your testimony in these cases this afternoon?
Yes, I do.
Mr. Spanos is now available to answer any questions, Your Honor.
Thank you. Mr. Nguyen, questions?
No questions, Your Honor. Thank you.
Vice Chairman Chandler, questions?
Yeah, thank you, Chairman. A single question. Good afternoon, Mr. Spanos.
Good afternoon.
In response to the DOD FEA's discovery, the company provided communications regarding the depreciation studies, including emails from you back and forth as a company. You know what communications I'm referring to generally?
Generally, I don't know that I have every single one of them in front of me right now, but yes, I'm familiar.
Definitely. The very first one was from, I think, 2018 or 2019. It was a proposed schedule for you to conduct the depreciation study or a depreciation study for the companies, where I think the final product was expected to be done, the final depreciation study on April the 30th. Does that sound about right?
Of 2020?
Of 2020, excuse me, yes.
Yes, that was the initial plan.
Okay, so other than a worldwide pandemic, what happened to the plan? And I ask from this perspective, my follow-up question will be, when did the company convey to you their new retirement dates for steam plant?
I don't remember the exact dates as to when those, the dates that we were discussing as part of the plan. This is a combination of the company's plan and then my comfort with those as to whether they're reasonable estimates based on the information I learned in conducting not only this depreciation study, but prior depreciation studies. I know that we extended because of the pandemic time period, we extended the time to file beyond, obviously, April. So that was why the schedule changed. And during that time period was when we updated the preliminary estimates for retirement dates that I then would communicate with the company my comfort level as to whether they seem to be appropriate.
So Mr. Beller, his data requests and responses indicate that retirement, the new retirement scenarios that I think Form 2 were more definitive around September or October of 2020, right? Between those 2 months. And this case was filed November the 25th. And notice a month before that, right? So I'm trying to, when you get a retirement date that changes, a steam plant retirement that reduces it, let's say it's 6 years or 8 years or whatever it may be, how easy is that? How easy is it for you to just receive that new information and then plug that in for the purposes of your recommendation and the depreciation study?
Well, the models are all set up and prepared for as we established our time period. Again, we started this process to coming up with estimates in the March, April time period. Then we added 3 months worth of data to get through June. And then from there, the models are in place. So to recalculate and do the necessary work, that can be done in a month's period of time because we have everything all set up, and it just requires us to have our phone conversations to understand any changes that have occurred. We had some ideas as probabilities as to where things may roll out, and then we get a final estimate. So that part can be done in a month's period of time. And that's basically the schedule that we worked off of as making those revisions to the expected models and the calculations during that time period once we received the updated plan by the company and then gave us a chance to review that.
Okay, and that's what I wanted to confirm there at the end. It was about a month turnaround between the time you saw Mr. Beller's proposed new retirement dates and we were able to have all of your information and studies done. Is that about a month?
That's correct, but again, I want to make sure it's clear that we had done all the work, the models were already set up, and then going in and making any revisions that occurred is the part that took a month. The study takes a lot longer, but we had already had all the models in place and the calculations and each schedule set up and ready, so anytime we made a change, then the month's time was just incorporating that change. It's not redoing the entire study at that point.
Okay. Thank you very much, Mr. Fence. I have no further questions, Chairman.
Dr. Matthews?
No, sir.
Mr. Riggs, any redirect?
Very briefly, Your Honor. Mr. Spanos, do you recall the data response the Vice Chairman referenced to you about the time period expressed by Mr. Beller on the preparation of the depreciation studies?
I remember the questions that were that we just had. I did not have the exact dates of all of those items in front of me, but I am familiar with the line of questions and the general topic, which is how I was responding.
That's fine. Thank you, Your Honor. I have no further questions.
May Mr. Spanos be excused?
Yes, Your Honor.
Thank you, Mr. Spanos. You may step down and you're excused.
Thank you. Have a good day.
Mr. Riggs, let me ask you this. We're at about 25 to 5, and what witness would you call next?
Mr. Sinclair?
Let me ask Mr. Nguyen, do you think we can't get through with Mr. Sinclair?
I think so. I don't have any questions for Mr. Sinclair.
You don't?
No, sir.
Well, let's see if we can get Mr. Sinclair on then, and then we'll recess for the day.
All right. We're going to have a change of counsel here and bring Mr. Sinclair forward to the witness chair. afternoon, Your Honor. Duncan Crosby for LG&KU.
Thank you, Mr. Crosby.
Who is it?
Mr. Crosby, would you repeat your full name for the court reporter, please? Wait, you'll have to
Sure.
speak slowly and into the microphone. We've had hearing problems here today.
I'll do my best. Is this better, Your Honor?
Yes, sir.
Perfect. My name is Duncan Crosby with Stoll Keenan Ogden on behalf of LG&E and KU.
All right, we got it. Thank you.
Thank
Mr. Sinclair, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Crosby, you may ask.
Thank you, Your Honor. Mr. Sinclair, will you state your full name for the record, please?
David Samuel Sinclair,
And by whom are you employed, Mr. Sinclair?
LG&E and KU Energy,
What is your job title, please?
Vice President Energy Supply and Analysis,
Okay, and what is your business address?
220 West Main Street, Louisville, Kentucky, 40202.
Did you cause to be filed in these proceedings direct testimony and responses to certain data requests?
Yes, I did.
And if I asked you the same questions that were asked of you in your testimony and your data requests, would your answers today be the same?
Yes.
Okay. Your Honor, the witness is available for questions.
Thank you. Mr. Nguyen, questions?
No questions, Your Honor.
Vice Chairman Chandler, questions?
Yeah. Thank you, Chairman. Get under the clock, the 5 o'clock. Good afternoon, Mr. Blair. I'll start with, I think it's your response to AGDR 1-163. You were asked about those 30 major accounts from the direct testimony that you referenced. You know what I'm talking about?
Yes.
Okay. The chart that was provided did not have 30 names on it. Is it that those individuals that were listed have more than one account, and that's what makes up the 30, or are there other major accounts that just weren't listed?
I don't know off the top of my head. I have not counted up the number on that exhibit.
Okay. It was, let's say it was like 15, maybe 15 to 20, maybe 16 companies. Are there 30 major accounts, or are there major accounts and some of them are multiples for the same company?
Well, there are 30 on a combined company basis, so I guess I'd have to see both responses. I'm not sure, Mr. Lovecamp, if you got NKU both.
I think that clarifies my question. I was looking at LG&E 1-163, the AGDR 163.
So, yeah, the responses were unique, obviously, for each company because each company has their own unique customers. So, without sitting here and counting them up off the top of my head, they look roughly about 15 or so each. And it looks like Mr. Lovecamp's doing the math real quick.
So that's the distinction then.
Okay. I think that's the biggest difference, yes.
Okay, great. Have the company curtailed CSR customers in the last 5 years?
Talking about physical curtailment or
That's right.
exercise the right to buy through, have them buy through?
Physical curtailment.
No, we have not. In fact, there was a data request on that point. I don't remember which one off the top of my head, but there was a data request on that.
Yeah, there was. And my question is, what has precipitated the not need to physically curtail those CSR customers for the past 5 years?
Well, as I'm sure you're aware, there's in the tariff, there are certain system conditions that have to exist before physical curtailment can be requested. I remember off the top of my head, I believe it's all or nearly all of our primary CTs or large frame CTs have to be committed or in the process of being committed, and which only happen in typically very high load conditions, and we simply have not had those kind of conditions occur in the last 5 years.
Right, but there have been a number of conditions in which the CSR customers have not been physically curtailed, but that they've been, I guess, put on notice and then use the buy-through, right?
Yes, in the tariff, there's a number of hours that we're allowed to request that. They obviously have the option to curtail, or they can buy through, and the price they pay then is based on a natural gas index and a certain heat rate. And so certainly, we want to make sure we're optimizing the tariff for the benefit of all customers. So if those situations occur relative to their energy rate, we will look to exercise those number of hours to make sure customers are getting the value from that tariff provision.
Yeah, does that get updated between each case, and does it pass a sort of cost-benefit analysis each case to determine if those rates are doing exactly what you were just talking about?
I'm not the rate person, so I'd have to punt that to the rate design folks.
That'd be fine. Do the CSRs have to pass some sort of total resource cost or cost-benefit analysis? For purposes of using them as an economic, sort of demand side resource?
In past cases, there's been a lot of testimony around that topic and as to what the CSR rate ought to be and the various provisions around it. And as you're probably, again, aware from this past settlements and stuff, that has been resolved. To my knowledge, in this case, there was no real questions around that issue.
Okay. If I wanted to know how much was paid in CSR credits, is that a Mr. Conover question?
I would think so, yes.
Okay. And is CSR fundamentally different than demand response, or is it just paid out? Is it similar and just paid out in sort of a fixed credit in lieu of some sort of variable credit or energy refund?
Right. The way our current direct load control program works, which I think what you mean by demand response, the way that program works now is we will only make a payment to those customers if, in fact, we call upon it. So it's a resource right now that if we never call upon it, it's costless in that regard. I will say it's very expensive if we ever did call on it. Second, so then where CSR, my understanding how that rate works is there's an amount that the CSR customer is assumed to be able to reduce their demand by, and that amount is credited to their bill every month.
Okay. There were quite a few questions in the case, in the discovery about curtailments under the FLS rate. Do you remember those?
I remember there were some data requests on that, yes.
Okay. And I think there was an indication of how many times I think there was a data request that indicated how many times those FLS customers, or the FLS customer was curtailed. I don't know if curtail is the right word, but that they were curtailed or interrupted, maybe is the best way, that they were interrupted during the year, and then what other system attributes existed during those interruptions. Is that accurate?
Yes.
Okay. So do you have, and I think you were the respondent, can you look at your response or the LG&E response to AG KIUC 1-185? I think you're the respondent. Mr. Love can correct me.
Yes.
Okay. And that's the exhibit that I was just talking about, right?
Yes.
Okay. So do you all have somewhere the causes of those unplanned outages that force or cause the company to call on FLS for an interruption?
I suspect we do. Basically, it's going to be most likely. And so I would think that we have the data that matches up to that.
And are those, well, let me ask, there's a number of those over, I think, only a 2 or 3 year period. The number of those, is that fairly normal, or is that something that should concern us, the number of unplanned outages that specifically led to the interruptions for FLS?
I don't have it, normal, not normal. I think, in operating a power system day to day, stuff happens. And, what you see here is, looking at this, you see, for example, the second line item, unit unplanned D rate. Well, by definition, almost all D rates are unplanned. So that can be a coal mill having some issues, et cetera. So, there's a variety of things that happen, which is why any grid carries, spinning reserve and fast start resources, et cetera, to deal with those upset conditions that naturally occur in operating a power system. So, I don't view this as really, abnormal, given that you're thinking about this from 8,760 hours in a year. You're talking about dozens of units. So it's really a relatively small number of events, I would argue, in the bigger scheme of things.
Okay. And do you all have to have spinning reserves before you issue a curtailment for FLS?
Well, every moment of the day, you have to carry a certain amount of your reserves in a spinning way. So that spinning reserves is there to deal with, ramping because of load volatility. It's there to deal with outage events on units. So there's a variety of reasons. So yes, we carry a certain amount of that, and that amount is driven by, the load in the day. So higher load conditions, you have to typically have more spinning reserve, lower load days, less. Because again, load is bouncing around every second of the day, so you have to have the ability to model or manage that load real time. So, in this situation, probably would have to look at the events, but somewhere, when that event occurred, it was probably at a time when we had, less than the, we had not enough excess reserves online at that time, and so it was the best thing to do was to hit the FLS button to stop the unit. And I would just point out that, again, the FLS button does two things. One, it can either ask the arc furnace to turn off, or it can stop. The key is we're trying to, while the system's sort of unstable momentarily, we're trying to get the wobbling to stop for a second. So we don't want a big further thing going on to start more conditions that we have to deal with.
So you're saying you hit the button to keep it from drawing that demand?
So, for example, you see that actually on that 2/7/2018 event, right? You see FLS load before curtailment was 0. So in that situation, the load was not online. So by hitting the button, we stopped it from coming online. So what that meant was then we didn't, until we got the problem fixed that we needed to deal with to reestablish the reserves that we wanted in real time, we didn't want that load coming back online, making our problem worse until we got the system restabilized. So you see several times throughout that chart, the load online at that time was 0. So we're just trying to stop anything else from happening until the situation is more stable.
That was actually my next question, while some of them are 0. So the last question, would you all be able to answer as to whether or not the fast start CTs were going before or after the curtailment, or before or after the unplanned outage?
Well, again, I think what you see here is we only have a certain number of our gas turbines that are in the fast start, which means they can be online and loaded in 10 minutes. So what you see in that column that says response, it said that we take the response to actually, use fast start CTs to deal with the upset condition in addition to hitting the FLS button. And so you see in some instances we did, in some instances we didn't. There's a probability, I guess, that the units are capable of that were already online. But if that's your question, we can probably figure out which units were online on those given hours or moments, rather.
Yeah, and I guess my question was twofold. One, I guess it's really the two sequences where the fast start CTs called before the unplanned outage. And second, does this indicate that the fast start CTs were called on before their curtailment, or that they were just called on during the same event?
Well, let's kind of walk through the nature of an event, and they all unfold a little bit differently. But you can certainly have an event where the operators get virtually no notice. Something occurs, and the unit trips offline very quickly, and so they have to respond in very quick notice. Other times you have more of a situation where they know a unit's having problems and they give you some notice, and so you might have time to actually say bring on a fast start CT if that was viewed as the best thing to do. So the operator has a certain set of parameters and tools in their toolbox to deal with the event. And so they're going to look at that event, the nature of the event, the rest of the system conditions, and decide what's the best tools to deal with the situation, keep us in compliance with the NERC standards on operating the system moment to moment.
The last question on this exhibit, do you all have the duration for which you all push the proverbial button for each one of these curtailments? Or did you all use the entire time permitted under FLS for each one?
You know, I don't know off the top of my head. It just has a start time. It doesn't say how long the event lasted. I'd have to check to see what we have data for that. I don't know off the top of my head.
We'll ask a post-hearing data request, and if the data doesn't exist, you all can let us know. But I'm just sitting here looking, you know, half a dozen or half a dozen plus curtailments in a month. I'm just curious how long each one of them was. So, the last question I have, Mr. Sinclair, is around. I think it's your response to LG&E response to DR 6-6 regarding the RFPs that were due by March 31st.
Yes.
You know what we're talking about? Are those responses in the company's possession?
Yes.
Okay. And are they able to be provided to the commission?
Yeah, we've indicated that, you know, a date or a point in time where we would. I guess I'd ask it's kind of legal question, it seems to me. I don't know if Duncan, you can respond on this. I'll put you on the spot.
Mr. Vice Chairman, as Mr. Sinclair has indicated, the companies do have in their possession the RFP responses. I think with respect to the response they provided to this request, there's a degree of concern about providing those into the record. Are you suggesting there be a way to provide those solely to the commission and to no other parties? Is that the request?
Staff asked for them, right? So the request was from staff. So that's the first thing, right? The commission staff has requested it. And there was no objection in the response. There was just the response from Mr. Sinclair. And so I take Mr. Sinclair's response at face value and appreciate it, but there was nothing, assertive that would indicate there's necessarily a concern with the other parties from council. So if that's a concern from council, then certainly I think the commission would consider the arguments from council. But I don't know that there's been any relevancy argument, and I can say that the commission is interested in it.
Yeah, Mr. Vice Chairman, you stated in the response that the concern this afternoon is the state of the data. The state of the data, as explained in the response, is not finalized. It is in what we say is a very raw or preliminary state. And we are concerned about providing that, any type of data in that state. We need the opportunity to finalize that and to analyze that, quite frankly. And so our proposal is, and our position is that we will certainly provide this data to the commission, at least in connection with the forthcoming IRP filing later this year. But the provision of this data at this time is not data that we consider to be, in its current state, completely reliable.
So, and I appreciate that. The request from the staff was for the responses, not for an analysis of the responses. The commission, the commission has asked for the question. There was no objection. So just start there. Additionally, requests like this have been made in previous IRPs, I think the 2018 or 2019 IRP. And the response was that responses to requests for information were not relevant in IRP proceedings. And it was updated and said that the response RFP was going to be used in a filing in January 2020, and that the responses would be provided then. but the responses were not provided in that docket until June of 2020, after that docket that was filed in January was even complete. So I would just like to say, this information is certainly relevant to the commission's inquiry in this case. And I don't understand why the responses themselves, rather than some analysis, is the relevant response.
Your Honor, there is a distinction between what I'm saying and the position your question takes. And that is, we are not declining to provide this information this afternoon because we understand the commission is asking for an analysis. We understand the commission is requesting this information, but the information as its current form, we do not believe has been finalized, and therefore in its current form today is not reliable. We need to complete our finalization of this information before it can be produced. And that is our concern with producing information, that it will be used, and it's information that today is not sufficiently final to be, and it's not comparable either. The data is in a wide range of forms. So we would like the opportunity to finalize the data and make sure it is on a comparable form, at minimum, before producing it.
But that objection or that position wasn't taken in response to the data request initially, is that correct?
Your Honor, I believe that it was. I did not use the word objection in the course of the data response, but I did explain the reasons why we were not providing that information with that response.
So when do you think that that the information can be properly assembled, organized, or analyzed?
Your Honor, I will be glad to ask, and I can provide that answer in the morning. I apologize. I have had my hands full, and I take responsibility for not being able to answer your question this evening. But I can provide you an answer in the morning.
Thank you, Mr. Riggs.
Thank you, Your Honor.
Those are all the questions I have, Chairman. Thank you, Mr. Sinclair.
Dr. Matthews, any questions?
I do not have any questions for Mr. Sinclair.
I get the sense that Mr. Fitzgerald has a question or two he'd like to ask, so Mr. Fitzgerald, go ahead.
I am standing 1 minute before the adjournment at 5 o'clock, and I have just a few questions. Mr. Sinclair, can you hear me okay?
Yes.
Okay, wonderful. Have you read the testimony of Mr. Conroy in this proceeding?
Some point in the past I have, yes.
Okay, he testified on page 27, lines 6 and 7 of his testimony, his direct testimony, that the commission, quote, the commission should not consider externalities in evaluating the cost effectiveness of net metering rates, end quote. Do you agree with that statement?
Yes, because we don't include externalities in evaluating any of our resource decisions.
Okay, more specifically, do you believe that the benefit that solar generation provides in avoiding greenhouse gas emissions is a positive value to LG&E and KU?
Well, under current regulation, since there is no regulation of CO2 emissions, there would be no value to customers to paying for that particular resource in that way.
Right. Well, what I asked is there value to the utility in investments that would avoid greenhouse gas emissions?
Well, I mean, the utility is just, it's an entity that's providing service to customers, and so we don't do things just for the sake of doing them. We do them because it's part of those providing service to customers. So given that, like I said before, there is no current in Kentucky or in the U.S. a CO2 emission cost, then simply paying more for a resource would not be part of the least cost analysis at this moment in time.
Okay, fine. Now, can you see what's on the screen there?
Oh, yes.
Okay, this is your testimony from case number 2014-00002. And specifically, it is page 27 of your testimony, which is page 68 of the filing that was made in this case. Do you recall this case that LG&E and KU filed?
Yes, I do.
Okay, and you recall that they was proposing a natural gas combined cycle plant as well as a 10 megawatt array of solar panels, the solar panels to be at the, do me a favor, and would you read me the question beginning on line 3 and the answer through line 10?
Okay, so it says, are the companies recommending any other resource addition for 2x1 natural gas combined cycle? Yes, the companies are also recommending construction of a 10 megawatt solar facility at the EW Brown station. While the Brown facility is not a lowest reasonable cost resource absent REC prices greater than $57 per REC, as can be seen in tables 35, 36, and 37 in the resource assessment. The companies are proposing to move forward with the project because 1 is a prudent hedge against both greenhouse gas regulations and natural gas price risk. 2, it will reduce the company's greenhouse gas emissions. And 3, it affords the companies the opportunity to gain operational experience with intermittent renewable resources. It's not materially add to revenue requirements over the next 30 years.
All right, thank you very much, Mr. Sinclair. I have no further questions. Mr. Chairman, you can dock me 2 minutes tomorrow for my making everybody a little late today.
No.
Thank you very much.
No, I'm bad, Mr. Fitzgerald, but I'm not quite that,
I wouldn't say you're bad at all, Mr. Chairman.
I'm not quite that strict. Mr. Crosby, any redirect?
No, Your Honor, thank you.
Okay. May this witness be excused?
Yes, Your Honor.
All right, thank you, Mr. Sinclair. You may step down and you're excused. So I guess we'll start tomorrow morning. We'll recess for the remainder of the day. Start tomorrow morning at 9 and see if maybe we can go till, if we get to where we just get to a couple of witnesses left, we'll quit at 5 tomorrow. If not, we'll go to 6. I know the Attorney General's 2 witnesses, I think request was made, they're going to testify on Wednesday morning or sometime on Wednesday. So anyway, we'll start tomorrow at 9 and see if we can, how far we can go, but we will go up to 6 o'clock if necessary. Is there anything else anyone would want to bring to the attention of the commission at this time? If not, we'll be in recess until 9 a.m. in the morning. Thank you.